ನಾವು ಹಾಕಿ ಬೆಂಗಳೂರು ರಾತ್ರಿ 11 ಗಂಟೆ ಲಿಂಕ್ ಕಡೆ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ. ಏನೋ ಸಮಾಚಾರ ನಮಸ್ಕಾರ ಸರ್. ಸರ್ ಏನು ಸರ್ ಮ್ಯಾಟ್ರಿಗಳೆಲ್ಲ ಇಷ್ಟ ಆಗಲ್ಲ, ರೀಚ್ ಆಗಲ್ಲ, ಏನಾಗಲ್ಲ, ಭಾರಿ ಕಷ್ಟ ರೀಚ್ ಆಗಲ್ಲ. ಅರ್ಜೆನ್ಸಿ ಇದೆ ಸರ್. ಹೆಂಗೆ ಸರ್ ರೀಚ್ ಆಗಲ್ಲ ಸರ್. ಒಂದು GM ಪೊಲೀಸ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ, ಮೊನ್ನೆ ಸೀರಿಯಲ್ ನಂಬರ್ 23 ಲಿಸ್ಟ್ ಅಂದರೆ ರೀಚ್ ಆಗಿದೆ. ತಿರುಗಿ ಇವಾಗ ಮೆಲ್ಲ ಹಾಕೋ ಪರಿಸ್ಥಿತಿಗಳು ಅರ್ಜೆನ್ಸಿ ಇದೆ ಸರ್. ಅಲ್ಲ ತುಂಬ ಲಾಂಗ್ ಡೇಟು ಮುಂದಿನ ತಿಂಗಳು ಕೊಟ್ಟಿದ್ದಾರೆ. ಮುಂದಿನ ತಿಂಗಳು ಅಲ್ಲ ಸರ್, ನಮ್ಗೆ ಬೇಕು, ನಮ್ಗೆ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಮ್ಯಾಟ್ರು. ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು ಸರ್. ಫೈನಲ್ ಇಯರಿಂಗ್ ಮ್ಯಾಟ್ರಸ್ ಅಲ್ಲ, ಫೈನಲ್ ಇಯರಿಂಗ್ ಮ್ಯಾಟ್ರಸ್. GM ಪೊಲೀಸ್ ಬೇರೆ, ಪೊಲೀಸರು ಸಿಕ್ಕಾಬಿಟ್ಟೆ ಜಾಸ್ತಿ ಹರಾಸ್ಮೆಂಟ್. ಪೊಲೀಸರು ಪ್ರಾಪರ್ಟಿ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ಯಾಕೆ ಸರ್ ಇಂಟರ್ವ್ಯೂ?
रीच वाली अब कोर्ट में बैठी हूँ, मेंशन करने के बाद बैठी कोर्ट। वो साहब तुमने भी तकलीफ है, हमने उससे ज़्यादा सिर दर्द हो गए हैं तो हाईकोर्ट में। मैं तो रीच होते नहीं, रीच हुए तो पोस्ट होते रीच होते नहीं। देखें खराब देखो
ನೋಡಿ ಸರ್, ಭಾರಿ ಕಷ್ಟ ಆಗ್ಬಿಡುತ್ತೆ ಸರ್. ಅಲ್ಲ, ಬೇಕು ಬ್ಯಾಂಡ್ ಬಿಚ್ಚಿಟ್ಬಿಟ್ಟು ಹೋಗೋದು ಆ ಲೆವೆಲ್ಗೆ ಹೋಗ್ಬಿಡ್ತಾರೆ ಸರ್. ನೋಡಿ ಕಷ್ಟ ಆಗ್ಬಿಡುತ್ತೆ ಸರ್. ಅರ್ಜೆನ್ಸಿ ಇರೋಂಥ ಮ್ಯಾಟ್ರಸ್ ಮಧ್ಯಾಹ್ನ ಹಾಕ್ಕೊಡ್ರಿ ಅಂದರೆ ಅದು ಮೋಸ.
ಮೊದಲು ಮಾಡ್ತಾ ಇದ್ರೆ ಏನು ಗೊತ್ತಾದ್ರೆ ಆರ್ಡರ್ಸ್ ಬಂದಿದೆ, ಎದಕ್ಕೆ ಬಂದಿದೆ ಅಷ್ಟಕ್ಕೆ ಈಗಲೂ ಬಂದಿದೆ, ಕ್ಲಿಯರ್ ಮಾಡಬೇಕು. ಇವರು ಈಗ ಬೀಚ್ನ ಪುಣ್ಯವನ್ನು ಕ್ಲಿಯರ್ ಮಾಡಿ ಡಿಸ್ಪೋಸ್ ಆರ್ಡರ್ಸ್ ಕ್ಲಿಯರ್ ಮಾಡಿ ಡಿಸ್ಪೋಸ್ ಯಾವುದು ಪ್ರಶ್ನೆ,
ಯಾವ್ದು ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಸರಿ ಇಲ್ಲ ಸರ್. ಮೆಮೊ ಹಾಕೋದು ಹೋಗುತ್ತೆ ಇಲ್ವಾ ಯಾರಿಗೂ?
ಸ್ಟೇಜಲ್ಲಿ ಕ್ಲಿಯರ್ ಮಾಡಿ ರೂಲ್ ಇಶ್ಯೂ ಮಾಡಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡೋದು ಫಸ್ಟ್ ಹೇಗೆ ಮೊದಲು ಹಂಗೆ ಮಾಡೋದು ಬಿಗಿನಿಂಗಲ್ಲಿ.
ಮೊದಲು ಚೆನ್ನಾಗಿತ್ತು ಸರ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್.
ಒಬ್ಬೊಬ್ಬರು ಒಂದೊಂದಾಗ ವರ್ಷ ಆಗಿದೆ.
ಬೇರೆ ಕಡೆ ಸಮಸ್ಯೆ ಇಲ್ಲ ಸರ್. ಡೆಲ್ಲಿ ಕೋರ್ಟೆಲ್ಲ ಕೆಲಸ ಮಾಡಿದ್ದೀನಿ. ಎಷ್ಟು ಬೇಕು ದಿನಕ್ಕೆ ಒಂದೊಂದು ಮೀಟ್ರ್ ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡ್ತಾರೆ.
ಹೌದಾ?
ಡೇಟ್ ಕೊಡ್ತಾರೆ, ಪರ್ಟಿಕ್ಯುಲರ್ ಡೇಟ್.
ನೋಡಿ ಇವ್ರದ್ದು ಅಷ್ಟೇ. ಹಲೋ ಸರ್, ನಮಸ್ಕಾರ. ನಾ ಎಲ್ಲೂ ಇಲ್ಲ ಸರ್, ಲಿಸ್ಟ್ ಇತ್ತು, ಲೀಚ್ ಆಗಿಲ್ಲ ಅವನ್ನೇ. ಅದೇ ಅದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ಹಾಕಿದ್ದಾರೆ. ವೀಕ್ಲಿ ಬಂದು ಸರ್ ರೀಚ್ ಆಗಲಿರೋ ಮತ್ತು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕ್ತಾರೆ ಅವರು ಡೇಟ್ ಕೊಟ್ಟು. ನೋಡೋಣ. ಅದೇ ಬಂದಿತ್ತು, ರೀಚ್ ಆಗಿಲ್ಲ. ಓಕೆ, ಹೇಳಿದ್ದೀನಿ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ ಹೇಳಿದ್ದೀನಿ. ಅದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ಹಾಕಿದ್ದಾರೆ. ನೋಡೋಣ. ಏನು ಮಾಡೋಕ್ಕಾಗಲ್ಲ ಸರ್. ಇಲ್ಲಿ ಮ್ಯಾಟ್ರಸ್ 100-150 ಹಾಕಿಸ್ಕೊಳ್ತಾರೆ, ಲಿಸ್ಟ್ ಮಾಡ್ತಾರೆ. ಅದು ಒಂದು 60-70 ಆಫೀಸಲ್ಲಿ ಟೈಮ್ ಮುಗಿದೋಗುತ್ತೆ. ಹಂಗಾಗಿ ನಮ್ಗೆ ರೀಚ್ ಆಗ್ತಾ ಇಲ್ಲ. ನೋಡೋಣ, ಅರೇಂಜ್ ಮಾಡ್ತೀನಿ. ಓಕೆ ಸರ್, ಮಾಡ್ಕೊಡಿ ಸರ್ ಅಂತಾರೆ. ಒದೀತಾರೆ ಫೀಸ್ ಕೇಳ್ಕೊಂಡ್ರೆ, ಫೀಸ್ ಕೇಳ್ಕೊಂಡ್ರೆ ಒದೀತಾರೆ.
ಮಾಡಿರೋ ಗಂಕಾರಿ ಹಂಗ ಹೇಳ್ಬಿಡ್ತಾರೆ ಸರ್. ಬೇಜಾರಾಗುತ್ತೆ ಗೊತ್ತಾ?
ಒಂದು 2 ಫೈಲ್ ಹಂಗೂ ವಾಪಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ, ಹೋಗಿ ಮಾಡಿಸ್ಕೊಟ್ರಪ್ಪ ಅಂತ. ಏನು ಮಾಡೋಕ್ಕಾಗಲ್ಲ, ಏನು ಮಾಡ್ತೀವಿ
ಸರ್. ಡಿಸ್ಪೋಸಲ್ ರೇಟ್ ಹಾಕೋಗ್ಬಿಟ್ರೆ ಓದ್ಕೊಂಡ್ಬಂದ್ಬಿಟ್ರೆ ಬೆಸ್ಟ್ ಸರ್. ಸಾಹೇಬ್ರು ಏನಿದೆ ಅದೇ ಹೇಳ್ರಿ ಅಷ್ಟೇ. ರಿಟ್ಗಳಲ್ಲಿ ಏನಿರುತ್ತೆ ಸರ್ ಕೇಳೋಂಥದ್ದು ಅಲ್ವಾ? ರಿಟ್ಗಳಲ್ಲಿ ಏನು ಹೇಳಿ? ಸಬ್ಸ್ಟೆಂಟಿವ್ ಕ್ವಶ್ಚನ್ ಆಫ್ ಲಾ ಇಲ್ಲ
ಅದೇ
ಮೊನ್ನೆಗೆ ಲಿಸ್ಟ್ ಹಾಕ್ಬೇಕಾಗಿತ್ತು.
ಜಡ್ಜ್ಮೆಂಟ್ ಮೇಲೆ ಮೆನ್ಷನ್ ಮಾಡ್ಕೊಡಿ. ಜಡ್ಜ್ಮೆಂಟ್ ಮೇಲೆ ಮೆನ್ಷನ್ ಮಾಡ್ಕೊಡಿ, ಇವ್ರ ಹತ್ರ ಕೊಡಬೇಡಿ.
ಇಲ್ಲ ಇಲ್ಲ, ಇವ್ರ ಹತ್ರ ಕೊಡಲ್ಲ.
ಮೇಡಮ್ ಸ್ಪಾದು 11
ಬರ್ತಿದೆ, ಇಲ್ಲಿ ಮಾತ್ರ ರಾಂಗ್ ಎಂಟ್ರಿ ಆಗಿದೆ.
ಅಲ್ಲಿ ರಾಂಗ್ ಬಂದಿದೆ.
ಹಲೋ, ನಮಸ್ಕಾರ.
ಫೈಲ್ ಮೇಲೆ 11
ಹೇಳಿ, ನಿಮ್ದು ಫೋನ್ ಇತ್ತು ಅದಕ್ಕೆ ಮಾಡಿದೆ. ಹಾ, ರೇ ಆ ಲಾಯರ್ಗೆ ಫೋನ್ ಕೊಡ್ರಿ, ನಾನು ಹೇಳ್ತೀನಿ. ಅದೇ ಬೇರೆ ಇದೇ ಬೇರೆ, ಅದಕ್ಕೆ ಇದಕ್ಕೇನು ಸಂಬಂಧ? ಮಾಡಿ ಮಾಡಿ ಆಯ್ತು, ಫೋನ್ ಮಾಡ್ತೀನಿ ಲಾಯರ್ಗೆ.
ಬೇರೆಯವರು ಎಷ್ಟು ಮಿಸ್ಲೀಡ್ ಮಾಡ್ತಾರೆ ಅಂತ, ಬೇರೆ ಆಸ್ ಇಫ್ ನಾವು ಕೆಲಸನ ಮಾಡ್ತಾ ಇಲ್ಲ ಅನ್ನೋ ರೀತಿಯಲ್ಲಿ
ತಾಯಿಯ ಹಾಕಿದ್ದೀರಾ, ಮಾಡಿ ಸಬ್ಮಿಷನ್ ಮಾಡಿ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ಗಳೆಲ್ಲ ಕೆಲ್ಸಗಳಾಗ್ತದೆ ನೋಡಿದ್ರೆ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ಗಳೆಲ್ಲ ರಿಲೀಫ್ಗಳು ಜಾಸ್ತಿ. ಏನು ಸರ್, ಶಾರ್ಟ್ ಡೇಟ್ಸ್ ಇರುತ್ತೆ, ಡೇಟ್ಗಳ ಪ್ರಕಾರ ಹೋಗಿ
ಲಾಂಗ್ ಡೇಟ್ ಕೊಟ್ಟರೆ ರೀಚ್
ಆಗಲ್ಲ.
ಯಾವುದು ಸೀರಿಯಲ್ ನಂಬರು? ಯಾವ ಮಧ್ಯಾಹ್ನ ಮೇಲೆ ಆಗಿದ್ದ, ಬೆಳಗ್ಗೆನೆ ಆಗಿದ್ದ? ಬೆಳಗ್ಗೆ ಆಗಿದ್ದೆಲ್ಲ ಅಪ್ಲೋಡ್ ಆಗಿರ್ಬೇಕಲ್ಲ ಸರ್. ಹೇಳ್ತೀನಿ ಬಿಡಿ, 34 ಯಾರಿಗಾಗಿದೆ ನೋಡ್ಕೊಂಡು ಅವ್ರಿಗೆ ಹೇಳಿ. ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅದು ಡಿಸ್ಪೋಸಲ್ ಅಲ್ವಾ, ಸ್ವಲ್ಪ ಟೈಮ್ ತಗೊಳುತ್ತೆ. ಹೇಳ್ತೀನಿ, ನಾನು ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಿ. ನೆಕ್ಸ್ಟ್ 12 ಗಂಟೆಗೆ ಬರ್ತಾರೆ, ಅವರೇ ಬರ್ತಾರೆ ಅಂತ ಹೇಳ್ತೀನಿ. ತುಂಬಾ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಹೇಳ್ತೀನಿ ಅಷ್ಟೇ. ಅವ್ರು ನನಗೆ ಹೇಳ್ತಾರೆ, ನಾನು ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಿ. ಅವ್ರಿಗೆ ಹೇಳ್ದಿರಾನು ನಾನು ಹೇಳ್ತೀನಿ. ನಾನು ಹೇಳ್ತೀನಿ ಅವ್ರಿಗೆ. ಗೊತ್ತಿಲ್ಲ, ಸೈನ್ ಮಾಡಿದಾಗ ಆಗುತ್ತೆ.
ಆಯ್ತು, ನೋಡೋಣ ಇವತ್ತಾಗಿ.
ಮೊನ್ನೆ ಇತ್ತು ಸೀರಿಯಲ್ ನಂಬರ್ 23 ಇಷ್ಟು.
ಮಾಡಿ
ಅರ್ಜೆನ್ಸಿ
ಮಾಡಿ 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 ಸರ್. ರಿಜೆಕ್ಟೆಡ್ ಮೆಮೋಸ್ ಎಲ್ಲ ಒಂದ್ ಕಡೆಗೆ ಎಲ್ಲಾದ್ರೂ ಇರ್ತಾ ಬಂದು ಯಾರಾದ್ರೂ ಬಂದು ಕೇಳಿದಾಗ ಹುಡ್ಕೊಂಡು ನಿಂತ್ಕೋಬೇಕು. ಅಲ್ಲೊಂದು ಇಲ್ಲೊಂದು ಅಲ್ಲ, ಒಂದ್ ಕಡೆ ಅವ್ರಿಗೂ ಹೇಳ್ತೀನಿ, ಎಲ್ಲಾದ್ರೂ ಒಂದ್ ಕಡೆ ಇರಕ್ಕೆ. ಅಲ್ಲ ಅಲ್ಲ, ನಿಮ್ಗೆ ಹೇಳಿದ ಮೆಮೋಸ್ ಬಗ್ಗೆ ಹೇಳಿದೆ ಅಷ್ಟೇ, ಇನ್ ಜನರಲ್ ಅದು ಇವತ್ತಿನ ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ. ಕೆಳಗಡೆ ಅಲ್ಲೊಂದಷ್ಟಿದೆ, ಅಲ್ಲೊಂದು ಸೈಕಲ್ ನೋಡಿದೆ, ಅಲ್ಲೊಂದಷ್ಟಿದೆ, ಅಲ್ಲೊಂದಷ್ಟಿದೆ, ಅಲ್ಲೊಂದಷ್ಟಿದೆ. ಇಲ್ಲಾಂದ್ರೆ ಫೋಲ್ಡ್ ಮಾಡ್ಬಿಟ್ಟು ಡೇಟ್ ಹಾಕಿ ಇಟ್ಬಿಟ್ರು ನೋಡಿ ಇಂಡಿಯಾ ನೋಡ್ಕೊಳ್ಳಿ ಅಂತ ಏನಾದ್ರು ಹೇಳಿ ಹಂಗ್ ಮಾಡಿ ಒಂದ್ ಕಡೆ ಎಲ್ಲ
ಮೇಡಮ್ ಇದೇನಾದ್ರೂ ನಿನ್ನೆ ಸರ್ಸಿದೆಯಾ ಮೇಡಮ್?
ಅಯ್ಯೋ ಅದು ಮುಟ್ಟಕ್ಕೂ ಟೈಮ್ ಇಲ್ಲ ಕಣಮ್ಮ ನಮ್ಗೆ, ನಾವೇನು ಮುಟ್ಟಕ್ಕೆ ಹೋಗಲ್ಲ, ಕೆಲಸ ಮುಗಿಸಿ ಮನೆಗೆ ಹೋದ್ರೆ ಸಾಕು ಅನ್ಸುತ್ತೆ.
ಕೇಬಲ್ ಏನು?
ಹೌದಾ? ಇಲ್ಲ ನಾವೇನು ಮುಟ್ಟಲ್ಲ.
ಕರಿತೀನಿ, ಮೆಸೇಜ್ ಬರ್ತಾ ಇದೆ. ಅದಕ್ಕೆ ಸ್ವಲ್ಪ ಇದು ಹಾಕ್ಬಿಡಿ.
ಅದಕ್ಕೆ ಇಷ್ಟು ಬರ್ಕೊಂಡ್ಬಂದ್ಬಿಟ್ಟೆ ಸರ್. ಇಡೀ ಗೇರಿಂಗ್ ಮಾಡ್ಬಿಟ್ಟು ಹಾಕಲ್ಲ. ಅದು ಡೇಟ್ ಅಲ್ಲಿ ಕೆಳಗಡೆ
ಮೇಡಮ್ ಚೇಂಬರ್ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀವಿ.
ನಾಲೆಜ್ ಇದೆ ಪ್ರಾಬ್ಲಮ್. ಈ ವೈರ್ಗಳು ಅದಕ್ಕೆ ನಮ್ಮ PC ಎಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಗಳು ಕ್ರಿಯೇಟ್ ಮಾಡೋದು, ಪೊಲೀಸ್ ಅವರು ಅದಕ್ಕೆ ಸಪೋರ್ಟಿಂಗ್ ಮೆಜಾರಿಟಿ ಕೇಸ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ಗೆ ಬೆಲೆ ಇಲ್ಲ. ಪೊಲೀಸ್ ರಿಟ್ಗಳೇ ಇರ್ತಾರೆ. ಟ್ರೆಂಡ್ ಹೆಂಗ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಇಲ್ಲ ಹೇಳಿದ್ರು ಕೋರ್ಟ್ ಆರ್ಡರ್ಗೆ ಬೆಲೆ ಇಲ್ಲ.
ಅದ್ರದ್ದು ಇಲ್ಲ ಪವರ್ ಅಷ್ಟೇ.
Yesterday it was working on. ಶರಣಕ್ಕೆ ಫೋನ್ ಮಾಡಿದೆ, ಅವ್ರು ಕರ ಮೇಡಮ್ ಚಂದ್ರ.
ಇದು ಇಲ್ಲಿ ಲೈಟ್ಸ್ ಎಲ್ಲ ಬರ್ತಾ ಇದೆ. ಇದೇನು HDMI ಕೇಬಲ್ ಇದೆ ಅದನ್ನ ಸ್ವ್ಯಾಪ್ ಮಾಡಿ ಚೆಕ್ ಮಾಡಬೇಕು. ಇದು
Any hotel not running right now?
lords. Lords,
Madam. Regarding?
Matter show cause notice was issued to the petitioner. Matter is according to state by honorable court is also subject to police brutality. This body, the ASP staff can include the matter.
You had moved it yesterday.
It was moved, but certain objections were raised in complaint.
As soon as the objection are complied, it will come. Yes.
My lord, one matter for 330, my lord, yesterday there was a dispute before our education institution and some samatas and then and police are refusing to intervene, my lord, so that's an urgency.
Police are refusing to.
Intervene and stop the issues because
If there's a private dispute, they can't come, madam.
because they put up a tent in front of our institution and therefore.
Tomorrow.
Let's-
2:30, my lord.
Tomorrow, madam.
That's one matter, Malats, for 230. Malats, petitioner is the owner of the petrol bunk, Malats. The display unit, Malats, of the dispensing unit, there is some malfunction. I tell the company that there is malfunction. They come, they fix it, Malats. Thereafter, they give me a fact finding report that they have broken the seal. And the time to, the notice time was to end on Friday, Malats. Before then and now, they've sent dozen of emails, Malats, stating we want to take over the petrol pump. Today, they've sent one,
Which company is it?
Malats, HP, Malats.
HP.
In this, at 2:30, Malats.
Hindustan.
Malats, there is extreme urgency, Malats.
HPCL.
Santosh Nagar.
Serve it on Mr. Nagrale tomorrow.
Malats, at 2:30, Malats. My
Tomorrow,
request,
please.
Malats.
Yes, Mr. Sarvana.
Lordship, I have this matter that Nagarbavi Club challenging the appointment of administrator. The matter was supposed to be listed on 3/8 for filing written submission. The matter went before the registrar. We have filed the written submission also.
Why did it go before the registrar?
Lord, there are some objection minutes by the government in filing their objection. So the matter went before the registrar.
So what is the next date given?
Lords, now, date was, I don't think the date is given, Lords, but we have filed written submission.
All registrars are also giving dates in all matters.
I'll just check, Lords. Lords, I just want to file 2 citations, Lords. Yesterday, my senior told that section
It will have to be
25.
listed. It will have to be listed, then we'll take it.
But senior said in some case, Lordship indicated section 25 and 27A.
Correct. But that,
Please,
what we only told him is that we will be considering that argument in that matter.
Please, Lords.
Let it come up.
Malaship, parallel extension, Malaship.
Huh?
Parallel extension.
Parole extension, 12th.
Today, Malaship.
Yes.
In this case, it was the matter was listed day before yesterday at 2:30 at serial number 23. Your lordships had told it will be listed for yesterday, and the matter was not listed since there is urgency, my lords. The reason is that police is intervening. Kindly have it at the end of the day.
Not end of the list, it will come.
Extension of parole, my lords. It's an extension of parole, my lords.
12th. Kodi.
In this case, my lord, counsel is appearing on behalf of some clients, my lord. He has been falsely implicated in the police complaint. He has issued a notice. I have filed a
Moved this matter.
police, my lord.
You had moved the matter.
Now today I am moving.
Monday same thing.
Moved, my lord, and that day some office objections were, now yesterday we are all
All of the
cleared.
objection complied. Complied agidre nade.
My lord, it's a fresh matter, my lord. My lord,
We have cleared.
We're challenging an AC's order, my lord, wherein on 27th the order was passed. Within 2 hours, a couple of hours rather, the mutation was affected, and now they're trying to sell the property, my lord. There's grave urgency, my lord.
Senior citizen matter.
My lord.
Senior citizen matter or what?
Yes, my lord.
Tomorrow.
2:30 urgency is this minute. Tomorrow is the tender is open minute for submitting the application. In similar matter, this honorable court has granted an interim order minute. This is relating to fishermen society's case minute where the government.
Tomorrow. Yen madala.
Tomorrow it's.
Tomorrow. Yes. The 10A. It will come in the regular course. Yes. What is the urgency, Mr. Counts? Cody. Yes.
Tomorrow.
The outdated 20th out. It will come. Why are you insisting like that? Ian, what is the urgency? We'll call your mother and make the inquiry. In another matter, it happened. Mother came on the video conferencing and she made a lot of allegations against the son. You want to take that risk? Yes. Nada. Please wait. Yenappa? Huh? In interim, pending matter. Pending matter will come in the regular course. ಆಯ್ತು ಒಳ್ಳೇದು ಮಾಡಿದ್ರಿ ಬರುತ್ತೆ regular course. Yes. What is the urgency in a mandamus will come in regular course?
My lord, this one. Medical emergency, my lord. My passport is arrested in this
moment.
My lord.
Yes.
There is some irregularities they have found, my lords, and they want to make a ad hoc arrangement, my lords. Yesterday they came for the petrol bunk, take over the petrol bunk, my lords. They want to make an ad hoc arrangement. Yesterday they came, my lords. I somehow avoided, my lords. Today again they wrote a mail. Today morning they will take over the process.
Who is the oil manufacturing company? OMC ಯಾರು?
My lords, HP, my lords.
HP Mr. Nagaralek sir ಮಾಡಿ tomorrow.
Today afternoon, my lords.
Tomorrow.
Because today they are coming, my lords, for taking.
Serve it on him. Let us get instructions.
My lord, a way bridge was allotted to the petitioner in the APMC yard in the year 2017.
APMC.
APMC yard, way bridge was allotted to the petitioner in the year 2017. In that year 2022, the precision certificate was issued. Right from the day one, there is no commercial activity. Now, the secretary has issued a notice for recovery of some of 29 lakhs.
APMC has issued.
Yes, my lord.
The APMC roster ಹೋಗುತ್ತೆ ಇಲ್ಲಿ ಬರುತ್ತೆ.
But public premises, ma. Now, the third government has also issued a notification for auction, for allotment through public auction. The auction is set to be held on 13th May.
It has been initiated under Public Premises Act.
Yes, my lord.
Tomorrow.
Madam, this is passport regarding my passport matter, my lord.
Already ಬರುತ್ತೆ.
Tomorrow, my lord.
My lord, the matter pertinent to parole, my lord. Parole, my lord. I had moved earlier also, my lord. I'm supposed to get listed today, my lord. The urgency is not. His father, Conway's father has been bedridden, and bedridden. And you want to see his son, my lord. That's what he has been granted.
12th. 40.
It is a,
Yes, madam.
it is a fresh matter, Your Honor. In the vacation bench, they got the interim order on this to vacate.
Will come in the
Posted on
Miscellaneous petition that
7th,
came
Your
to be
Honor.
dismissed for non-prosecution, my lords.
Maybe on 7th.
My lords, this is a miscellaneous petition which came to be dismissed for non-prosecution, my lords. My lords, for the issuance of a death certificate, my lords. Apparently it was posted before Honorable Justice Nagaprasanna, my lords. And then later on, after finding out in the registry, it was told that it has to be moved before a bench which has a miscellaneous application that can be heard here itself, my lords. It's a criminal miscellaneous. Criminal petition, yes, my lords.
Criminal miscellaneous, how will it come before us?
My lords, it was told that since criminal miscellaneous doesn't come under any roster as such, so it has to be moved before a miscellaneous court itself, my lords.
For the appropriate bench tomorrow.
Responding KPTCL has been conducted the exams, my lordship.
My lords, there's urgency in that.
Upon the
Come, bro.
Yes, much.
More urgency than tomorrow.
responding KPTCL is conducting the exams, my lordship. Upon that, there is a notification that before the 2025 of March, who has been enrolled as an employee can't write the exams. The coordinate bench of Kalburgi has allowed the petition. I am also petitioner for conduct exam has been called.
When is the exam?
On to the deputy registrar. They filed a complaint saying that there are full financial irregularities. We challenge the notice
Total
to
9.
your lordship directed that you file the reply and let the DR consider the reply and let him pass the necessary orders within 30 days. My lord, even after lapse of 1 year, my lord, there was no order passed. Now all of a sudden, my lord, the one inquiry record came to be filed. Where allegation says that there are no allegations. My section 25 order is passed, my lord, against the
Section 25 order illaagade. It's only an inquiry report.
inquiry.
Kodi ಬರುತ್ತೆ. ಯಾರು ಬಿಡ್ತಾ ಇಲ್ಲ ನಿಮ್ಗೆ? Executive officer ಬಿಡ್ತಾರೆ. Serve it, let us see tomorrow. NBW. ಯಾರಿಗೆ NBW? ಹಾ. ಈ ಕೋರ್ಟಿಂದ NBW ಆಗಿದೆ. ಯಾರಿಗಪ್ಪ NBW? Tomorrow.
My lords, this petition is challenging the compounding order passed in the Bureau of Indian Standards Act, my lords. The deadline is this Saturday, my lords. It may be, there's apprehension that it may be taken tomorrow. Tomorrow, my lords.
Compliance are there, it will come tomorrow. Give it.
My lords, the seized articles may be appropriated
If
towards.
you are complied with everything, it will come tomorrow. If you're not complied, it won't come tomorrow. That's all.
It's a fresh matter, my lords.
I'm a banker, my lord. Associations are being challenged before the Karnataka SEC Commission. My actions have been stayed over there.
Tomorrow.
My lords, one submission. In last week, my lords was not on leave. On that day, matter was listed. The senior citizen matter, my lords was directed Udupi DHO to take care of him.
Mysore.
My lords, not Ramakrishna Pillai, my lords. Is the senior.
Visit.
Yes, my lords. What happened is that my lords, he has undergone with an operation by tomorrow or day after, my lords. Therefore, it may be taken up tomorrow, my lords. I'll submit the order records.
Tomorrow.
Much obliged.
My lords, may I
At
make
2:30, my
submission?
lords, I'll request for tomorrow at 2:30.
It will come in the preliminary hearing.
My lords, may I make
Much
submission?
Yes.
My lord, number 34, I want to withdraw the petition.
Adjournment. List number 1, page number 4, serial number 24 and 25. Page number 5, serial number 26 to 29. Page number 6, serial
My
number
lords,
30.
please, serial number 29, my lords, Farishta Vanidya. And WP 12056, we have to file statement of objections, my lords. Kindly grant us 2 days time.
Have you informed everybody?
No, my lords,
Then please don't mention.
My lords, I appear for the petitioner in that matter, serial number 29, my lords.
Yes. He's not informed all the other respondents also. When it's taken up, please.
Please, my lords.
Serial number 30 to 32. Page number 7, serial number 33 to 37.
My lords, I appearing for petitioner in serial number 34, my lords.
32.
Memo for withdrawal.
32, there are two matters.
34, my lords.
34.
Yes, please.
Petitioner is before this court seeking for the following views. Memo dismissed as withdrawn.
Obliged.
Huh? Yes. Have you informed everybody? All the councils you are informed. We are not informed. Wait till it reaches. Yes.
Page number 8, serial number 38 and 39. Page number 9, serial number 40 and 41. Page number 10, serial number 42 to 45. Page number 11, serial number 46 to 48.
My lords, serial number 48, my lords. Respondent 4, my lord. 4 weeks time, my lord.
Have you informed the petitioner?
Yes, ma'am. Yes, my senior is informed. I'm not sure, my lords.
No, you're not sure whether don't.
My lords, kindly. We have filed a wakalat and
Once it reaches only if you're not informed. Yes.
Page number 12, serial number 49 and 50. Page number 13, serial number 51 and 52. Serial number 65 and 66.
65 and 66. Memo for withdrawal, dismissed as withdrawn.
List number 1, fresh matter, serial number 1. Lokesh Anjanappa.
Mr. Lokesh. The bit freeze. HDFC.
Francis Xavier.
Francis Xavier for respond number 2 and 3. Notice to respond number 1 is deferred for now. Petitioner is directed to appear before the Cyber Command on 6th, relist on 13th.
Serial number 2, Venkatesh Prasad.
Here for the petition, senior citizen matter. Annexure is A is under challenge. See, I am directed to pay 10,000 to my mother that I am paying, but without there being any order on the amendment application. 32 lakh is ordered to be paid. To that extent, I am before this honorable court without any inquiry. I have produced the order sheet also. I have produced the application for amendment filed by them. It is not supported by the affidavit. It is only memorandum of facts filed by the advocate. And presently,
have you borrowed this money from the on the base of the FD?
No. It is not the borrowed. The property was sold, and that particular amount was I have received it. And as per the wish of the mother, that has been shared among the children. Totally 4 children are there. He is the youngest person, the petitioner before this honorable court. And he was continuously taking care of the mother. See, when she was admitted to hospital, the sisters, they have taken her to the.
The finding here is that there's a fixed deposit of 32 lakhs, on which basis 52 lakhs, on which basis you took a 32 lakh
32
loan.
lakhs. 32 lakhs.
Have you taken the loan?
No, we have not taken any loan. We have not taken any loan. See, the instructions are, my lord, that particular amount has been shared amongst the children. Children, without making all the children as a party in this petition, this without even inquiry, without even giving notice to me on the amendment application, this order came to be passed. And now there is a direction also that cannot be done to the police, and police are harassing me. And I am ready to take her. Forcefully, ಅವರು ಹೆಣ್ಮಕ್ಳುಗಳು ಕರ್ಕೊಂಡು ಹೋಗಿ ಮಾವನ ಮನೆಯಲ್ಲಿ ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. She is suffering from acute dementia. 2023 onward, she is not even know what is happening.
Verify. Verify. And AGA for respond number 1 to 3, issue notice to respond number 4 returnable by emergent notice to respond number 4 returnable by 19th August. The who will go? The
Tahsildar will have to go.
Tahsildar
AC.
Dementia andre
Dementia ಇದೆ.
District surgeon to depute. The district surgeon, where is this? Bengaluru. Bengaluru under district surgeon would be difficult. Which
Victoria. Nimans are Victoria.
Being of the considered opinion that the Nimans would be appropriate, the submission of learned counsel for the petitioner is that the respondent number 4 is suffering from dementia. Being of the considered opinion that the same would have to be ascertained by deputing a suitable, competent medical professional to do an assessment. Nimans is directed, the director Nimans is directed to depute a suitable suitable in psychologist who is going dementia, who verifies a suitable doctor to ascertain the same to the residents.
Generally neurologist
of respond number 4. Registry is direct print the name of Sri Madhusudan Rao in the cause list to enable him to submit the report. So Rao is there. No. The Registrar Judicial is direct forward the copy of the above order to the Director Nimans. And AGA is also directed to inform the above order to the Director Nimans. The order dated 19/6/26, insofar as the repayment of a sum of rupees 32 lakhs is concerned, is stayed till the next date of hearing.
And also further, there is a direction, failure on the part of the respondent, police has to.
If that is stayed, then the police will not come, right?
ಅಲ್ಲ ಪೊಲೀಸ್ನವರು ಅವ್ರಿಗೆ ನಮಗೆ ಕಳಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ.
32 lakhs
without even field warrant also they come.
ಏನ್ ಸ್ಟೇ ಮಾಡಿರೋದು ಮಿಸ್ಟರ್ ಹೆಗ್ಡೆ?
ಅಲ್ಲ ಕರೆಕ್ಟ್.
ಮತ್ತೆ process fee and copies to be furnished by end of day 6th August, failing which the interim order will stand automatically vacated.
Hand delivery may be ordered, my lord, because police are harassing me.
Good. Yes, next.
Serial number 3, Varun Sai.
Defreezing of bank account.
Defreezing within the state, outside state?
Outside state.
And AGA for respond number 1, Shri Francis Xavier for respond number 4. Notice to respond number 2 and 3 is deferred for now. Petitioner is directed to appear before the Cyber Command on the 6th.
Tomorrow.
List on 13th.
Great.
Nale.
Serial number 4, H.C. Shivram.
So I pray for a short accommodation in this matter. We're awaiting certain clarifications on the.
And AGA accepts notice for respond number 1 to 3. At the request of counsel for the petitioner, released on, as per time, then it will go on 1st September. Yes.
Serial number 5, Shri Praveen Kumar.
Yes, Mr. Agar.
But matter pertains to, raises a question as to whether there can be a
classification within a classification, and whether it is permissible, my lord, under Article 16 in the context of presidential orders issued under 341, 342. As your lordships are aware, my lord, so far as scheduled caste, scheduled tribes are concerned, the requirement, my lord, of the Constitution is the 341, 342, there should be a presidential notification.
Yes.
Now that presidential notification has been issued. And, my lord, the persons belonging to 3 castes, namely Banjara, Bovi, Korcha and Korma, are classified, my lord, by a government order in terms of the presidential order. We are all scheduled castes, no difficulty about that. Now, my lord, within that, can there be a further classification which says that out of the 63 castes in C category, 59 castes are considered to be very backward and 4 castes are considered to be backward. And on the basis of empirical data, my lord, the population, 80% of the seats are reserved in favor of these 4 castes, 20% is reserved in favor of the 59 castes. And now in that 59 castes, the government says, my lord, we will reserve. They will get a preferential reservation, and if there is nobody amongst these 59 castes who have 20%, then only it will come to the 80%. Whether that is permissible is a question. And our submission is that having regard to the scheme of the Constitution, Article 16, read with Article 341, 342, there cannot be the executive government by a executive head cannot make a classification which in terms disturbs the classification that has been made by the president under 341, 342. The entire power under the Constitution, my lord, with respect to reservation is preserved to the president. Whether they want to create a sub-classification, that's a matter left to the president, if it is permissible under Article 16.
This is based on 2 reports.
Yes, that's right. That's right. It is. It is. It is. That is empirical data they have collected. That's a different issue, my lord. We are now on the question as to the power of the government without even a legislation to simply make a government order. And in fact, this question is already pending consideration before your lordships. If I may point out to your lordships those writ petitions, maybe it can be posted along with that. WP number 32137 of 2025.
What is the order passed in that matter?
But there is an interim order that has been passed. Your lordship may, in WP, there is one. There is another writ petition, my lord, 28612 of 2025, where your lordships have passed an order, my lord, on 16/10/2025.
Yes.
If your lordship will kindly see the order dated 16/10/2025.
Yes.
Learned AG accepts notice for respondents 1 and 2. He seeks for and is granted 2 weeks time to file statement of objections.
This is as regards the recruitment. Recruitment.
Yeah, that's right. This is exactly, this is also recruitment. This is also recruitment. And we are concerned, my lord, with the fact that under annexures L and M, please see, my lord, please be kind enough to turn to annexure L, which is at page 393.
This is still pending.
But it's pending. It's all pending.
1 year old matter.
Madam?
Yes, madam. In that you have filed objections? Last time it had come up before was in November, when you had sought time to file your synopsis of arguments, everything. Mr. Ruben Jacob had appeared. Learned AG accepts notice for respond number 125. A state commission for scheduled caste Sri Chandramohan K for respond number 6. What about respond number 7?
Respondent number 7, in fact, my respectful submission is notice can be dispatched at this point of time. But they were only giving
Memo has
a
been
report.
filed by the council for the petition.
For the present, notice can be dispatched.
For the present,
Unless your lordships want, think after, at the time of hearing, your lordships want to issue notice. Because according to me, my lord, may not be necessary because they have only given a report.
Commission need not be heard in any way.
That's what. So your lordships may I suggest
But
this
to respond number 7 is deferred for now.
You get great. That's
in view of the interim order dated 16/10/2025, passed in WP number 28612 of 2025, though the process for recruitment shall go on, the respondents are restrained from appointing any person in pursuance of
annexure L and M.
Annexure
L and M. L and M.
L and M. till the next date of hearing.
Great.
Connect with WP number 28612 of 2025 and relist on 1st September.
Great. General blanket, madam.
Arun Kumar,
The petition for this case. Lord,
Yes.
yesterday this case was passed over, and yesterday this case was passed over, Lord.
Uh-huh.
And it could not reach, Lord, therefore I'm seeking for a short accommodation.
You want a short accommodation?
Please, Lord. ನಿನ್ನೆ ಪಾಸ್ ಓವರ್ ತಗೊಂಡಿದ್ರು ಸ್ವಾಮಿ.
I had sought Passover, my lord.
But it could not, it did
This
not reach.
regarding
therefore-
the
You
base
again,
price.
what do you?
I'm seeking for a short accommodation, that's all, my lord.
Short accommodation will go to 1st September.
22nd or 25th, believe, my lord can
And
accommodate.
AGA accepts notice for respond number 125, relist on 1st September.
7, Ashoka T.
My lords, for petitioner, my lords,
Yes.
my lords, tender notification is challenged, my lords. Yesterday it was heard and passed over, my lords, for annexure A in page number 20 is challenged, my
At
lords.
5%.
Please, my lords.
Without showing the
Please,
price.
market rate.
Yes, madam. The
Lord,
market
it
rate is not
It
shown,
is issued based on a circular, my lord. Government
but market rate has to be shown for them to say what is the calculation of 5%.
instructions are that, my lord. If my lords may kindly peruse the circular, clause number 10, my lord.
Yes.
This is regarding the fixing the price, my lord. ಟೆಂಡರ್ ಅಂಗೀಕಾರ ಪ್ರಾಧಿಕಾರ ಸಮಿತಿಯು ತಾಂತ್ರಿಕವಾಗಿ ಅರ್ಹರಾದ ಬಿಡ್ಡಿದಾರರ ಸಲ್ಲಿಸಿರುವ ದರಗಳನ್ನು ಡೌನ್ಲೋಡ್ ಮಾಡಿಕೊಂಡು ತುಲಾತ್ಮಕವಾಗಿ ದರ ಪಟ್ಟಿ ತಯಾರಿಸಬೇಕು. ಟೆಂಡರ್ ದರಗಳನ್ನು ಮಾರುಕಟ್ಟೆ ದರಗಳಿಗಿಂತ ಹೆಚ್ಚಿಗೆ ಇಲ್ಲದಿರುವುದನ್ನು ಖಚಿತಪಡಿಸಿಕೊಳ್ಳಿ. ಕೃಷಿ ಮಾರುಕಟ್ಟೆ ವೆಬ್ಸೈಟಿನಿಂದ ಎಪಿಎಂಸಿ, ಜನತಾ ಬಜಾರ್, ಕೇಂದ್ರೀಯ ಭಂಡಾರ, ಎಂಎಸ್ಐಗಳಿಂದ ಪ್ರಚಲಿತ ಮಾರುಕಟ್ಟೆ ದರವನ್ನು ಟೆಂಡರ್ ಅವಧಿಯಂದೇ ಪಡೆದುಕೊಂಡು ಸಿದ್ಧಪಡಿಸಿಕೊಂಡು ತಕ್ಕದ್ದು. ಆರ್ಥಿಕ ಬಿಡ್ ತೆರೆದ ನಂತರ ಮಾರುಕಟ್ಟೆ ದರಗಳು they have to first take the
APMC, MSIL, Janata Bazar, so many of them different prices.
first, my lord, the tender amount submitted by the petitioners, my lord, will be taken, my lord, and they will ascertain with the prices which are given by
But
the
your
APMC.
condition is not
Lord,
more
because-
than or not less than 5%.
Lord, this is for providing food, my lord, to the patients.
Correct.
The prices may vary, my lord. For that reason, they have.
That is exactly the reason. Because if the price is 100 rupees by Janata Bazar,
Please, my lord.
102 by APMC,
APMC.
105 by MSIL.
They say further, my lord.
So by the difference only that 5% will go away. They'll become ineligible. Technical, they'll be disqualified. This is quite arbitrary.
My instructions are that, my lord, they have followed the government order, my lord.
Government order. You'll have to challenge
My
this.
lords, it is a coffee, tea,
Lord, may I
my lords.
submit one more
In our
submission, my
canteen,
lord?
we get coffee for 12 rupees. In
May I
coffee day, my lords, it may be 250.
You're not supplying coffee, but you have to challenge the circular now.
But that is not applicable to this case.
This is a
Because the
general
food-
direction which has been issued to everybody. If they have done it as per that, unless you challenge this, we can't pass any order.
Well, make amendment, my lords, till then.
Challenge Marty, then we'll stay this.
And, my lord, there are several prospective bidders, my lord, and
Everybody will have this
all tender matters, my lord, that are last 2-3 years, my lord, all the tender matters bring to your, my lord's notice that
You apply your mind, madam, to this. If this clause is there, what will happen? If you had even fixed only APMC is also fine.
Please, my lord.
You have fixed 5 authorities. APMC, Janata Bazar, Kendriya Bandara, MSIL.
MSIL, ಪ್ರಚಲಿತ ಮಾರುಕಟ್ಟೆ ದರ ಟೆಂಡರ್ ಅವಧಿ.
Shri Maratha, Nibandhane. So that is another this one.
They will do the comparative study and then fix the price. That is
Then
what
what
they
happens
say.
to your clause 6, 5%? Not more than or
They,
less
my
than.
lord, they have completely extracted from the government order, whatever it is.
Then AGA. Notice that again. And AGA accepts notice for respondents. She is filed a memo enclosing a circular dated 12/3/24 and submit that in terms of clause 10 thereof, circular is applied to the tender. Counsel for the petitioner seeks for and is granted.
1 week time, my lords. 1 week time, my lords.
1 week time. A
Two
week's
two
time
days,
to-
my lords. My lords, 2 days.
Tender will close by 1 week.
Please, my lord, 2
2
days.
days time.
Till then, my
File
lords.
amendment application released on 7th August.
My lords, till then, my lords, because.
Until you challenge, we can't pass orders.
Please, my lord.
Serial number 8, R.K. Mahadeva.
Yes, Mr. Mahadev.
Consider the representation, annexure page number 9. Consider the representation. Page number 9.
National Guardian Certificate Deputy Commissioner ಹೆಂಗ್ ಕೊಡಕ್ಕಾಗತ್ತೆ? You'll have to file under the Guardians and Wards Act.
ಅಂದ್ರೆ ಸರ್ಕ್ಯುಲರ್ ಡೆಪ್ಯೂಟಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ ಸರ್ಕ್ಯುಲರ್? Which circular are you referring to? You are asking yourself to be appointed as the guardian.
Yes, yes. Natural guardian.
Deputy Commissioner cannot appoint unless there is a certificate to be issued or something.
Certificate ಅಷ್ಟೇ. Only issues natural guardian certificate.
What is the circular that you want to claim this benefit of?
Page number.
ನಿಮ್ಮ ಹತ್ರ circular copy ಇದೆಯಾ? You have not produced it.
ಇಲ್ಲ. ಅಲ್ಲಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಇಶ್ಯೂ ದ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಅಂತ
Show the certificate, circular. If it is, because your representation is to appoint a guardian.
Yes, yes.
That cannot be done by the district. If it's only a certificate, we can direct them to consider.
Certificate, only issue certificate.
Circular ಕೊಡಿ ಅದು.
Kindly pass over.
Pass over.
Serial number 9, Badrinath.
Yes.
Notes appearing for the petitioners.
Yes.
Petitioner has deposited the amount before the respondent number 7 and 8, my lord. Where the 7 and 8 are under the control of the liquidator, my lord. Now we have made a representation to the respondent number 6, my lord, to withdraw to refund the amount deposited by the petitioners. The same similar matter is passed by the Honorable Court as Annexure D, my lord, page number 60.
That is only permissible up to 5 lakhs.
Yes.
Up to 5 lakhs, they can permit you to withdraw. We'll direct them to permit you to withdraw for 5 lakhs. But ಇವರೆಲ್ಲ party ಇದಾರಲ್ಲಪ್ಪ. And AGA for respond number. Who is for appellate authority? Why you made all of them a party? Shanti Bhushan, and DSG is directed to accept notice for respond number 1. Pradeep Savkar for respond number 2. 2 and 3. AGA for 4 and 6. Who is for 5? Managing Director, Karnataka State Sawadra Federal Cooperative Limited.
My lords, I will permit to withdraw 7 and 8, to delete the 7 and 8 of the respondents. They are under the control of the liquidator, respondent number 6.
Shruti Sahara. Liquidator Shruti Sahara Bank ಮಾಡಿದೀರಾ? ಇಲ್ಲಿ Shruti Sawadra Sahakara Bank ಅಲ್ವಾ? Respond number 6.
Yes, ma'am.
Which is the bank under liquidation?
Shruti Sahakara Bank. Shruti Saharda Cooperative Limited.
Shruti Sawadra Pattina Sahakari. See, your names that you have mentioned everywhere are different. Annexure B, the name is different. Annexure A, different. Respond number 6, 7, and 8 are different. And ACGP for 4, 5 and 6. Notice to accepting the memo. The petition as against respondent number 7 and 8 stands dismissed. The petitioner is before this court seeking for the following reliefs. The submission of the counsel for the petitioner is that a claim petition had been filed by the petitioner before the special officer and government authority, which has not been considered nor numbered. By way of the said claim petition, the petitioner had sought for withdrawal of a sum of rupees 25,00,000,000 for treatment of the petitioner who has undergone cancer surgery and suffering from various other age-related issues. The said claim petition not having been considered, did you give any representation? The petitioner is before this court seeking for the aforesaid relief. The application having been filed on 8/6/26 requiring immediate release of monies for the immediate treatment of the petitioner, it was but required for the respondents to have considered the same and pass necessary orders as expeditiously as possible. The same not having been done, this court passes the following order. Writ petition is allowed, a mandamus is issued, respondents are directed to consider the claim petition stroke representation of the petition dated 8/6/26 and pass necessary orders within 15 days from the date of receipt of a copy of this order as per the applicable norms, and permit the petitioner to withdraw the amount as may be permitted as permissible under the applicable law.
Serial number 10. Srinivasan Kulkarni.
Yes.
The petitioner is a pensioner of the Canara Bank. My lord, she is taking family pension since last 23 years. It so happened in December, one of the managers called her, said that some biometrics is required and she has to give some additional OTPs and all. She has given it innocently. Ultimately, it was found out that the manager who was taken into custody later on had committed a similar modus operandi against 21 other customers. But the bank went ahead and stopped me from using my own pension account. I'm getting hardly 14,000 something from because that to a family pension.
Canara Bank, TP Muthana. Yes. Shri TP Muthana is directed to accept notice for respondent number 1 and 2. Counsel for the petitioner to furnish 2 sets of the petition along with annexures on the said counsel. Shri TP Muthana is directed to secure instruction, make a submission as regards why the petitioner has been stopped from operating her account as indicated in the petition, and what are the steps to be taken by the petitioner steps to be taken by the petitioner in order to operate her account. Released on 12th August.
Serial number 11. Lokesha MY.
Petitioner, my lord. Annexure B, page 14, my lord. Is the order challenge before you ask?
Rowdy sheet.
Please, madam. As per annexure A, my lord, the page number 11, on request of this fourth respondent, third respondent passed the annexure B, my lord. See, while passing the order, requisition letter, page number 12, may kindly look into, my lord.
Yes.
There are 6 cases are quoted in my lord. Out of that, as per the view of the respondents, 2 cases were acquitted in the year 2013 and 15 itself.
Which case is acquitted? Serial number 1.
Page number 12.
Serial number 1 is pending.
Serial number 3 is acquitted, and serial number 6 is acquitted, my lord.
So,
out of 4, remaining 4, 4 cases are already investigation is completed. Charge sheet has been filed.
Yes.
Out of 4 cases, as per annexure D and E, a matter has been stayed before your honor. Page number 24 and 25, my lord.
Now, serial number 1 is pending.
Please, my lord. That has been stayed by the your honor.
That doesn't mean that it's gone away. It's stayed.
Yeah, please, my lord.
Serial number 2, only investigation is completed.
Investigation is completed, my lord.
Serial number 3,
acquitted, my lord.
Acquitted.
Please.
Serial number 4, pending.
Pending and it is stayed, my lord.
Serial number 5,
File is
Investigation completed.
investigation is completed, my lord.
Uh,
ದಾಖಲಾಗಿದ್ದ ಪ್ರಕರಣಗಳಲ್ಲಿ ಭಾಗಿಯಾಗಿ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಜಾಮೀನಿನ ಮೇಲೆ ಬಿಡುಗಡೆಯಾಗಿ ಹೊಂದಿರುವ ಸಹ ಪದೇ ಪದೇ ತನ್ನ ಸಹಚರರೊಂದಿಗೆ ಗುಂಪು ಕೂಡಿಕೊಂಡು ಅಮಾಯಕರನ್ನು ಅಪಹರಣೆ ಸಲುಗೆ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಸಮಾಜದಲ್ಲಿ ಸಾರ್ವಜನಿಕ ಶಾಂತಿ ನೆಮ್ಮದಿ
This is the requisition for seeking opening the rowdy sheet, my lord. No such cases registered against the petitioner, my lord. Admittedly, my lord, this petitioner is a owner of AK News YouTube channel, my lord. Because of some rivalry of other news channels, they managed to.
Always rivalry attributed to everything.
Managed to get
Is there
registered.
any
It
other-
appears that my lord he is.
No, if he is indulged in any other criminal activity, is there any other complaint filed?
That I have.
These are 6 earlier ones.
Please, my lord.
After getting bail, you are saying that he has ಜಾಮೀನ್ ಆದ್ಮೇಲೂ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ.
Please,
ಅದು ಏನ್ what are the documents for that?
I'll have to ascertain that.
Verify.
No such cases, my lord. Even, my lord, Annexure C, my lord, Annexure C, page 17, my lord. After
According to you, no such case. Let them verify and get back.
one submission, my lord. Page number 17, Annexure C. After the opening rowdy sheet, my lord, respondent number 2 issued notice for externment, my lord, without any report of the.
So what are you challenging? Externment order?
No. Rowdy sheet is challenged, my lord.
And AG accepts notice for the respondent. She seeks for and is granted a week's time to ascertain and make a submission. If there are any other complaints filed against the petitioner other than the 6 complaints, criminal proceedings listed in the requisition notice dated 24/1/2026.
Yes, sir.
Released on 12th August.
Till then, my lord, because the as per Annexure C, they are going to pass
Clearly
externment.
saying that there are so many matters, let them get the info.
No, their submission is, my lord, after release
The
from
counsel,
the.
your client already has 6 criminal complaints.
Please.
Not one.
Please.
And
All
for
same kind of.
quite serious offenses. Next.
Serial number 12, Satish K.
Matter pertains to the Kalburgi bench.
Kalburgi bench.
Offense is, my lord, the allegations are, my lord.
I was on deputation to Kalburgi. Lord, I am an
Hence
employee
regard-
of my lord government secretariat. Lord, I was on deputation. Lord, certain allegations were made, my lord. Annexure F is the committee constituted at page 43. Lord, retired district judge was appointed as Lord chairman of the committee, page 45, my lord. Lord, the report was submitted. Three members committee was constituted. Lord, page 47 is the report holding that, Lord, the charge leveled against the petitioner is not substantiated. On 2/8/2022, page 47. And, your lordship may kindly come to 3 points for consideration is at page 49. Whether the respondent has misappropriated the grant sanctioned to Shadi Mahal during his tenure as a district backward class welfare officer Kalburgi and in charge minority welfare officer Kalburgi. Then, my lord, finding is at page.
In the negative, yes.
Negative. Then, my lord, Annexure H, my lord, page 55 is the note given by the minority department. Lord, I was on deputation as district officer minority. Lord, the report of the committee was accepted and the file was closed. Then, my lord, the complainant was also informed, page 57. The complainant was, my lord, one Shri G. Rahman Sharif.
Yes.
Thereafter, my lord, after the closure of the file on 10/10/2023, my lord, the third respondent writes a letter, which my lords will find at Annexure K, page 60, reference number 6. After the closure, Lord, closure happens on 13/9/2022. After 1 year on 10/10/2023, my lord, 17A permission is sought. Lord, in respect of the same allegation, verbatim same, Lord, a complaint was given to Lokayukta. Annexure M is the note sheet of the Lord Lokayukta.
Yes, but the division bench has held that internal department inquiry will not take away the
internal
powers of the Lokayukta.
Yes, department, Lord, Lord, Annexure M, page 69, Lokayukta also, my Lord, conducts inquiry, page 69.
Yes.
Lord, that is also closed at page 78.
That is also closed.
That is also closed, my Lord.
Page?
Page 78, my Lord. Para 175. ಗೌರವಾನ್ವಿತರು ಒಪ್ಪಿದ್ದಲ್ಲಿ ಈ ದೂರು ಅರ್ಜಿಯನ್ನು ಮುಕ್ತಾಯಗೊಳಿಸಬಹುದಾಗಿ ಅಭಿಪ್ರಾಯಿಸಿ. Then, my Lord, page 176, para 176, my Lord, the Honorable Lokayukta concurs with the closed, my Lord. After this, my Lord, impugned order is passed, which is at annexure, page 67. Lord, the interesting part is, my Lord, all other closure orders are referred, and then, my Lord, the 17A is given. For
Lokayukta is closed, departmental inquiry is closed.
I'll have to verify, my Lord, get instructions.
We'll stay this further.
Lord,
And AG
as an
access notice
Lord,
for respond number 1 to 3. Considering that the inquiry committee in its report dated
2/8/2022
2/8/2022, as also the Lokayukta has closed the complaint against the petitioner, the permission granted under section 17 capital A of the PC Act would not be sustainable. As such, the impugned order dated 16/5/24 bearing so and so at annex issued by respond number 1 at annexure L is stayed till the next date of hearing. Released on 3rd September.
But R3, my Lord, for R3, my Lord,
sorry, AGA for 1 and 2.
R1 and R2, my Lord, my learned friend appears. R3, my Lord,
Arbatti.
Venkatesh Arbatti.
Arbatti for respond number 3.
Yes. Date may be given, my Lord, for
3rd September.
Serial number 13, Varun J. Patil.
Yeah, for the petitioner in this matter, Your Lord, challenging the final voter list prepared for the elections of respondent number 5 association, Your Lordships. Lordships would get the voters list at 21/7 at page number 13, prepared on 21/7/2026.
Civil suit.
Lordships, I admit, Your Lordships, one aspect, Your Lordships, page number 14 may be seen, Your Lordships. Serial number 40, the voter who is mentioned here has not cleared the bar exam.
We can't get into all these. Supreme Court has said full bench of Madras High Court. You only
And actually the
Senior only quoted the judgment that day.
The district committee also, Your Lordships, when I complained, they did consider it and they make an observation. Your Lordships should get it at the senior committee, page number 105 at paragraph number 14. They admit that these people cannot be in the voter list. But however, since there are decisions of the Supreme Court, they cannot do anything and it's at the hands of the returning officer. In fact, dead persons are also included in the voter list.
File a civil suit. You may get a stay of the election also.
Would request, Your Lordships, these members who have not cleared.
You can't involve in
subject to result. Your Lordship.
Writ petition cannot be done.
Please, Your Lordship. Please, Your Lordship.
And AGA accepts notice for respond number 1. G Natraj for respond number 2. Notice to respond number 3, 4 and 5 is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. The judgment to Nagaprasana or judgment to, he has quoted all 3 judgments. What has been sought for is for interference with the final voters list dated 21/7/26, prepared in respect of election to a society. The full bench of the Honorable Madras High Court in so and so has held that a writ petition would not be maintainable in respect of election disputes in respect of a society registered in Societies Registration Act, which has found approval with the by the Honorable Supreme Court in so and so. In that view of the matter, reserving liberty to the petitioner to avail appropriate available civil remedies, petition stands closed. Petitioner is disposed.
Please.
14, Manjunath, yes.
Petitioner.
Yes.
Plus the undated notice, my lords, at Annexure A is challenged, through which, my lords, the respondent authorities are opening a rowdy sheet, my lords, as against the petitioner herein. My lords, 4 crimes, my lords, are alleged in this notice. My lords, in respect of the very same crimes, my lords, earlier there was a rowdy sheet that was opened, my lords, and if my lords sees Annexure F, my lords, at page 41. This honorable, the coordinate bench, my lords, considering the very same crimes, my lords, and the first two crimes, my lords, under section 89 of the Police Act, my lords, the petitioner pleaded guilty. The other 2 crimes, my lords, civil in nature. And on these observations, my lords, the rowdy sheet was itself, my lords, quashed. So on the very same crimes, my lords, if my lord sees Annexure A, that is the impugned notice.
What are all the offences on Police Act?
My lords, 2 offences under Police Act, my lords. 2 crimes under Police Act, 87, my lords.
Yes.
And 2 other crimes, my lords,
109.
under 323, 448. But my lords, there was an observation, my lords, earlier that these crimes, my lords, have been filed by none other than the paternal aunt and the daughter of the petitioner, and hence a civil in dispute.
So all these 4 have been considered in that order.
All have been considered, my lords.
Yes,
if my lords sees para 6, 7, and 8, my lords.
How can you again be doing that after the High Court passes or not?
This that they have
And AGA accepts notice for respondent 1 to 4. The petitioner is aggrieved. Petitioner is before this court seeking for the following release. Petitioner is aggrieved by the undated notice at Annexure A, which is a show cause notice calling upon the petitioner to show cause as to why a rowdy sheet ought not to be opened in respect of the petitioner. Learned counsel for the petitioner would submit that the very offences which have been listed in the said undated notice had been considered by this court, by coordinate bench of this court, in its order dated 7th August 2024 in WP number 77 of 2024. And the coordinate bench had come to a conclusion that in 2 of the crimes which had been registered, the petitioner had pleaded guilty, and in 2 other cases, and the 2 other cases were registered on the basis of a complaint filed by the paternal aunt and her daughter of the petitioner, which is also pending in a civil suit, pending consideration in a civil suit. And on that basis, I had quashed, I had allowed the petition and directed deletion of the name of the petitioner from the rowdy register. Once this court has directed the deletion of the name of the petitioner from the rowdy register, the question of the respondents having once again issued the show cause, the respondents could not have issued a show cause notice calling upon the petitioner to show cause as to why his name should not be entered into the rowdy register as regard the very same complaints and or the crime registered against the petitioner, which had been dealt with by a coordinate bench of this court. Before issuing such show cause notice, it was required for the concerned officer to verify the status of the matter and if any orders had been passed in relation to the rowdy sheet of the petitioner. The same not having been done, the Director General of Police, as also the Inspector General of Police, PCW, are directed to, in furtherance of the directions which had been issued in earlier matters, to also incorporate a system for the issuing authority for opening a rowdy sheet to verify if any court orders had been passed in respect of the person to whom such a notice is proposed to be issued before issuing such notice. In view of the above, this court passes the following order. A certiorari is issued. The undated notice issued by respondent number 4 at Annexure A is quashed.
Great.
They could have replied for this also.
We have.
Log reply madrenu kashta.
Great.
15, Abhinay, yes?
Lords, I appear on behalf of the petitioner, my lords. Lords, the petitioner is a registered society, my lords, which was formed in the year 2004, my lords. We herein challenge the order of the Register of Societies, my lords, barring me from collecting the maintenance for the association, my lords. In fact, my lords, the matter is squarely covered by another interim order, my lords. I just pass the order. Exact same facts, my lords. If my lords may just look at page 2, my lords. The learned senior counsel appearing for the petitioner submits that the impugned order at Annexure A has been passed at the behest of respondent number 1, who is one of the owners of the residential premises in the layout. Directions are issued by the second respondent, the same second respondent herein, to the petitioner association not to collect any maintenance charges.
We won't say anything about that order. You are aware of the order passed by the division bench.
Please, my lords.
Then,
my lords, the only issue is this, my lords. There is
still continue to operate as a society.
My lords, there is no other act, my lords, under which I can register as a layout association.
If you don't know which act, we can't help you.
My lords, this is
and
a
AGA accepts notice for respondent number 1, notice to respondent number 2 is deferred, dispensed with in view of the order proposed to be passed by this court. The petitioner is before this court seeking for the following reliefs. The petitioner admittedly is a society registered under Societies Registration Act 1960 for the purpose of maintenance of a layout and the constructions which have been put up therein, including the common areas. By way of the impugned order, the first respondent has directed the petitioner not to collect maintenance amounts. There can be no infirmity found in the said order inasmuch as the division bench of this court in WA number 914 of
2025, if I'm not wrong.
No, dear.
That's the. I may just make this submission, my lords. My lords, all efforts are being taken to register it under the separate act, my lords. But in the meanwhile, he's not asked me not to take maintenance, which affects the day-to-day activities of 1,000 residents, my lord.
You are aware of that order some 10 years ago, and you have not done anything. In view of the order passed by the Honorable Division Bench in WA number so and so, when it has been categorically held that a society registered in Societies Registration Act cannot involve itself or have an object of maintenance of an apartment or a layout. In that view of the matter, no grounds being made out, the petition stands dismissed, reserving liberty petitioner to incorporate itself under the appropriate law.
Serial number 16.
My lord, University, my lord, is up to completion of the satisfactory work, my lord. The third respondent, executive engineer, submitted the bill, my lord, to the second respondent, finance officer, to his pending for since last 2.5 years. Please.
Mangalore University as standing counselor.
TP Rajendra Kumar Sundar.
TP Rajendra Kumar Sungay is directed to accept notice for respondent 1 to 3. Counsel for the petitioner to furnish 2 sets of the petition along with annexures on said counsel. Released on 27th August.
17. Nandish.
Nandish.
Defreezing of an account.
Defreezing.
Defreezing.
This is within the state of Karnataka. Utkarsh Small Finance Bank.
Different state, my lord.
Different state.
Different state. Annexed to B, page 10.
Page 10.
Various transactions in Andhra Pradesh, Tamil Nadu, Bihar, and Karnataka.
Oh. He has not made them a party. Yes, Mr. Nandish. You go to Cyber Command tomorrow.
Permit me to take out the handsome also.
You go to Cyber Command tomorrow. We'll issue notice. You can take all this information. They'll try and help you there. And AGA accepts notice for respondent number 1. Issue notice to respondent number 2. Returnable by
My lord, one humble submission, my lord. Kindly
Yes.
permit me to take out the handsome.
We'll permit you to do that. Return by 2nd September, counsel for the petitioner is also permitted to take out hand summons in respect of respond number 2. The petitioner is directed to appear before the Cyber Command on 6th August 2026 with all necessary documentation. So on. So relist on 2nd September.
Serial number 18, Monica.
For the petitioner in this matter.
I-1 of 26 is
My
allowed.
lords,
Yes.
impugned order is passed by the Information Commission, my lords,
Hmm.
where the present and past public information officers, penalty has been imposed on them to be recovered from their salaries, my lords, and direction is issued to reveal all the private details of the tenderer, successful tenderer. RTI application, my lords, page 18, my lord.
18.
Please, my
What are the information has to be there?
My lords, originally RTI application, my lord, is at page 28, wherein he has sought for the tender notification and Tirthalli Talukina Bahugrama Neerina Yojane. The typed copy, my lord, is overleaf, my lord, at page 30. ಬಹುಗ್ರಾಮ ನೀರಿನ ಯೋಜನೆ ಟೆಂಡರ್ ಸಮಯದಲ್ಲಿ ಯಶಸ್ವಿ ಗುತ್ತಿಗೆದಾರರು ಟೆಂಡರ್ ಪಡೆಯಲು ನೀಡಿರುವ ಎಲ್ಲಾ ದಾಖಲೆಗಳನ್ನು ಮತ್ತು ಟೆಂಡರ್ ನೋಟಿಫಿಕೇಶನ್ ಪ್ರತಿಗಳನ್ನು ದೃಢೀಕರಣೆ ನೀಡುವುದು. Tender notification, work order, agreements are all issued, my lords, in the first instance itself. Only the documents pertaining to net worth certificate, bank statements were not issued.
Why not?
Since it was information.
It is a public document once it is submitted along with the tender.
Please, my lord. However, under
That is what they want to see, whether he has a net worth or not.
My lord, under section 11, my lord, notice was issued to this successful tenderer, and he responded indicating that he is not, it would affect his confidentiality and material standing when it comes to his future
Madam,
projects.
once he enters the domain of tendering,
Please, my lord.
and he has submitted all the documents for evaluation,
Please.
there is nothing which can be said to be private about that.
Please, my lord.
He
Further,
has disclaimed his privacy right.
my lord, but it pertains to his bank statements and his net worth certificate, and that was put forth before the Information Commission at page 18.
Bank statement has not been, so network certificate, yes.
Please,
Bank
my lord.
statement kelidare.
Please, net worth, turnover, experience certificate at page
Ashte,
18. It's detailed.
Not bank statement.
Please, the relevant documents were all issued, my lord.
Network
Now the
and
Information
certificates
Commission.
are public documents. There is nothing private about it.
My lord, all the, if I may kindly request, my lords, to peruse page 18, my lords, at para 9.
Yes.
The Information Commission holds, my lord, ಒಂದು ಸಾರ್ವಜನಿಕ ಕಾಮಗಾರಿಯ ಟೆಂಡರ್ ಅಂತಿಮಗೊಂಡ ನಂತರ ಯಶಸ್ವಿ ಬಿಡ್ಡುದಾರರು ಸಲ್ಲಿಸುವ ದಾಖಲೆಗಳು ಮಾಹಿತಿ ಹಕ್ಕು ಅಧಿನಿಯಮದಡಿಯಲ್ಲಿ ಬಹಿರಂಗಪಡಿಸುವ ಮಾಹಿತಿಗಳಾಗಿರುತ್ತವೆ. ವೈಯಕ್ತಿಕ ಮಾಹಿತಿಗಳಾದ ಆಧಾರ್ ಕಾರ್ಡ್, ಪ್ಯಾನ್ ಕಾರ್ಡ್, ಆದಾಯ ತೆರಿಗೆ, ಬ್ಯಾಂಕ್ ತಕ್ತೆ ಮುಂತಾದವುಗಳನ್ನು ಸಾಮಾನ್ಯವಾಗಿ ಬಹಿರಂಗಪಡಿಸಲು ಕಾಲಂ 8 ಅಡಿಯಲ್ಲಿ ವಿನಾಯಿತಿ ಇರುತ್ತದೆ. ಸಲ್ಲಿಸಿರುವ ದಾಖಲೆಗಳಲ್ಲಿ ವಾಣಿಜ್ಯ ರಹಸ್ಯ ಅಥವಾ ಟೆಂಡರ್ ಗೌಪ್ಯತೆ ಎಂದು ಮಾಹಿತಿ ಒದಗಿಸಲು ವಿನಾಯಿತಿ ಇದ್ದಲ್ಲಿ ಅದನ್ನು ನಿರ್ದಿಷ್ಟವಾಗಿ ತಿಳಿಸಬೇಕಾಗಿರುತ್ತದೆ. Then ಸಾಮಾನ್ಯವಾಗಿ ಯಶಸ್ವಿ ಬಿಡ್ಡುದಾರರು ಟೆಂಡರ್ ಅಧಿಸೂಚನೆ, ಲೆಟರ್ ಆಫ್ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್, ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಸೆಕ್ಯೂರಿಟಿ ಕಾಂಟ್ರಾಕ್ಟ್ ಅಗ್ರಿಮೆಂಟ್, ನೆಟ್ ವರ್ತ್, ಟರ್ನ್ ಓವರ್, ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಮುಂತಾದ 10 ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಯಶಸ್ವಿ ಬಿಡ್ಡುದಾರರ ಕಾರ್ಯಕ್ಷಮತೆ ಈ ಎಲ್ಲಾ ದಾಖಲೆಗಳ ಮೇಲೆ ಅವಲಂಬಿಸಿರುವುದರಿಂದ ಅವುಗಳನ್ನೆಲ್ಲ ಬಹಿರಂಗಪಡಿಸಬೇಕಾಗುತ್ತದೆ ಮತ್ತು ಕಾಲಂ 11 ರಂತೆ ಮೂರನೇ ವ್ಯಕ್ತಿಗೆ ಸಂಬಂಧಿಸಿದ ದಾಖಲೆಗಳೆಂದು ಪರಿಗಣಿಸಲು ಬರುವುದಿಲ್ಲ.
Yes.
This, my lords, is the PIOs, my lords, rightly called for opinion under section 11. And it was based on that, they only did not withheld information with respect to net worth and turnover, my lords. And contract agreement were all
issued. You are being more
issued.
loyal than the king to the tenderer, not
My
to
lords,
your work.
since penalty is imposed, my lords, because they rightly withheld it.
Wrongly.
And, my lords, only based on their understanding of section 11. In fact, if I may, my lords, in the first appeal, they were directed to issue notice to the successful tenderer. If I may just produce that, if I may just request my lords to peruse the first appeal order at page 33.
Yes.
It was not unilaterally done by them also. And they've been now subjected to penalty, my lords, for acts which are done in good faith.
The application was submitted when?
My lords, the application was at 17/1/2025, my lord.
17/1/2025.
Please, my lord.
When was the first appellate order?
That was, my lords, on the 23/5/2025, my lord.
23/5/2025.
At the first
KIC
instance, documents were issued, my lord. Please,
whatever you thought fit to issue.
please, my lord.
And the second appellate order, KIC order was 3/7/26.
Please, my lord. There are two
After
orders,
the
my lord.
first appellate order also, you did not issue the thing.
My lord's first appellate order directed me to issue notice under section 11. I complied with that, my
Where
lord.
is that?
That's at page 33, my lord.
First appellate order said notice under
Please, my lord.
33. Yes. Where does it say issue notice?
My lord,
under
at
11?
the last but third line, my lord, ಸಂಬಂಧಪಟ್ಟ ಗುತ್ತಿಗೆದಾರರಿಗೆ ಪತ್ರ ಬರೆದು ಅವರಿಂದ ಲಿಖಿತ ಹೇಳಿಕೆ ಪತ್ರ ಪಡೆದು.
These are the facts. This is what your contention is.
Two, my lord. The
This is your
overleaf at
contention.
page 33, my lord.
ಆದೇಶ ಏನು?
Please, my lord.
Right, this is
ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ತಿಳಿಸಿರುವ ಅಂಶಗಳೆಂದು so and so. Last but third line, my lord. ಸದರಿ ವಿಷಯದ ಬಗ್ಗೆ ವಿಚಾರಣೆ ನಡೆಸಿದ್ದು ಅರ್ಜಿಯಲ್ಲಿ ಕೋರಿರುವ ಮಾಹಿತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸಂಬಂಧಪಟ್ಟ ಗುತ್ತಿಗೆದಾರರಿಗೆ ಪತ್ರ ಬರೆದು ಅವರಿಂದ ಲಿಖಿತ ಹೇಳಿಕೆ ಪತ್ರ ಪಡೆದು ಸದರಿ ಅರ್ಜಿಯಲ್ಲಿ ಅರ್ಜಿದಾರರು ಕೋರಿದ ಮಾಹಿತಿಯನ್ನು ನೀಡುವಂತೆ ವಿಭಾಗ ಶಿವಮೊಗ್ಗ ಇವರಿಗೆ ಆದೇಶಿಸಲಾಗಿದೆ. In accordance with this, notice was issued, and they being they paid less, my lord, and
see, K. Rajshekar is direct to accept notice for respond number 1. AGA accepts notice for respond number 2. Issue notice to respond number 3. Returnable by, where is he? Shumaga. Returnable by 9th September. The operation of the order date 3/7/26 passed by respond number 1 in case number KIC/1996/APL/2026 at Annexure A, and the order dated 25/3/26. What is 25/3/26 at Annexure B are stayed till the next date of hearing. Process fee and copies to be furnished by end of day 6th August, failing which the interim order will stand automatically vacated.
I'm grateful.
19, Prakash Ambed.
Respect of arbitration proceedings under section 34. While filing the petition before the learned district judge, my lord, it was belated. The first instance, my lord, the learned district judge has granted the interim order, having caused notice, my lord, keeping open the point of application regarding delay. After appearance, my lord, the learned district judge has discharged the interim order by passing an order on Lord, IA number 2.
Page number?
IA number 2. Lord, page 87. Lord, may kindly come to
87.
Please. Para 13. It is pertinent to note that the plaintiff here has challenged the award dated 1/9/2023 after lapse of 1095 days. The plaintiff has filed IA number 5 of the Limitation Act to condone the delay. The said application is due for consideration. It is a submission of the defendant counsel that in the month of December 25 itself, the plaintiff was made aware of the award of execution petition filed by the defendants. With regard to the said contentions, I am of the view that the merits of the case can be considered while dealing with IA number 1. The application averments in IA number 2 and the main petition averment do not contain any grounds so as to stay the execution operation of the award by exercising powers under section 36(2) of the Arbitration Conciliation Act. Hence, I am of the view that the ex parte order passed by this court so also deserves to be set aside.
Yes.
This is the only narrow ground, my lord, keeping open the other application. In fact, the respondents have filed one more application under section 9.
They should have dismissed your section 34 on this ground.
It is the only narrow ground, my lord. Yes.
Your 34 has to be dismissed.
Yes.
Instead of only vacating the order.
In fact, they have moved an application invoking section 9 that they are seeking a direction from the petitioner to deposit rupees 10 crores.
ಅದು ಬೇಕಾಗಿಲ್ಲ execution. 1095 delays. You have only 90 days.
Of course, 120 days is the
90 plus
prescribed.
630.
Please.
If you have to explain.
Since the proceedings were not, I mean, the notice of the proceedings was not reached the petitioner, that the ground taken. Lord, looking into that aspect only, the Lord District Judge has granted interim order at the first instance. And Lord may kindly turn to the initial portion of the interim order granted. By forming opinion that that application can be considered on merit so far as whether the petitioner was served or not.
When did you enter appearance in the execution proceedings?
Lord, execution proceedings in December 2025.
And when did you file section 34?
Lord, this was on 2/5/2026.
That is also 5 months
Yes.
later. If at least it was within 30 days of that, you could have done. Notice to respondent is dispensed with the new of the proposed order to be passed. Petitioner is before this court seeking for the following leaves. The petitioner is aggrieved by the order dated 9/6/26 passed on IA number 2 in commercial AP 6/26. IA number 2 was filed under subsection 2 of section 36 of the Arbitration Conciliation Act. ಇದು ANC Act ಕೊಡಿ. Which one? For vacating the ex parte order of stay granted in the matter. The reasons, the grounds on which the said application was filed was that the application under section 34 was ex facie barred by law of limitation, inasmuch as the award having been passed on 1/9/23, the section 34 petition was filed on
2/5/2026.
2/5, where is the date?
Page 75, Annexure J, the first page of the order sheet.
2/5/2026. And therefore it was contended that the filing of the proceedings under section 34 was beyond the period prescribed under proviso under subsection 3 of section 34, including the proviso thereof, which requires that a application under section 34 is to be filed within a period of 90 days, within a period of 3 months, and the proviso enabling the filing after a further period of 30 days, provided sufficient cause is shown for the delay. It was therefore contended that there was the award having been passed on 1/9/2023, the section 34 petition was filed after 1095 days. That apart, it was contended that the petitioner, who was the judgment debtor, had entered appearance in the execution petition filed by the respondents in December 2025. Even if that date were to be taken into consideration, the filing of the section 34 petition on 2/5/26 is beyond a period of 120 days from the date of appearance made by the petitioner in the said execution proceedings. These aspects were dealt with by the section 34 court in its reasoned order dated 2/6/26 for the very same reasons, and taking into consideration that even if the petitioner was not aware of the award having been passed on 1/9/23, the execution petition having been filed for executing the award in this, wherein the petitioner had entered appearance in December 25, was sufficient notice to the petitioner of the award having been passed. Even if the petitioner were to claim that he was not aware, it was not aware of the award having been passed on 1/9/23, when it became aware of the execution of the award in December 25, it ought to have complied with the requirement of subsection 3 of section 34. Even taking that date into account, the petition having been filed after more than 120 days, there is no ground made out in the petition. Though the commercial court could have dismissed the section 34 application, it has only vacated the ex parte ad interim order. This court does not find any infirmity in the same, petition stands dismissed.
Bill number 20, Gaurav.
20 minutes here on behalf of the petitioner. Lord, the relinquishment deed, my lord, has been executed by the BBMP, my lord, insofar as the petitioner are concerned. Land was acquired for widening of road, my lord. In spite of relinquishment deed, my lord, being executed in 2017, even as of today, my lord, the TDR rights have not been.
TDR not given.
BBMP, my lord.
BBMP, BDA. And AGA for respond number 1. Pawan Kumar for respond number 2. K. Krishna for respond number 3. 4 is BDL, va?
BDA.
3 and 4 K. Krishna. Counsel for the petitioner to serve 2 sets of the petition along with annexures on the said counsels. Relist on 19th August.
Please. Great.
21.
Yes. Yes, Mr. Chota.
Writ in the nature of mandamus to consider representation, my lords. My lords would notice 2 prayers that we have made at page 21, my lords, prayer 1 and prayer 3.
CCTV footage, yes.
And prayer 1, my lords, where we have given a representation to the director. That representation, my lords, should get at page 24, my lords. So this particular investigating officer, my lords, without there being a registration of ECIR, an interception that takes place, 24 hours a person has been detained, my lords. And then there is a complaint given against the investigating officer to the commissioner.
Your representation, you want the investigating officer to be relieved.
And change to another one, my lords. We want the investigation to go on, but a change of investigating officer, my lords.
We direct such a representation to be considered.
My lords, the reason.
Item prayer 3, yes.
Yes.
Change
No.
of this one on a mandamus.
No, my lords, what? No, only for considering it. Person in charge will be the director, my lords, under the PMLA Act. He has the power to entrust it to an officer of his choice. Here, this particular officer, my lords, on 18th would cause an interception of a person, my lords, would call me back from my house. We are taken to the ED's office, my lords, without there being registration of any ECIR, 24 hours detention. Then, my lords, we give a representation to the
You
commissioner.
have no choice as to who is going to investigate.
No, my
There
lords,
is a
anyone
question
of their choice, but this particular investigating officer, he becomes an informant, my lords, in an FIR registered against me, and he becomes an accused.
That may be a ground for you to argue. Not for change, it's by way of a representation.
My
Can't
lords,
be allowed.
only bias, my lords, is what we are looking at. Would it be a fair investigation if he is an accused, my lords?
You can take it up as a ground. Not more than that we can't say.
Oh, but my lords, director always can change the investigating officer if it is a
At
case
his
that he is
discretion,
an.
not at your request. Ms. Annapurna.
Please, ma'am.
Annapurna Bardale accepts notice for respond number 1 to 4. CISF.
That's respondents 5
for
and 6,
the
my lords.
CCTV
That's
is
where-
in their custody.
Yes, my lords. The footage is with them.
CISF, we are standing counsel here
My lords, I'll appear for CS.
for 1 to 5. BIAL, now it is KIAL.
KIAL.
Manu Kulkarni for respond number
6.
Airports Authority.
Joshua Samuel.
Joshua Samuel for respond number 7. You will appear for 8 also.
8
right?
also.
8. Annapurna Bardale for 1 to 5 and 8. Petitioner is before this court seeking for the following reliefs. The submission of Shri Sandesh Chautal and counsel for the petitioner is that the investigating officer is prejudiced against the petitioner and there is a reasonable apprehension of bias of the investigating officer insofar as the petitioner is concerned. And as such, a representation has been submitted to
Mainly to the director, my lords. Others are not relevant. Director would be the relevant person. First person.
everybody in the world.
But first person is relevant, my lords. He is the highest post under the PMLA. The first name may be noticed, my lords, to the director, Directorate of
They have to
Enforcement.
take exception to this kind of a communication. You are addressing it to the Honorable Chief Justice, High Court of Delhi, Chief Justice of India? What kind of a representation and a letter is this that you are sending?
Should be to the director. I think that would be the
You
appropriate.
send it by email to Delhi High Court at nic.in, Supreme Court at nic.in?
I get it. I understand.
And you produce that also.
That's
On
only
that basis, you are seeking for relief.
That's the only representation they gave.
You have to advise. Being a senior counsel, you are also an officer of the court. Please, not like this. We'll impose costs. So let him know that he can't be doing these kind of things. And since more so you have appeared, costs have to be quite reasonable.
I'm sorry.
Quite reasonable in fact. A representation had been submitted on 25/7/26 to the Honorable Minister of Finance, to the Directorate of Enforcement, with copies to the Honorable Minister of Finance, Secretary, Department of Financial Services, the Chief Vigilance Officer of the Directorate of Enforcement, the Honorable Chief Justice, High Court of Delhi, the Honorable Chief Justice of India, Supreme Court of India, seeking for the immediate recusal and relieving of the investigating officer, the investigation to be entrusted to another independent officer who had no prior involvement in the events of 18/4/26 or subsequent proceedings, and further not to take any coercive steps against the petitioner until his representation is considered and an appropriate decision is taken. The said representation, firstly, could not have been submitted by the petitioner. The petitioner, being under investigation, has no choice as regard the investigating officer. Secondly, the manner in which the said representation has been addressed not only to the Director of Enforcement, but also to the Honorable Minister of Finance, the Chief Justice, High Court of Delhi, and the Honorable Chief Justice, High Court of Delhi, Honorable Chief Justice of India, by marking emails to the email ID of the High Court of Delhi as also the Supreme Court of India, is required to be deprecated and is so deprecated in no uncertain terms by this court. The manner in which such a representation has been addressed would require this court to impose costs on the petitioner so that these kind of actions are not encouraged in future. Insofar as the second and third prayers are concerned, the third prayer is concerned, insofar as second prayer is concerned, no such direction could be issued by this court changing the investigating officer. I'll do interim order. Where is an investigation to another person? And as such, prayer 2 is liable to be rejected. Insofar as prayer 3 is concerned, what the petitioner is seeking for is for preservation of the CCTV footage from 11 p.m. on 17th April 26 to 11 p.m. on 18th April 2026, which the petitioner would be entitled for, since the same would be part of the investigation.
Yes.
Hence, respondent number 5 and 6 are directed to preserve the CCTV footage from 11 p.m. on 17th April 26 to 11 p.m. on 18th April 26. At which location?
Well, it's just in the Kempegowda International Airport itself.
From the,
that's where respondent 5 and 6.
So from the disembarkation in the air, from the plane, or from the time that you entered the arrival hall?
If I narrate the factual aspect, what had transpired, this one gentleman called Mika Mark, who has also filed a similar petition before this honorable court, which is pending, and there also cost is imposed. In that, Mika Mark was found in the airport, inside the airport. We intercepted him and found in the airport.
Airport or the aircraft?
No, in the airport.
Yes.
And then, my lords, this Mika Mark informed that he is accompanied by this petitioner. And Mika Mark made a call to this petitioner, and petitioner came inside the,
We are not looking at all.
yes, my lords.
From where is, which location?
Airport, my lords. In the airport, they both were,
CCTV,
Portion of
madam.
the airport.
that, my lords, I need to verify.
Thousands of CCTVs are there. We can't.
Yes,
preserve
yes, that's
everything.
correct, my lords. We need to find out.
Location to which location?
Correct. We need to find out that. My lords may have it.
My lords, from his arrival in the airport, my lords, till the ED took him along with him. Because there was
My lords,
no.
my
but
instruction is we did not take him away. He has volunteered
Anyway, my
to
lords, we are
accompany.
asking for
We are not making
CCTV
any
footage.
observations.
That's all of it. We are only asking for the footage.
Yes, yes, yes.
Footage from which location to which location is
Yes,
what we
my
are
lords.
asking.
From entry to the exit.
From blank to blank, you find
Yes,
out.
my
and
lords,
let
we'll
us know.
exactly give the.
Hence, this court passes the following order. Writ petition is partly allowed insofar as the preservation of the CCTV footage is concerned and is dismissed in respect of the other prayers by passing the following order. The respondent number 5 and 6 are directed to preserve, secure and secure the CCTV footage from 11 p.m. on 17th April 26 until 11 p.m. on 18th April 2026 from blank to blank. Which location you will?
We'll give that, my lords.
The above, as observed supra, cost being required to be imposed, cost of rupees 5 lakhs is imposed on the, cost of rupees 1 lakh is imposed on the petitioner payable to the Karnataka State Legal Service Authority within a period of 15 days from the date of receipt of a copy of this order. If the said payment is not made, the member secretary KSLSA would be entitled to recover the same from the petitioner as arrears of land revenue. Come back in 5 minutes.
ವಿಶ್ವಾಸ ಅವತ್ತೇ ಒಂದಿನ ಹೇಳಿದ್ದೀನಿ. ಅವತ್ತು ಹೇಳಿದ್ದೀನಿ ನಿಮ್ಗೊಂದಿನ ಹೇಳಿದ್ದೀನಿ ನೋಡಿ, ಲಿಸ್ಟಲ್ಲಿ ಇರುತ್ತೆ, ತೆಗೆದು ನೋಡಿ, ತೆಗೆದು ನೋಡಿ ಒಂದ್ಸತಿ. ಏನಿಲ್ಲ ಬರೆಯಲ್ಲ ನಾನು. ನೋ 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 ಲಿಸ್ಟಲ್ಲಿ ಇದೆ ನೋಡ್ರಿ ಇವತ್ತು. ಹುಡುಕ್ರಿ ಲಿಸ್ಟಲ್ಲಿ ಇದೆ. This number 1, figure number 22, the Ananda Tirtha.
But it's a case where, my lord, the second respondent has started some development activities on, my lord, the government land, which includes, my lord, a public roadway, preventing a total, my lord, denial of access to the property of the petitioners. And some other people, my lord, who are not even aware that, my lord, such an obstruction is there. Kindly see, my lord, I produced the sketch of the property. Page 45 may kindly be seen.
Slum Development Board has started.
Yavadu?
Slum Development Board has started.
Howdu?
Yes.
No, kindly see page 45. My lord.
45.
Last page. This is, my lord, attached to the notice issued to, my lord, the second respondent Slum Development Board. They are really doing the construction activity. My lord, the plot shown, my lord, the bigger plot belongs to the petitioners. My lord, something shown in red color, my lord, round again. That is where the obstruction is. My lord, two roadways are there giving access to the petitioner's property. They are totally blocked it. Your lordship can find it in the photograph.
Notification has been issued under section 3 and
ಏನು
17.
ಇಲ್ಲ.
No
Nothing is there. They are not even replied to my legal notice also.
Where is
Kindly
the-
see, my lord, annexure D1 for a better understanding, my lord, what is the activity being carried out.
Page
Page, my lord, 38.
38.
Out.
38 is the photograph.
Photograph, yes. But your lordship will find some trenches are there, my lord. That is one obstruction to the one roadway. Other, my lord, they have already obstructed by constructing some, my lord, the building. My lord, my lord, we are satisfied if we can get the one roadway also.
Where is the road? In
My
the
lord, your
picture?
lordship will find, my lord, that ಇದು ಹಾಕಿದ್ದಾರೆ ಅದರಲ್ಲಿ.
Is it a public road? Where
It is a public
what
road.
document is there to show that it's a public
Yeah,
road?
it is public road, my lord.
Show us a public document.
My lord, it is there since ages. Your lordship may kindly see one document which I can show. This road has been recognized at the time when the conversion order was also granted by the development authority. Page, my lord, that is annexed along with the sale deed, but it is given by, my lord, the development authority.
That's
Kindly
your
see.
own declaration, Mr. Krishna.
No, not on my
First, a public document that it's a road.
But your lordship may kindly see page 36, my lord. Page 36. This is the document issued by, my lord,
Innon
development authority.
High Court of Karnataka sale ಮಾಡಿ ಕಬ್ಬನ್ ಪಾರ್ಕಲ್ ರೋಡ್ ತೋರಿಸ್ತಾರೆ.
ಇಲ್ಲ, your lordship may kindly see
Show
the-
us a public document.
Well, public document ತೋರ್ಸೋದಕ್ಕೆ, my lord, except this, there is no other document. Even otherwise, my lord, your lordship.
First, it is if you are claiming easement right, you file a suit.
I am not asking for, my lord, it is not my road. It is not my road alone. My lord,
Claiming
I can
access.
understand, my lord, it is my road.
If you have shown a road in some other land without it being a public road, that does not make it a public road.
No, what I am saying, my lord, is that the second respondent clandestinely, my lord, even if they were, assuming, my lord, for that matter, this is only road I have.
So you don't have any public.
I don't have any other road at all.
Here accepts notice for respond number 1, Slum Development Board.
HL Pradeep Kumar.
HL Pradeep Kumar is directed to accept notice for respond number 2, counsel for the petitioner to serve 2 sets of the petition along with annexures on the said counsel. Counsel for respond number 2 is directed to as regards on what basis the second respondent is putting up construction on property bearing survey number
But that is survey number 92/2.
92.
92, my lord.
In survey number 92.
Yes.
Released on 18th August.
May I seek for a status quo, at least insofar as one road is concerned, my lord.
If you had shown us a public road, you would have stopped them.
My
Not
lord,
otherwise.
my lord, now the problem is, my lord, I don't have an access at all to my property.
You
No
bought a
access.
land without access by
No,
somebody
there was an
showing
access, it was recognized even by the development authority. Your lordship will find it in page 36. That is, it is a sketch given by the development authority.
Sorry, Mr. Krishna, next.
Please, my lord, can I have a shorter date at least, my lord?
18th is a very short date.
Aye.
Number 23, Ina N, corrected matters.
Lots in this 23, they all pertaining to minor irrigation. My request, Lordship,
In
to have
irrigation or fisheries?
fisheries and minor irrigation both.
Lords may take note 23.1,
Lots may
the second matter.
may request Lordship, if it's not an objection to the other side, to have it on Monday. Lords, I'll prepare a chart with respect to 23 and also 57. When 57 reaches, I'll mention that.
57 is also connected.
It's all tender with pertaining to fisheries and
57 randomization.
P7, we have filed the impeding application. We are the successful bidders where we have.
Who are you?
I'm the successful bidder in that.
Successful.
In implementing
Paid an amount of 90.
Mr. Manmohan will say, welcome to the party. He won't.
I'll just file a chart in respect of these two. Lordships may have it on the same day, Lords, and give us about half an hour.
How long will you take?
I think about half an hour, Lords, because I'll prepare a chart.
Not the issue, my lord, accord in my matter, 15-20 minutes. That would
Your matter or all
my
the matter?
matter. Lord. That's the first, the second
Who
matter.
else would be arguing?
But
They
in
are
fact,
arguing.
Lord, I think my learned friend's matter is different from mine. I think 23.3, Lord, my learned friend's matter.
Then why are they connected?
But I don't know why it is connected. But there, Lord, my learned friend says, Lord, his matter relates to where, not whether it comes within not the jurisdiction of the fisheries department or not lift irrigation. But in my matter, the issue is not they have issued not the circular, and in the circular they have mentioned not both lift irrigation and not the fisheries not department.
Anyway, it's the same more or less.
Very well.
23 connect to 57.
23.2, that 23.2, Murad. These petitioners, Murad, 5 societies, Murad, their tanks, Murad, fishing right granted by the fisheries department within the Bangalore agglomeration and BBMP limit.
We'll consider all of it together on that day.
Let them, Murad, made a clarity, Murad, with regard to.
That is what the chart is making.
Whether you included or excluded, that's not.
Objection is filed.
Yes, yes.
23.4 non-compliance with office objection. Sandesh. 23.4 counsel for the petitioner is granted 2 days time to comply with office objection. If not complied by next date, the petition will be liable to be dismissed for non-prosecution. Connect with 57. 57 and on order. Vijay Kumar T.
ಇದು ಮೆಮೊ ಹಾಕಿದ್ದೀನಿ ನಾನು ಇಂಟರ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್
Memo ಹಾಕಿದ್ದೀವಿ to adopt 23.1. 23.1.
You are appearing for Mr. Vijay Kumar. Where is Mr. Vijay Kumar? Who is he? ಎಲ್ಲರಲ್ಲೂ Vijay Kumar ಹಾಕಿದ್ದಾರೆ and you have also filed. Okay, when that reaches, connect with 57. When 57 reaches, he will come probably.
The interim order may be extended.
Released on 10th at 2:30 p.m.
Please.
All the councils are, respective councils are directed to place their respective synopsis of dates and events, list of authorities, along with copies of the authorities after serving advance copy on the other side.
The interim order may be extended.
Interim order earlier granted is extended.
Great.
B group matters, serial number 24.
Lordship, serial number 24. I appear for respondents in 24.1 and 2. All the three are connected to same issue, my lords. May I request for 10 days time? I place these 10 objections.
I'm appearing for the petitioner, my lord. Here, my lord, only the question is, my lord, which guidelines is applicable, in earlier guideline or subsequent guideline? Here is
10 days time, my lords. I place it on record.
You
10
are not
objections.
appearing 24, Ajay, you are
No,
appearing.
I am appearing for 24.
In 24, Shri Ajay Prabhu has entered up.
True, man. 24, 24, 1.2.
The name of Shri H. Shanti Bhushan as that appearing for respond number 1 to 3. 24.1 and 24.2 Shri Kumar MN has entered appearance for the respond. Delete the name of Shri S. Shanti Bhushan as that appearing for respond number 1 and 2. Shri Shanti Bhushan, Shri MN Kumar seeks for and is granted 10 days time to get ready and make a submission released on 25th August. Please.
Please, my lord. Much obliged.
I will make it, my lord. File objection. Obliged.
Serial number 25, NC Shivram.
Appearing for the petitioner, my lord.
Yes.
My lordship, in respect of respond number 3, the present advocate was filed retired memo. The respond number 3 informed that to file wakalat in the next date of hearing.
You will be appearing.
Please, please.
So also submit that you would be appearing for respond number 3 and by filing his wakalatnama during the course of next week. He also seeks for and is granted 2 weeks time to file a statement of objections. Relist on 1st September, interim order earlier granted is extended till next date of hearing.
Grateful.
26. Yes, sir.
Petitioner, my lord.
Yes.
The 4 police officials, my lord, entered the petitioner's house, my lord, without any warrant, my lord. And in this regard, I given a complaint, my lord, to the respondent number 2.
AGA to secure instruction as to what has become of the complaint.
The departmental inquiry had been initiated. What happened? I'll just seek inspection about the departmental inquiry.
Already.
On last hearing, we had filed a memo about the proceeding of the departmental inquiry.
Pass over, get
Please, ma'am.
pass over.
27.
Lordships, I have filed wakalat for respond number 3 this morning, my lords, in the counter. I'm seeking 2 weeks time to file my objections.
But what is this matter?
My lordships, the petitioner is a landlord, leased out a premises for the Union Bank. They have adjusted the security deposit towards the rents before vacating itself.
Security deposit towards the rents.
Rent. That is contrary to the lease agreement. That apart, the bank has freezed the bank accounts of the landlords without any notice.
For what reason?
My notice is at page 43, my lordships. And they have not cancelled the encumbrance. Vacated the premises, they have not cancelled the encumbrance.
These are all
my lordships, freezing of account is there.
Freezing of account is the only thing.
Freezing of account and the direction to remove the encumbrance.
All the others are civil
Others
disputes.
I will, please, ma'am.
Why have you frozen the account, madam?
Because I'll seek
Without
instructions,
notice,
my
my
lords.
lord.
I will seek instructions and file objections as well, my lords.
Let counsel for respond number 1 to 3 submit that she has filed wakalatnama today.
This morning.
She seeks for 10 days time to obtain instruction, make a submission more specifically as regards the basis for freezing the account of the petitioner. Released on 19th August.
Serial number 28. Yes, Gurudat.
I'm for the petitioner in this case.
Yes.
I filed my rejoinder.
Hmm.
They filed the detailed objection to my petition.
Hmm. Yes.
Petitioner is about 75 years. She is the mother-in-law of the second respondent. She filed an application before the AC on the section Senior Citizen Act.
Yes.
There are two premises, one is 23 and another is 24 premises, my lord. 23 premises is the temple premises where the petitioner was living. The second respondent husband died. They were living separately. The second respondent forcefully she entered to the house and she evicted this petitioner from the house, my lord. Then she filed an application before the Assistant Commissioner against section 20, section 22 of the Senior Citizen Act, my lord. There, the order was passed by then alternative accommodation has to be given. I said, we are ready for that. We filed an application with a sketch also, and also we have filed a sketch and an affidavit that the section, the premises number 24 on portion is vacant. She can go there. The Assistant Commissioner passed an order also in the month, they pass an order that that should be accepted. But the respondent, once again, she approached the assistant commissioner, and the assistant commissioner on his own order, he has changed the order and said that this is, they have to go to the civil court. He can't change the order, my lord, whatever it is. He changed his own order. If the second respondent has been agreed,
Where is the order?
my lord, I'll tell you, my lord. Annexure.
Annexure.
Annexure C, my lord.
Page.
Just one
Annexure
second, my
C,
lord.
Allah.
One second.
Annexure B is the original order, Your Lordship. Annexure page 16, my lord.
Annexure B is the original order.
Yes, Your Lordship. ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ ಎದುರುದಾರರಿಗೆ ಪುಟ್ಟ ಮಗು ಇದ್ದು ವಾಸಕ್ಕೆ ಬೇರೆ ಯಾವುದೇ ಮನೆ ಇಲ್ಲದೆ ಇರುವುದರಿಂದ ಅರ್ಜಿದಾರರು ವಿಚಾರಣೆಯಲ್ಲಿ ತಿಳಿಸಿರುವಂತೆ ಒಟ್ಟು ಆಸ್ತಿಯಲ್ಲಿ ಎದುರುದಾರರ ಭಾಗಾಂಶದ ಮನೆಯನ್ನು ನೀಡುವವರೆಗೂ ಎದುರುದಾರರು ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತಿನಲ್ಲಿ ವಾಸ ಮಾಡಲು ಅರ್ಜಿದಾರರು ಅನುಕೂಲ ಮಾಡಿಕೊಡಬೇಕೆಂದು ಈ ಮೂಲಕ ಅರ್ಜಿದಾರರಿಗೆ ತಿಳಿಯಪಡಿಸಿದೆ. ಯಾವುದೇ ಸಣ್ಣ ಪುಟ್ಟ ಜಗಳಗಳಿಗೆ ಸೋ.
What is the changed order?
Changed order, Annexure G, page 33, madam.
33.
The second para, my lord, it starts from page 33. There's a third para, my lord, third para.
The first order was passed on 27/11/23.
Annexure G, 27/5/2004.
This was passed on 27/5/2024, Your Lordship. Second, third para,
of issue, how did he, that was disposed?
Yes, sir, that is disposed of.
Then how does he get power on 27/5/24?
Third para, my lord, third
Yes.
para. ಈ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ರೀತ್ಯ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತು ಅರ್ಜಿದಾರರ ಹಕ್ಕು ಮತ್ತು ಮಾಲೀಕತ್ವಕ್ಕೆ ಒಳಪಟ್ಟಿರುವ ಮಿಲಾಡ್ ಗಾಟ್ ಇಟ್ ಮಿಲಾಡ್ ಪೇಜ್ 33 ಅನೆಕ್ಷರ್ ಜಿ ಮಿಲಾಡ್ ಅರ್ಜಿದಾರರ ಕೋರಿಕೆ ಮೇರೆಗೆ ಮುಂದಿನ 1 ತಿಂಗಳ ಕಾಲಾವಕಾಶದೊಳಗೆ ಮನೆಯನ್ನು ಖಾಲಿ ಮಾಡಿ ಭಾಗಾಂಶದ ಮನೆಯಲ್ಲಿ ವಾಸ ಮಾಡುವಂತೆ ಹಾಗೂ ಅರ್ಜಿದಾರರಿಗೆ ಮಾನಸಿಕವಾಗಲಿ ಅಥವಾ ದೈಹಿಕವಾಗಲಿ ಯಾವುದೇ ರೀತಿಯಲ್ಲೂ ತೊಂದರೆಯಾಗಬಾರದೆಂದು ಎದುರುದಾರರಿಗೆ ಅಂತಿಮ ತಿಳುವಳಿಕೆ ಪತ್ರವನ್ನು ಸಹ ನೀಡಲಾಗಿರುತ್ತದೆ. ನೆಕ್ಸ್ಟ್ ಮಿಲಾಡ್. ಆದರೆ ಎದುರುದಾರರು ಮತ್ತೊಮ್ಮೆ ಈ ಕಚೇರಿಗೆ ಮನವಿಯನ್ನು ಸಲ್ಲಿಸಿ ಅರ್ಜಿದಾರರು ತನ್ನ ಭಾಗಾಂಶಕ್ಕೆ ನೀಡಿರುವ ಸ್ವತ್ತು ವಾಸ ಮಾಡಲು ಯೋಗ್ಯವಾಗಿರುವುದಿಲ್ಲ, that is not possible to remove along with the children's fellowship. ಹಾಗೂ ನನ್ನ ಸ್ಥಾನದ ಮನೆ ಕೊಠಡಿ ಭದ್ರತೆಗಾಗಿ ಬಾಗಿಲು ಮತ್ತು ಇತರ ಯಾವುದೇ ವ್ಯವಸ್ಥೆಯೂ ಇರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಸೂಕ್ತ ವ್ಯವಸ್ಥೆಯನ್ನು ಒದಗಿಸಿಕೊಡುವವರೆಗೂ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತಿನಲ್ಲಿ ವಾಸ ಮಾಡಲು ಹಾಗೂ ಹೆಚ್ಚಿನ ಕಾಲಾವಕಾಶವನ್ನು ಕೋರಿರುತ್ತಾರೆ. ಮುಂದುವರಿದು ಅರ್ಜಿದಾರರು ಎದುರುದಾರರಿಂದ ಮಾನಸಿಕವಾಗಿ ತೊಂದರೆಯಾಗುತ್ತಿದ್ದು ಸೋ ಕೊನೆ ಕಾಲದ ನೆಮ್ಮದಿಯಿಂದ ಸೋ. This is the reason, Your Lordship. Actually, I have been
accepted that's location.
No, I have
thereafter you cannot say I am not acceptable.
No, that should.
And functus officio officer cannot pass this order.
No, in fact, my lord, that should have been challenged by the respondent number 2, Your Lordship.
Yes.
In the event that it is not correct, my lord.
She cannot go and file an application like that.
No.
Once she was acceptable to this particular extent.
The fact remains, my lord, she is the daughter-in-law. She is staying with 2 children, Your Lordship. And kindly see the photograph which I have now produced, Your Lordship, even now, my lord. Kindly see, notwithstanding the order passed by the assistant commissioner, my lord, kindly see page annexure R2, my lord. In second para, the fourth para of my objections, my lord, kindly see. That clarifies everything, Your Lordship.
Annexure R2 is what?
R2 is an house, my lord, which is still vacant, my lord, complete house, Your Lordship, 45, 38.
Which house is this?
The R2 where we were residing, Your Lordship, where my mother-in-law was residing.
Where is the house that you have got now?
No, my lord, my house, my lord, where I am residing, my lord. Annexure R4, Your Lordship.
Yes.
Annexure R4 is the house, my lord, where I am residing, Your Lordship.
Yes. What is wrong with this?
Kindly see para 4 of my objections, para 4. Para 4. When this respondent was thrown out of the house, after we were living together, Your Lordship, in an house, my lord. After my husband died, Your Lordship, I was thrown out, as stated above, went on strike in front of the house itself, which had appeared in the newspaper published in the Andolana, of which is produced as Annexure R1. This respondent herewith produces the copy as per Annexure R2 of the entire house, including the portion which is said to have been given to this respondent in the absence of any partition deed. There is no partition deed, Your Lordship. No partition is also taken.
File a civil suit, Mr. Shivramu.
My lord,
Have you filed a suit for partition?
that is there, your lordship. I can.
There's no partition, you have to file a suit for partition.
That suit is also there, your lordship, filed by the daughter, my lord. One of the daughter has filed the suit.
Then wait for that outcome. Now you've been given a place which you have accepted.
Now, wow,
After
what I would
acceptance, you
like,
cannot be doing
no,
this.
what I would like to say, your lordship, this entire portion, annexure R2 is there, your lordship.
Once there is an order passed, if you agreed by it, you have to challenge it.
That's correct.
You cannot go and make an
But they did
application
not
before
do
that
so.
authority and make that
Even
change.
now, my lord,
After acceptance.
to have amicable this thing, my lord, annexure R2, my lord, which I have pointed out, your lordship, my lord, their photograph.
Amicable,
That
both
entire-
of you
Yes.
to go for mediation, whatever, we'll facilitate that.
Mediation it was
But
went
this
by
order cannot,
be
we'll
sent
stay
for
this order.
mediation. It would be sent for mediation.
mediation it went once.
ಎಲ್ಲಿ?
ಹೇಳಾಗಿದೆ ಹೋಗಿದೆ ಬಂದಿದೆ ಇಲ್ಲ ಇದೇ ಕೋರ್ಟಲ್ಲಿ ತಾವೇ ಆರ್ಡರ್ ಮಾಡಿದ್ರು
ಆಗಿದೆಯಾ?
ತಮ್ಮ ಆರ್ಡರ್ ಆಗಿದೆ
ಇಲ್ಲಿ ಬಂದಿತ್ತು.
ಇಲ್ಲ ಮೈಸೂರಲ್ಲೇ
ಮೈಸೂರು.
ಮೈಸೂರಲ್ಲಿ ಇಟ್ ಇಸ್ your own order my lord.
Failed. Let us come back as failed.
The lordship has passed this order. Yes. Now she's staying in her daughter's house, my lord. She's not been allowed to there. That is my grievance. She's not been allowed. She's 75 years. Nobody's scared to take her.
We'll set aside this order, Mr. Shivramu. If you agreed by it, you challenge it.
Lord, even
The order cannot sustain.
Even now, my lord, the kindly see section 16 of the Act, your lordship.
There is an order passed
That's
already. Subsequently, he
That
could
we have
not
to
have
file an
passed
appeal
that
before the deputy commissioner. That is one aspect. The present order is also, my lord. Present order, which is said to have been modified, my lord, by the
order. That is what we'll set aside.
That also, my lord, that has to be. They have to
Restore the earlier order.
Yes.
Because that is the order which had been passed. We'll set aside the subsequent order. He could have at the most given you time, not like this.
In fair, the appeal, my lord, says,
Petitioner.
senior citizen or a parent, as the case may be, agreed by an order of the tribunal may within 60 days from the date of the order prefer an appeal to the appellate tribunal. My lord. That's the
Petitioner is before this court seeking for the following reliefs. The petitioner
Lordship, I make
had filed an application under section 22 of the Senior Citizens So and So Act. After consideration, notice having been issued, and after consideration of the said matter, on the ground that the senior citizen was facing harassment at the hands of respondent number 2, the daughter-in-law, the assistant commissioner had directed that the portion of the property which had been identified to be made available to the respondent number 2, and that the respondent number 2 would shift to the place identified to be handed over to respondent number 2 and dispose the said matter on 27/11/2023. Subsequently, the respondent number 2 is stated to have approached the second respondent with an application stating that the house which had been identified for the respondent number 2 to shift to was not suitable for our residence. And it is in that background that the order dated 27/11/24 was modified by 23 was modified by the Assistant Commissioner on 27/5/24. The submission of Sri Gurudat, BS Learned Counsel for the petitioner, is that once the order had been passed by the Assistant Commissioner on 27/11/23, he was rendered functus officio and no application could have been considered, no application filed by second respondent could have been considered. If at all, the respondent number 2 had been, was agreed by same, respondent number 2 ought to have challenged the same by filing necessary appeal. Shri S.C. Shivramu, Learned Counsel for respondent number 2, would submit that respondent number 2 was constrained to approach the Assistant Commissioner on the ground that the said premises was not habitable and did not satisfy the requirements of respondent number 2 and her children. And furthermore, that since there was no partition which has occurred between the parties, this particular property could not have been given to the respondent number 2
Because there was no basic facilities, Your Lordship, to
without such. Everything is there. We are not observing that here. Without such partition being effected. Heard, Shri Gurudat B.S., Learned Counsel for the petitioner, Shri S.C. Shivram, Learned Counsel for respondent number 2. There is merit in the submission of the Learned Counsel for the petitioner in that once an order was passed by the Assistant Commissioner on 27/11/23, the Assistant Commissioner had been rendered functus officio, the matter having been disposed. If at all anyone was aggrieved by said order, if at all the senior citizen was aggrieved by said order, an appeal under section 16 was available. If at all respondent number 2 was aggrieved by said order, the same would have to be challenged by way of a writ petition. There is no scope for respondent number 2 to have approached the Assistant Commissioner by submitting an application which would amount to a review, and for the Assistant Commissioner to have passed the order dated 27/5/24, which would amount to a review of the earlier order which had been passed. In that view of the matter, the order dated 27/5/24 at Annexure G is not sustainable. Insofar as the contention of Shri S.C. Shivram, Learned Counsel for respondent number 2, that without a partition being effected, this particular property could not have been given to the respondent number 2. It is for respondent number 2 to have filed a suit for partition if so advised. Not having sought for partition or filed a suit for partition, respondent number 2 cannot be heard to contend that without partition a particular property cannot be given to respondent number 2, when an order to that effect had already been passed by the Assistant Commissioner in the presence of respondent number 2 and after hearing the respondent number 2. In that view of the matter, this court passes the following order. Writ petition is allowed. The order dated 27/5/24 passed by the first respondent at Annexure G in so and so is set aside. Liberty is reserved to respondent number 2 to challenge the order dated 27/11/23 at Annexure B if so advised.
Delay, if any, that could be the time spent in this court.
The respondent number 2, you have not come before this court, they have come. How will you be entitled as respondent?
That's correct. Your Lordship put.
It's a writ petition, so you can do that.
Public.
Serial number 29. Chandan, yes.
For the petitioner, means.
On last date of occasion, I submitted that I'll file my objection. I've yet to receive the affidavit, Lordship, because
You are yet to receive the affidavit. So you are appearing in a few matters. Mr. S.H. Prashant,
My lords, R3, my lords.
you have filed your objections?
No, my lords, I need 2 days.
So you are not filed. Who else is appearing?
in fact, MD just transferred, Lordship.
29.1, 2 and 3 are complete, my lords. And
29.4 we have to-
29.4 have to be.
1, 2 and 3 pleadings are complete.
Completed.
29 and 29.4 pleadings
we
are
have
to be completed. When will you file it?
Lordship, I have already submitted, Lordship. MD has recently taken charge.
Is
Yet to
there
receive.
if you have filed your pleadings in the other 3, is there separate pleadings required in this?
Actually, I have to file one table, Lordship, distinguishing the 117 batches of NSQ drugs. The entire crux of the matter is there are 117 NSQ batches of the medicine, Lordship, which have been challenged by the petitioner before the Central Drug Laboratory, Lordship, and he has submitted 8.
Okay, when will you file your objections?
A week, Lordship.
29.3 IA 1 of 24 is allowed. Learned counsel for respondent in 29 and 29.4 seek for and are granted 10 days time frame to file their respective statement of objection. Objections, if any, by 19th August, failing which will be taken as not filed, matter proceeded with, relist on 25th August.
This month.
Interim order earlier granted is extended till next date of hearing.
Deeply obliged.
Serial number 30. Manu Kulkarni.
Time. The daughter, my lords, challenging the order granted under the senior
Mr.
citizens.
Mutana?
Is there.
Yes. Good.
My lord, last occasion, your lordship has said that at the time of executing the gift deed, her age was 52. It was not, it was by mistake only. She was 64 at the time of executing this gift deed.
Senior citizen matter.
I don't know. Please documents this.
Yes.
In terms of a few key dates, my lords.
Where is the document?
The gift deed, the lordship has in the last occasion has remarked.
Gift deed, my lords, is at page.
She was 52 years.
36.
She was 64 years. I produced the document, my lord.
I'm not disputing that, my lords, that she was a senior.
Only date of birth
Argued that she was not a.
No, I didn't, my lords. In fact, your lordship
Date of birth,
noticed
my
it.
lord.
I didn't want to say anything without
You
cross-checking.
said that at that time.
Lords, I didn't want to say without cross-checking once more.
Then this leads to a presumption that you have got it drafted.
Lords, there are, lords, I have, your lordship's judgment
When
also I have seen.
such a
Petitioner's
Lords,
date of birth was 41. She was 41 years.
let
Mother
my
54.
learned friend allow me, my lords. There are two other gift deeds on the same date in favor of two of my sisters. Those also contain the same age.
Yes.
There are two others, my lords. On the same date, they
So all the
contain.
daughters got it done. Collusion. We won't go to next word. Yes, really.
Lords, my respectful submission is the mother has been staying with me from about 2001 onwards until 2022 November in the house at Vishweshwarapura. My father expires in the year 2021. Thereafter, my lords, there are some, my version is thereafter there are some discussions about doing a final partition of joint family properties. Thereafter, in November 2022, my mother moves out. These gift deeds are done in 2012. After she moves out to one of my sister's house, in 2023 December, a petition comes to be filed saying I am not maintaining her. Whereas all her life practically, I am estranged from my husband. So therefore, after marriage, I've been residing with my parents in the same house. Therefore, practically, I am the only child who has been residing with the mother. It is their own pleading in the petition that in 2006, my brother moved out of the property. In those circumstances, my lords, in 2023, on 12th of December, a petition comes to be filed. Interestingly, my lords, on 18th of December 2023, 6 days after filing the petition, she executes another gift deed in favor of her son, which she has not disclosed before either the assistant commissioner or before this honorable court. After filing this petition, a gift deed for the Vishweshwarapura property, about 6,000 square feet of property, where about 3,500 square feet, her undivided, her entire share, and 50% share in about another 3,000 square feet. In those circumstances, my lords, my respectful submission is this petition is really an inspired petition at the behest of the son and the other daughters, because parties are at loggerheads in respect of partition. And my lord, she is a director in a company. She has been filing annual returns. She signs those annual returns in English. She has filed these pleadings in English. Therefore, she is not illiterate. She is not from a rural background. There is no clause. I understand, my lords, that clause is also not necessary, but there is no provision. And my lords, they made a submission after I pointed out that the property is in 3 floors, ground, first and second, that they want to stay in my property. Lords, what they have missed seeing is, Lord, she is now 78 years old. She has had a heart ailment. The petition narrates the fact that she is suffering from severe knee pain. And my lords, their case is she wants to live on 2nd floor of a property which does not have a lift. The ground floor of the property is occupied by a tenant. She does not say, I want to stay on the ground floor. She is currently staying on 1st floor. And now the version is she wants to stay on 2nd floor when she is 78 years old, suffering from severe knee pain. This itself, my lords, shows that these claims that maintenance is not being provided are hollow. Be that as it may, my lords, I have also filed an affidavit disclosing that if the question is, my lords, irrespective of what other daughters and son is doing, whether I am willing to provide maintenance, I have put it on affidavit. Lords, I have put 4 options. I have said, let her come and stay with me in Vishweshwarapura, like it has been from 1995 since the house was purchased. I have said, if you want to live separately, I'd rather organize a house close to Vishweshwarapura. Over and above that, I will pay 30,000 in cash, over and above organizing a house. I have said, in the building where my mother is currently residing, ground floor is occupied by a tenant let out by one of my sisters. I have said I will pay.
It has been gifted to your sister.
Gifted to my sister. I have said I will pay rent to my sister. Over and above that, I'll pay 30,000 in cash to my mother so that her day-to-day needs are taken care of. And I'll pay rent to my sister. I have made all these options on affidavit. And my lords, their version is they want to stay in the second floor of the house.
There is no lift.
There is no lift. And my lords, in the AC court, there is not a whisper. She does not say she needs maintenance. I have produced papers to show in 2019 when she had a heart ailment, it was my insurance card that was utilized. I was with my mother. Naturally, I was staying with her, my lords. I am estranged from my husband. I have only one daughter who is abroad. So mother and daughter have been staying together. There is no denial of that fact. The dispute crops up only in or about November 2022 after my father has passed away, because my lords, I start asking for partition. In 2024, I have filed a partition suit.
So that is pending.
Please, my lords, that is pending.
Where is the plaint?
Lords, plaint I'll produce, my lords. I have produced a copy of the interim order.
Plaint we need.
Lords, plaint copy I'll file, my lords.
You have a copy?
Lords, if your lordship will kindly pass it to my lords, I'll file it at 2.
Pass over.
Serial number 31.
For petitioner.
Covered.
The petitioner is carrying on the business of
Where is the judgment of the coordinate bench in that brigade?
valid license is Annexure G. Additional document produced.
The petitioner is before this court seeking for the following reliefs. The lists in the present matter has been considered by detailed judgment dated 23rd November 2018 in WP number 48795-48797 of 2018 and other connected matters. Hence, the above matter is disposed of in the as per the direction issued by the coordinate bench of this court at para 15 and 16 of the said judgment.
Serial number 32. Sharath M. Connected matter.
And 32.1 are
Yes.
appear for both 32 and 32.1.
Is which one has to be taken, 32 or 32.1?
32, your lordship may take it in any order, 30, because both
Yeah, for
arise
the
from the
petition.
same impugned order of the claims.
Okay, for the petitioner, please.
So we'll start with 32.
Please.
Matter is this. 32.
Yes.
490.
Because the petition has been filed, my lords, challenging the order passed by the Karnataka Medical Council, whereby, my lords, without assigning reasons, arbitrarily and without application of mind, my lords, the Medical Council has decided to proceed with disciplinary proceedings as against the petitioner herein, my lords, who is one of the respondents in the complaint in the proceedings before the Karnataka Medical Council, my lords. The impugned order, my lords, is at Annexure A, my lords, at page number 18, my lords. 18. It's KMC/63 EXP doc TOCT 2024. My lords, the petitioner herein is arrayed as respondent number 3 in the proceedings.
Yes.
My lords, at page number 19, the operative portion of the order commences, my lords. 19.
Number 19.
19. 19. Orders on admission.
Yes.
No, first, my lords, I just want to traverse the impugned order and thereafter, my lords, go through the law on the point as well as my limited role and why the proceedings are not maintainable as against me, my lords. Orders on admission. My lords, the Karnataka Medical Council received a complaint on 9th July 2024 by Mr. Vikas M. Dev against the respondent doctor. Mr. Vikas M. Dev is respondent number 2 here in my lords. The council received the complaint from Annapurneshwari police station on 2nd July 2024 alleging medical negligence from respondent doctors which led to the death of the complainant's father. The complainant states that his father, MC Mahadev, was diagnosed with hiatus hernia on 8th January 2024 and was undergoing argon plasma coagulation treatment for watermelon stomach. During the treatment period, he was further diagnosed with kidney disease and was placed on dialysis thrice weekly with a HD catheter inserted at GM Hospital under the care of Dr. Veerabhadra Gupta, who is the petitioner herein. Subsequently, due to the infection, the patient was advised catheter removal and replacement with a perma catheter, for which he was admitted on 4th April 2024 under Dr. Sumant Raj K, who is respondent number 1 before the proceedings, who is not a party in this writ petition, my lords. Thereafter, at paragraph number 3, the complainant contends that during the procedure, the patient was transferred to the ICU where the surgery was performed by Dr. Manjunath without appropriate consent, which had been granted solely to respondent number 1. Following the procedure, dialysis attempts failed due to the absence of blood backflow allegedly caused by improper catheter placement. The patient was then transferred to Fortis Banerghatta Hospital and treated by Dr. Nagbhushan, who reportedly performed a corrective procedure at 4:30 p.m. on 5th April 2024. At 5:32, respondent number 5 informed the complainant, respondent number 5 therein is Fortis Hospital Banerghatta, informed the complainant of a cardiac arrest, after which the patient was revived but had suffered hypoxic brain injury leading to his death on 15th April 2024. The complainant further alleges medical negligence, procedural lapses including improper consent, catheter misplacement resulting in left-sided hemothorax and lung damage, and lack of supervision. Because the gist of the complainant's case is that his father was admitted to the hospital. He was supposed to undergo catheter placement. There's incorrectly placed catheter initially. Thereafter, my lords, he has gone to a different hospital where he's undergone surgery again, because of which there's a death which has happened in the...
Sumant Raj is in which hospital?
He's at GM Hospital, my lords. GM Hospital, who's
Manjunath is at also GM Hospital.
GM Hospital.
Same hospital.
Same hospital, my lords.
After, according to the complaint, after 3 blotch-ups, they shifted to Fortis.
No, there's more to it, my lords. And
what you read?
Please. Because the complaint, my lords, differs from what the medical council has actually held. Because at point number 5, my lords, of the impugned order, the council issues notice on 9 July 2024 to all parties directed the respondent doctors to furnish an explanation. Because there is no dispute in respect of this. The notice has been issued, the show cause notice which has been issued to all respondent doctors, my lords, and I have also furnished my response, yes, which is seen in paragraph number 6 of the impugned order, whereby the medical council records what contentions I have taken. Response number 2, 3, 4, and 6 submitted a joint reply on 30th July, wherein they denied the allegations raised by the complainant and stated that proper informed consent was obtained prior to the procedure. They submitted the failure of the perma catheter placement in the right internal jugular vein and the subsequent plan to displace the dialysis catheter in the left jugular vein were duly explained to the patient. It is further submitted that as per standard ICU or CCU practice, dialysis catheter placement in the jugular vein is routinely performed by ICU registrars and not by vascular surgeons. This is the contention which has been taken. And it was also said that there was no pneumothorax, bleeding or lung damage within 24 hours following the procedure at GM Hospital, and they had no knowledge or recollection of advising the patient to seek treatment at Fortis Hospital, Bangalore. This is the contention which has been recorded by the medical council. Then thereafter, other doctors have also filed their respective responses, my lords, which I'm not traversing because they're not parties to the present petition. Now, my lords, at paragraph number 10 is where the impugned order, the portion where I am impugned.
Let us read the entire thing.
Please. Respondent number 1, who's Dr. Sumant Raj, my lords, in his separate reply stated that after obtaining valid consent, he attempted perma catheter insertion into the right internal jugular vein, but was unsuccessful due to thrombosis. The respondent number 1 denied attempting catheter insertion into the left internal jugular vein as it was not within the routine scope and therefore referred the patient back to nephrologist with full disclosure of the failed procedure. The respondent number 5 and 7, Fortis Hospital, submitted that they successfully inserted a permanent perma catheter into the left internal jugular vein, and while removing the previously placed temporary catheter, the patient experienced a sudden drop in blood pressure and oxygen saturation. The patient was diagnosed with hemopneumothorax, for which intercostal drainage (ICD) was placed, and the bleeding was controlled by emergency placement of a covered stent. They further submitted that despite all the efforts, the patient suffered a cardiac arrest, which was revived, but he sustained hypoxic brain injury and hemodynamic instability, ultimately leading to his death on 15th April 2024. Respondent numbers 5 and 7 deny any negligence, deficiency in service, or breach of medical ethics in the treatment rendered and assert that all care provided was in accordance with established medical standards. More or less, all parties have filed their respective responses. In paragraph number 10, my lords, the council, lords,
This is only against GM Hospital or Fortis also?
it is against Fortis Hospital also, my lords. Respondents number 6 and 7 are the doctor and the hospital, Fortis Hospital.
Not before us.
No, I have just one submission.
Is it a complaint against both GM and Fortis?
Yes.
It is a complaint against GM and Fortis, but I understand it is settled law. Your lordships are aware that KMC proceedings will not lie against hospitals. So therefore, I have no
Not done
difficulty
that. We can't take
We are
it up
not
if it is
going in that
Fortis.
issue as of now.
Post before a bench of which SGRJ is not a party.
I just wanted to clarify that insofar as 6 and 7 are concerned, I can withdraw my proceedings before the KMC because
Don't withdraw anything just because we are
no,
disabled.
not because of your lordship's insistence.
My lord,
Settled law, I understand.
even if it is so, it's not proper for us to take it up.
I understand. But
Once you have made a complaint against that.
6 and 7 I can withdraw before the KMC because anyway KMC will not have any jurisdiction so far as 6 and 7 is concerned. I understand the lordships have expressed a reservation.
Disabled for that.
I understand. Then could your lordships assign a date because by
And assign a date, it will have to go before the chief. Special orders have to happen. Then it will be placed before whichever judge.
So there's an interim order insofar as in this petition.
Order earlier granted is extended till next.
Because what happened is the interim order is confirmed till final hearing and disposal of the petition.
Yes, yes.
The interim order is there till further orders.
Yes,
There are
please.
interim orders in
Why do
both.
you want extension?
On the last date, there's an order which is extended till the next date of hearing. That is why the submission.
Interim order is extended till further orders.
Serial number 33. Srinivas, please.
Petitioner, my lord, applies for a license to build a petrol fuel station, my lord. My lord, that has also been granted by BPCL. And later, my lord, kindly see, my lord, there was an application called by page 25 from BPCL, my lord. There's an application, my lord. 29, there's
Mandamus to complete the construction.
my lord, what has happened, my lord?
Who is to construct?
The BPCL, my lord. Then, my lord, BPCL on the last date of hearing, my lord. What they submitted, my lord, that PESO, my lord, has not given them license. Then, my lord, this court granted me permission to allow, to implead PESO as the additional respondent.
They have to give the license.
Yes, my lord.
For the respondent number 2 and 3, my lords. Insofar as the prayer which has been sought, my lord, the respondent number 2 and 3 has not at all withdrawn the consent for approval for construction.
Now, what do you need from them?
NOC from them.
You are HPCL, you have to construct.
NOC from PESO.
NOC.
NOC from PESO.
Because what is the instructions is that, my lord, there is an OS suit which has been pending before the land. So we had issued to the respondent number 1 for a clarification, my lord. Still today there is no clarification as given by the respondent number 1 to the respondent number 2 and 3.
I cannot mention, my lord. The BPCL has to write a letter to them to
Personally, we
clarify.
have met, we have clarified, but they asked us to get
Personally, Allah, but writing.
writing.
Have you given any clarification in writing?
Officers have personally visited PESO office and explained the facts, my lord. There were two cases.
Mr. Srinivas will come and visit HPCL office and give the clarification in verbally. You will accept.
I will come with the clarification, my lord. Kindly have it next
Whatever they want the clarification, you give the clarification. And then go ahead with this. Counsel for respondent number 2 and 3.
My lord, the problem is they're insisting for, there is an interim order in that OS. They're insisting that an interim order be
No,
vacated.
there is no interim order.
So
as
that
such.
is not in my hands, that petitioner has to do.
No, there is no interim order as such. There is no interim order. I will clarify, my lord. If
We
there
don't
is-
know what is there. So
My
both
lord,
of
if
you
there
have
is an
to
interim order.
The
reply to
point,
them.
my lords, we have issued them because, my lord, the landowners have the dispute amongst their own family members, my lords. So
You have
they,
issued the letter to both of them or
oh
only?
no, my
only
lord,
for
because
them?
I only issue it to the respondent number 1, my lord, since there is a
If you
complaint.
want to reply, you also reply.
Yes.
So there's a complaint, my lords, and pursuant to that, my lords, we send him the clarification. Till today, my lords, there is no written clarification as sought, my lords. That's the.
The plaintiff in that OS suit has made a
You
complaint.
give a copy to Mr. Srinivas also. Let him
We'll
also
only clarify,
reply.
my lord, if at all.
Land Council for respond number 2 and 3 submit that there are certain clarification which had been sought for by them from respond number 1, which clarification has not been furnished in writing, and as such, no action could be taken by respond number 2 and 3.
Was on 28th of March 2025, my lord, we have issued it to the.
Certain clarification had been sought for under cover of letter dated 28 March 2025.
Please, my lord. And
Land
also, my
Council
lords,
for respond number 2 and 3 is.
February 2025 also, my lords.
Land Council for respond number 2 and 3 is also directed to furnish a copy of the said letter to the petitioner. Both the petitioner and respond number 1 are at liberty to reply to the same, which they submit that they will reply within period of 15 days from today. If such reply is furnished, Land Council for respond number 2 and 3 submit that necessary the orders
We will
are
consider it in accordance with law, my lords.
the same would be dealt with in accordance with law within 30 days
Please.
from such receipt. Relist on 29th September.
Okay. Serial number 34 dismissed, 35. BM Siddhappa.
Waiting
The
for
Siddhappa.
respondents, madam.
Ilva. Yes, Mr. Siddhappa.
Lord, this is a petition by the petitioner for seeking writ of mandamus to give approval to the committee, my lord, which was submitted by me on 9/5/2025 to the respondent number 1, my lord. And either two, my lord, he has not taken any decision even after recommendation made by the respondent
You
number
are
2.
appearing for both of them. You wrote a letter to
My
yourself.
lord, I have sought information from the board, my lord. Till now, I have not obtained
One year has been lapsed.
information, my lord.
How
My lord, they have sent only the representation made by the committee, my lord. They
Madam,
have to send a detailed report to the board for the formation of managing committee.
you are
my lord.
not considering their request because respond number 1 wrote a letter to respond number 2.
Yes, my lord.
Correct? You are appearing for both respond number 1.
Yes, my lord.
So left hand and right hand.
But we have not
You
received the
can-
detailed information, detailed report from the officer, my lord.
You want us to call respond number 2 to court? We'll ask them to be present. If that is the, can't keep these things pending like this.
1 year has been lapsed, my lord.
Lord
For
Council
approval.
for respond number 1 and 2 submits that proper report from respond number 2 has not been received. The matter being pending for last 1 year, the same council appearing for both respond number 1 and 2. It was for respond number 1 and 2 to sort out the matter among themselves. Since apparently the same has not been done, respond number 2 is directed to be personally present before this court by on the next date of hearing. Relist on 19th at 2:30 p.m.
Serial number 36, Nishant AV.
Kindly see the order dated 29/6/2026.
29/6/26.
Please, ma'am.
Yes. 47.77, 44.7. Yes. Who is
The
appearing?
Kindly have it next week.
There's so many matters listed that you will have to be ready with this. There's a simple thing. Get this, we'll pass it over, get this clarification. Because this will have to be set aside. Your portal is showing one amount and your tender document is showing another amount. It may be key error 47.77, 44.77. See the order date 29/6/26. Simple things, close it if you need. Pass over.
37, Navin Jaya, connected matter.
For the petitioner, appear in.
Devraj, you are appearing for 3.
Lord, I appear in 37.1. Lord, the matter pertaining to my Lord, 17A permission.
You already have interim order in your favor. What about the others? You want to, Shaman, you want to file anything?
I'll have to file objections. But Lord, Lokayukta also has to file their objections.
My lords, respondent in serial number 37.
Sharbati. Who is respondent number 2 in 37.1, Satish? Respondent number 2 in 37.1, yaar.
Lord, Lokayukta, my Lord.
Lokayukta.
Yes, ma'am.
VP Patil, 37.1, Shri Venkatesh Sharbati is directed to accept notice for respondent number 2.
Lord, he is also in the.
He has not filed his MA. At least Mr. Sharbati has appeared in another matter.
Yes, yes, my Lord. In the connected matter, my Lord.
Sharbati is directed to accept notice for respondent number 2. Registry is direct print his name as such and delete the name of Shri VP Patil as that appearing for respondent. Anil Kumar Jain.
My lords, respondent number 1, my lords, in 37.1.
You have filed your objections?
My lords, 2 weeks time may be granted, my lords.
The respective counsels for the respondent are granted 2 weeks time to file the respective statement of objection. Objections, if any, by 27th August, failing which it will be taken as not filed, matter proceeded with. Relist on 3rd September, interim order earlier granted is extended till next date.
38, Abhishek MB.
Petitioner made representation seeking for police protection, my lord. Lord, this court in the writ petition, my lord, which I produced at Annexure D, my lord.
Page?
Annexure 28, my lord.
28.
28. Some residents and strangers lodged a complaint, my lord, against the petitioner. They purchased the property illegally. This honorable court, the deputy commissioner initiated the proceedings for resumption of the land, my lord. The resumption order has been passed, against which I approached this honorable court.
Is there any court which has directed police protection to be granted to you?
No court. Only this honorable court in earlier writ petition, he recognized the petitioner's rights over the scheduled property, my lord. Some strangers and unknown persons, my lord, they are not allowed the petitioner to enter upon his land, which is decided by this honorable court, my lord.
Have you filed any complaint?
Yes, my lord. I have produced Annexure E and F, my lord, to the respondents.
Page number really new, annexure ಹೇಳಿದ್ರೆ ಆಗಲ್ಲ. You have annexure
Annexure
there.
40, page number 40, my lord. As per this honorable court order, the petitioners have been declared as
ಅದ್ಭಸ್ತು ಮಾಡಲು ಯಾವುದು ತೊಂದರೆ ಅಥವಾ ಅಡಚಣೆ ಇಲ್ಲ ಅಷ್ಟೇ.
And also I made a representation to SP, my lord. Annexure F, my lord.
How can you ask for police help? You are seeking for adbast. Adbast alli ಅಡಚಣೆ ಇಲ್ಲ. So you'll have to.
They are not supposed to obstruct my right over the property, my lord. They are not even allowed to trespass into our property. They disturb our peaceful possession, my
If
lord.
somebody
Unlawful
has
interference.
trespassed, you can't go to the police. You have to go to the civil court.
My lord, this honorable court has decided the entire issue about the legal title of the
Where
property,
is
my
that?
lord.
Where is that?
But page number 32, my lord. Para 8, this honorable court observed that nearly 13 years, a second petitioner purchased the property. Residents of the area lodged the complaint that the petitioner had acquired the property
What are
illegally.
you reading, Mr. Counsel? Which para are you reading?
Lord,
Page number?
Page number 32, my lord.
Ah.
Para 8.
Yes.
in the year 2020, nearly after 30 years, the second petitioner purchased the property. The residents of the area lodged the complaint that the petitioner acquired the property illegally. On the basis of the complaint, Tahsildar issued the notices to the petitioners, calling upon them to give their version. The petitioner submitted their response stating they had purchased the property after a period of non-alienation had expired. The Khata had also been registered in their name by the municipal.
Yes.
The attempt made by the Tahsildar to question the alienation 36 years after the grant has been made was impermissible, my lord.
This was
Notwithstanding,
a proceeding where you had challenged the cancellation of proceedings initiated for cancellation of the grant.
yes, my lord.
And that is what the court said, not to cancel the grant, that proceedings cannot be.
That,
Now, if somebody
the
else is
property has been taken
interfering,
back, my lord.
if somebody is interfering with your possession, this order will not come to your rescue. Whoever those persons are, you will have to make them a party and file a suit. And you can't go to the
But they are
police.
strangers. They are strangers. In this
Find out
regard,
who
my
they are
lord,
and
there is a
file.
circular. It is issued by the DGP, my lord.
This order will not help you. If a third party is trying to interfere with your possession, you have to file a civil suit. Police cannot interfere in private disputes.
Some unknown persons.
Yes.
I don't know, my lord. In
Petitioner
the-
is before this court seeking for the following reliefs. The contention of the petitioner is that certain unknown persons
unknown.
are trying to interfere with the possession of the petitioner as regards the property purchased by the petitioner. And it is in that background
ಆಗಿ ಮತ್ತೆ ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ತಗೋಬೇಕು.
that a representation had been, ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ತಗೊಳ್ಬೇಕಾಗುತ್ತೆ. A representation been submitted by the petitioner on 10/2/26 and 12/2/26 for police help, police protection. The submission of learned counsel for the petitioner is that once earlier when certain others, certain residents had lodged a complaint with the Tahsildar had initiated proceedings for cancellation of the grant made in favor of the petitioner's vendor, which came to be set aside by this court on 9th April 25 in WP number 22971 of 2024. On that ground, he submits that the coordinate bench of this court, having held that the petitioner's purchase is valid and the cancellation of grant cannot be initiated, it is but required for the jurisdictional police to provide help to the petitioner and to protect his property. Having heard learned counsel for the petitioner, this court is of the considered opinion that the order dated 9th April 25 in WP number 22971 of 24 would not be applicable to the present facts, inasmuch as that was relating to proceedings initiated by Tahsildar to cancel the grant made in favor of the petitioner's vendor. The present issue raised by the petitioner is that certain unknown persons are seeking to interfere with the possession of the petitioner. If that be so, it is for the petitioner to initiate appropriate proceedings against those persons. The police cannot be roped into a matter which is a civil dispute as regards the possession or title of the property, reserving liberty to the petitioner to approach the appropriate forum seeking for appropriate remedies. The petition stands disposed.
Great.
39, Tejasvi KV, connected by.
For petitioners, my lords, I was filing a memo, Lord, 39.3. I am withdrawing, Lord.
39 point.
Please, my lords. I am the petitioner in that case. So that's a writ of mandamus that I have filed. It's become infectious, my lord.
39.14068. Petitioner is before this court seeking for the following leaves. A memo has been filed. The memo dated 5/8/26 signed by the counsel for the petitioner has been filed, which reads as under. Accepting said memo, petition is dismissed as withdrawn.
My lord, other
Raise time to
petitioner
39.2, my lord. I am the impleading applicant.
You are the-
Heading office objection raised on statement of objection, my lord.
Just 39.
Point 2.
Nothing to be done. 39.1. There's some office objection on your
Please, my lord,
rejoinder.
pray for weeks time, lords. I will.
39.2. SOB filed by respondent number 8.
I am the impleading applicant in response.
Impleading applicant?
Yes, ma'am. 39.2, Dilip Kumar A.
There is no impleading application which has been listed.
Put up agila. Maybe not put up.
You have filed the impleading application?
Yes, sir.
Idea? Have you served a copy? Have you
On
received
the
the
6
copy?
to 24, I filed up. On 6 to
Implemented, my lord.
application implemented, I filed an statement of objection regarding office objection is raised.
You're no longer impleading applicant, you are
Already
responding.
implied, respond number 8, my lord.
You are respond number 8 now.
Yes, ma'am.
Counsel for the petitioner in 39.1 seeks for and is granted 2 weeks' time to comply with the office objection raised on his rejoinder. 39 point, counsel for respond number 8 in 39.2 seeks for and is granted 2 weeks' time to comply with the office objection raised on his statement of objection. You want to file any rejoinder in that?
My lord, already filed, my lord.
Rejoinder is filed in 39.
Rejoinder is filed, my lord. 39.2.
Relist on 3rd September.
There is an interim order.
Interim order earlier granted is extended till next date of hearing.
Please.
Serial number 40. Pawan Chandra Shetty.
Yes, Mr. Shetty. Invest you are for respond number 5. Allowed,
Paper for respond number 5.
Sumant, you are for 2 to 4. Okay, Sumant Bharadwaj has appeared for 2 to 4. Delete Prashant VR as that appearing for respond number 2 to 4. Yes.
Lord,
Ready?
as simple as, my lord. Respond number 2, my lord, call for the tender notification. Out of that, my lord, your lordship may kindly straight away come to running page number 119, annexure F.
119.
Annexure F.
One line, if we say both of us have quoted same price,
Same
both of
price,
us are
yes,
L1 and I have been selected and my lord, he is therefore before this court. That is the single line argument, my lord.
Yes, ma'am. Your lordship may kindly see the, my lord, terms and condition of the
Single
tender.
line fact. Argument in a Bharat.
Fact.
Yes.
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 Please, my lord. Your lordship may kindly peruse the, my lord, name of the 3 bidders. Munisomappa Gopal, who is the respond number 6, my lord. Serial number 1. Then, my lord, Suresh Gowda is the petitioner. Srinivas, who has been withdrawn, my lord, he is not interested to the participation as per annexure G, running page number 123. Now, my lord, kindly come back to the, my lord, the terms and condition of the tender, my lord. That is running page number annexure B, running page number 44, my lord.
44. Yes.
3.2. ಅದರಲ್ಲಿ ಅ ಆ ಇ ಈ ಉ ಉ ಉ ಈ
Yes.
ಟೆಂಡರ್ದಾರರು ಒಂದೇ ಸಮಾನವಾಗಿ ದರ ಸ್ಲಾಶ್ ಸೇವಾ ವೆಚ್ಚವನ್ನು ನಮೂದಿಸಿದಲ್ಲಿ ಟೆಂಡರ್ ಸಮಿತಿ ಕೈಗೊಳ್ಳುವ ನಿರ್ಧಾರಗಳಿಗೆ ಟೆಂಡರ್ದಾರರು ಬದ್ಧರಾಗಿರಬೇಕು. ಅಂತ ಸಂದರ್ಭದಲ್ಲಿ ಟೆಂಡರ್ದಾರರಿಂದ ಒಪ್ಪಿಗೆ ಪಡೆದು ಅದರಂತೆ ಕ್ರಮವಿಡಲಾಗುವುದು. Here, my lord, tender has been confirmed in favor of the respond number 6 without consulting me and my lord, without taking the any consultation. Now, your lordship may kindly come to, my lord, running page number 124, annexure H.
What is this for?
Is providing the manpower. Manpower. ನಾನು ಅದಕ್ಕೆ ಹೇಳಿದ್ದೀನಿ, ನೀವು ಒಂದು ವರ್ಷ ತಗೊಳ್ಳಿ, ನನ್ಗೊಂದು ವರ್ಷ ಕೊಡಿ. ಹೆಂಗು ಇಂಟ್ರಿ ಮಾಡ್ರು ವೈಲೇಟ್ ಮಾಡಿದಿರಿ, ವರ್ಕ್ ಅನ್ನ ಕಂಟಿನ್ಯೂ ಆಗಿ ಮಾಡ್ತಾ ಇದ್ದೀರಿ. ಇಟ್ಸ್ ಓಪನ್ ಪ್ರಪೋಸಲ್ ಐ ಹ್ಯಾವ್ ಗಿವನ್, ಮೈ ಲಾರ್ಡ್.
Tender matter she appears.
ಅಲ್ಲ, in identical circumstance, this honorable, sorry.
Shaman, this is a problem which is coming up in all these manpower matters. In all the manpower matters, you either have 3% or 5%. Not more than 3, not less than 3. Not more than 5, not less than 5.
5.
Everybody quotes
Same
that
price.
3%, same amount is quoted. So many matters coming up. Both of them will quote 3% only, they won't quote 2.5. Because anyway, they are getting it free. You are only making them rich by giving them 3% because you are outsourcing. And when that petition comes for regularization, we will regularize. But this is bound to happen. This is inherent in this tender. And if you say, ಒಪ್ಪಿಗೆ ತಗೊಂಡು ಮಾಡ್ತೀವಿ ಅಂದ್ರೆ ಯಾರು ಒಪ್ತಾರೆ?
And in
Because
may I make further, sorry.
most probably in all this, we'll require the finance department to say something.
These clauses are inserted eventually. But in food tenders, what we end up doing is we'll have multiple bidders bidding the same amount, pick of lots.
But we'll have same council appearing for all.
Food tender, I stand in Pawan Chandri Shetty's shoes, my lord. In food tender, I'm there.
The n number of matters are coming up. But if the finance secretary were to give proper instructions to all these authorities regarding this. And this is Milk Federation.
Yes, my lord. KMF is a Dairy Circle, Bangalore, my lord. Now, my lord, in identical circumstance, at running.
Sumant is appealing.
100 may kindly be looked into.
100.
100.
100.
Yes.
ಸೂಚನೆ 1 ಮೇಲೆ
100.
ಮೈ ರೀಡ್ ಟೆಂಡರ್ದಾರರು ಒಂದೇ ಸಮವಾಗಿ ಸೇವಾ ವೆಚ್ಚ ನಮೂದಿಸಿದಲ್ಲಿ ಟೆಂಡರ್ ಸಮಿತಿಯು ಪ್ರತ್ಯಕ್ಷತೆಯಲ್ಲಿ ಟೆಂಡರ್ದಾರರು ನೀಡುವ ಉದ್ದೇಶಿತ ಯೋಜನೆಗೆ ಮಾನವ ಸಂಪನ್ಮೂಲ ನಿರ್ವಹಣೆ ಬಗೆಗಿನ ವ್ಯವಸ್ಥೆ, ಎಲ್ಲಾ ಪಾಳಿಗಳಲ್ಲಿ ಮಾನವ ಸಂಪನ್ಮೂಲವನ್ನು ಕಾಯ್ದೆಯನ್ವಯ ನಿರ್ವಹಿಸುವ ವಿಧಾನ, ಮಾನವ ಸಂಪನ್ಮೂಲ ಹಾಜರಾತಿ ಕುರಿತು ನಿರ್ವಹಣಾ ವಿಧಾನ, ಫೈನಾನ್ಷಿಯಲ್ ಕೇಪಬಿಲಿಟಿ, ಹಿಂದಿನ ಅನುಭವ, ಪ್ರಸ್ತುತ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಕಾರ್ಯಗಳು, PF, ESI, ಬೋನಸ್ ಬಗ್ಗೆ ಮಾಹಿತಿ ಹಾಗೂ ಇತರೆ ಸವಲತ್ತುಗಳನ್ನು ಕಾರ್ಮಿಕರಿಗೆ ನೀಡುವ ಬಗ್ಗೆ ಸಮಿತಿ ನೀಡುವ ಮಾಹಿತಿಗಳನ್ನು ಎದುರಿಸುತ್ತ ಸಮಿತಿಯು ಅವಲೋಕಿಸಿ ಕೈಗೊಳ್ಳುವ ನಿರ್ಧಾರಗಳಿಗೆ ಟೆಂಡರ್ದಾರರು ಬದ್ಧರಾಗಿರಬೇಕು. But the response number 5 was the tender.
Inna ಜಾಸ್ತಿ discretion ಬೇಕಾಗಿತ್ತಾ? You wanted a little more discretion?
No.
This is completely discretionary. You'll decide whatever on any of them.
This based on this only, the response number 5 was our tender for previous 2 terms, and we are quite satisfactory with his services. That's why we have even awarded the.
So why did you invite tender if we are satisfied with the services for the last 2 terms?
Previous also with 2 tender only we have awarded.
You're making it a joke. The entire farce.
As all the tenders have been reported the same amount, my lords.
That is what we are saying. It is bound to happen. Your tender is inherent that it has to be the same price. Because the moment a person quotes 2.95, he is out. So why would somebody be out? Everybody will give you that 3% only.
That is what the financial department makes, that they give financial department state.
Sorry, 2.95, 3.05.
The state financial department gives that this should be the margin within which if you doesn't give, you will be out of the tender. But it is the department, financial department which guides all the tendering authority to make tender conditions.
That is for food grain, that's a different matter.
Even for this also,
it's a different thing. Manpower is different. Food is between 5 to 15.
5 to 10.
5 to 10, 5 to 15. 5 to 10, 5 to 15 only, you can give 6, 7, 8, whoever gives whatever, it can't be less than 5, more than 10.
In finance department, for supply of manpower also, they quote that this, the salary part and everything should not exceed 3%, and if it exceeds more than 5%, you will be out of the tender. And these are the guidelines what they issue. Finance department is the one which issues the guidelines to call the tender within the particular area, and therefore they will do it.
Even 3 to 5 also is understandable. But when you give only one figure of 3,
yes,
it can't be understood. So everybody will quote only 3. And then if you have this kind of a clause at 100, it leaves every discretion.
Your lordship may kindly see condition.
Arbitrary.
Condition
Then, my lord, in identical circumstance, this honorable court, my lord, 1 ವರ್ಷ ಅಂತ ಕೊಟ್ಬಿಟ್ಟು annexure H, my lord, running page number 124. ನಾನು ಅದನ್ನ I have made my fair request with my learned senior friend Srinivas sir, saying that ನೀವು 1 ವರ್ಷ ತಗೊಳ್ಳಿ, ನಮಗೂ 1 ವರ್ಷ ಕೊಡಿ ಅಂತ. ಅವರು
parties came together Milord, Pawan knows very well all these things.
I don't know, sir. I'm a restaurant intender. I'm not more than any matter in 230 or anything.
We'll have to follow what the law is a tender matter. It's not
Yes,
a
Mela.
family matter, matrimonial
Yes,
matter
yes.
where you can arrive at something. Tender has to be
Yes,
clear.
yes,
for the
either
terms.
head or tail, that's all. My lord, in the identical circumstance, this honorable court, my lord, after a careful observation and made that, my lord, 1 year, now, though there is an interim order, my lord, work is continue. Though there is an interim
That
order.
was probably done with the good intention of closing that matter, which
Yes,
is
yes, I agree,
unlikely
my
to
lord. I agree.
close like
Yes,
this.
yes. And it
The
should
tender
not
is
be
bad.
opportunity to tomorrow others, my
The
lord.
inquiry into this as to why you came up with this kind of issue and
It's a high
continue
time, my lord.
that tender, the earlier contractor, because you are happy with this service.
Happy.
This-
Services was satisfactory.
Satisfactory. Or you are satisfied with the service.
Service is satisfied.
Till Monday.
Monday, file the affidavit of your second respondent. We'll also ask for first respondent to file an affidavit because too many matters are coming of this and everything is this, the whole thing is a farce. And if we quash it again, public money is wasted.
And my lord, though there is,
Again, you will issue the same tender.
it's the same, my lord. Every year, same.
Last
Same
week or
terms
something,
and conditions.
3 times the tender with the same.
Same. In many of
Only
cases, we have.
that one person who was succeeding in L1 left that saying there's no point doing this work.
Then, my lord, one submission, my lord. Though there is an interim order is operating, my lord, they are given work order to the, my lord.
No, work order, they have not given any separate work order pursuant to this
You
tender,
won't
my
get
lord.
paid for whatever you've done.
Milord,
You won't get paid for whatever you've done.
Milord, work
Because
order
we'll
is
be-
not issued. Milord, work order issued.
The
Work order issued.
rate exceptional letters was issued on 21/2/2026. Work order was issued on 1/4/26.
That has been
The
stated.
interim order of stay of not to give work order was passed on 17/4/26.
That is, my lord, after the concern.
17/4/26. When did you issue the work order?
1/4/26.
So you backdated it also.
No, before they filed a writ petition, work order was issued. We are not in
Lord,
defense of any interim
during the time of granting the interim order, my lord,
Yeah,
it was
Monday,
duly served, my lord. Expert order not given, my lord. Expert order not given, my lord. And after the service of the papers to the my learned friend,
Any confidence. It smells very fishy. We'll direct an inquiry. If you have done any backdated or anything, you'll be in serious trouble. Tell your officers.
By Monday, I will get.
This whole thing is, again, repeating it, it's farce. Petitioner and respond number 6, having participated in the tender issued by the third respondent.
Hello,
where
5 and
both-
6.
where fifth, where 5 is withdrawn, alva?
yes, withdrawn. That is, my lord, page number.
6 withdrawn.
6 withdrawn.
6 withdrawn.
No.
I am 5.
Venu Enterprises withdrawn, sir. You are not for 5, you are for 6, Allah.
Venu Enterprises is 6.
5 has withdrawn. Sorry,
Petition
6 has
number-
withdrawn.
So has withdrawn.
Petitioner and respond number 5 having participated in the tender issued by respond number 3. Both of them were declared L1. In terms of the clause, the tender clause in relation thereto is 3.2 Wu, page 44, which is reproduced here under for easy reference. In terms of clause R of 3.2, it is required that the bid submitted ought not to be less or more than 2%. Clause 3.2R is reproduced here under for easy reference. In terms of clause U of, subclause U of 3.2, if there was, if more than one tender had submitted the same bid, then it is with the consent of both the lowest bidders that an decision would be taken. Said clause U of 3.2 is reproduced hereunder for easy reference. On the relying on the said clause U, respondent number 3 had awarded a tender to respondent number 5. However, before the petitioner claims that before the issuance of the work order, the petitioner had approached this court, and this court had, while its order dated 17/4/2026, directed the respondents not to issue the work order. Learned counsel for respondent number 3 also relies on clause
page 100.
What is this called?
Commercial.
Banda.
Part 2.
Suchane, the note in part 2 to the tender document at internal page 59 of the tender document. More particularly note 1, which is reproduced hereunder for easy reference. By relying on note 1, a submission is that if more than one tenderer were to be declared L1, the various aspects mentioned in note 1 would be taken into consideration for the purpose of awarding of the tender. And it is in that background that respondent number 5, who had earlier been rendering services for earlier financial years, and his services being satisfactory. In ಯಾವ word ಬೇಕು satisfactory?
Sorry, Mullah.
Satisfactory. The respondent number 5 was chosen over the petitioner, and in pursuance thereof that the work order had been issued on 1/4/2026. The above sequence of events does not inspire any confidence in the tendering process resorted to, more particularly as regards outsourcing of human resources. As can be seen from the narration above, any of the tenderers could not have quoted more than 2% insofar as this particular tender is concerned. If this 2% being the service charges leviable by a manpower agency for supply of outsourced labor/workmen. If anywhere, the payments payable to the supplied manpower would be at the rates prescribed. The 2% indicated above payable to the manpower agency would be the tenderer. But this court is of the considered opinion that nobody would quote more than 2%, since anybody quoting more than 2% would automatically be a higher tenderer and may not be qualified and would not qualify as L1, which is what has been, which hypothesis has been proven by the fact situation which has arisen, in as much as the petitioner and respondent number 5 have quoted the very same amount of 2%. The note which has been relied upon, the clause U of 3.2 provides in such a situation that with the agreement between the L1 tenderers, a decision would be taken by the tender issuing authority. This, in the considered opinion of this court, is a complete farce. Once a tender has been issued, the question of any arrangement or agreement between the two L1 tenderers cannot be the manner in which a tender is awarded. Insofar as note 1 at internal page 59 is concerned, as can be seen, there are various aspects which could be considered by the tender issuing authority when there is more than one person who is L1. The number of items which could be considered are not technically, are not qualifying parameters, but are parameters which vest in the sole discretion of the tender issuing authority or the tender acceptance authority, while considering which of the L1 is to be awarded a tender. In this case, the tender is apparently, the work order has apparently been issued to respond number 5 on the ground that respond number 5 had earlier rendered satisfactory services over the earlier over two financial years had rendered satisfactory services. If that be so, the same would again render the above tender FRs inasmuch as the awardal of the tender is on the basis of the earlier satisfactory service. In that view of the matter, respond number 1 is directed to look into this aspect and file an affidavit as to whether the process resorted to by respond number 3 is proper and correct. Similarly, an affidavit of respond number 2 is also directed to be filed. Apart therefrom, most of these requiring financial concurrence of the finance secretary, finance department, the principal, ACS principal secretary or principal secretary? Principal secretary finance department is also directed to look into the matter and file his affidavit as to the procedure which has been adopted by respond number 3, since this tender and many like this deal with public monies, and any action taken by this court, even in quashing the tender, would result in wastage of public monies, apart from valuable time in relation thereto. The state of Karnataka, represented by the Principal Secretary Finance Department, is brought on record as respond number 7. Learned AG accepts notice for respond number 7. Counsel for the petitioner to carry out necessary amendment and file amended cost title. Relist on 19th August at 2:30 p.m.
With your lordship's kind permission, my lords.
21.
My lords, serial number 52, if I may make a mention, my lords. There's some urgency, my lords. With your lordship's kind permission.
We'll come back after lunch
My
and
lords,
see that.
please, my lords.
ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ಕೊಳ್ಳೆ ಹೋಯ್ತು ಒಬ್ಬೊಬ್ರು ಅಷ್ಟೇ ಚೂರು ಫೈಲ್ ಕೊಡಿ ಎದ್ಬಿಟ್ಟ ಆಗ್ಲೇ ಬೇಕಲ್ಲ ಸ್ಟ್ರೈಟ್ ಕೇಸ್ ಕಮಿಷನರ್ ಫೈನಾನ್ಷಿಯಲ್ ಡೈರೆಕ್ಟರ್
ಇಲ್ಲ ಫಸ್ಟ್ ಕಲಬುರ್ಗಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಥರ್ಡ್ ಲಿಸ್ಟ್ ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ 2:30 ಇದಲ್ಲ ಫಸ್ಟ್ ಕಲಬುರ್ಗಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಥರ್ಡ್ ಲಿಸ್ಟ್ ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಕಂಟಿನ್ಯೂ.
ಮೇಡಮ್ ಇವತ್ತು ರೀಚ್ ಆಗದಿದ್ರೆ ಯಾವ ಡೇಟ್ ಸಿಗುತ್ತೆ?
ಸೆನೋಗ್ರಾಫರ್ ಮೇಡಮ್
98
ಮೆನ್ಷನ್ ಯಾವಾಗ ಮಾಡಬಹುದು?
ಅವರು ಯಾರಿಗೆ ಹೇಳಿದ್ರು ಸಾಹೇಬ್ರನ್ನ ಅವರು ಒಂಚೂರು ಮೇಡಮ್ ಯಾರನ್ನು ಮಾಡ್ಬಿಟ್ರೆ
ಮೇಡಮ್
ಅದು ಇಂಪ್ಲೀಡ್ ಮಾಡಕ್ ಹೇಳಿದ್ರಲ್ಲ, ಯಾರ ಹೆಸರು ಹೇಳಿದ್ರು? R7 ಆಗಿ ಮಾಡಕ್ ಹೇಳಿದ್ರಲ್ಲ ಫೈನಲ್ ಇವಾಗ ಆಗಿತ್ತು ಲಾಸ್ಟ್ ಟೈಮ್.
ಮೇಡಮ್ 2:15 ಮೆನ್ಷನ್ ಮಾಡಬಹುದಾ?
ಇದೆ ಫೈನಾನ್ಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಏನೋ ಹೇಳಿದ್ರಲ್ಲ ಮಾಡಿದ್ರು ತಗೊಳಲ್ಲ, ಮಾಡಿದ್ರು ತಗೊಳಲ್ಲ, ಸೀರಿಯಲ್ ವೈಸೇ ಹೋಗೋದು. ಮಾಡೋದ್ ಮಾಡಿ ಚಾನ್ಸ್. ಟಿಪಿ ಮುತ್ತಣ್ಣ ಬೆಳಗ್ಗೆ ಬಂದಿದ್ರು, ಟಿಪಿ ಇಲ್ಲ ನನ್ನ ಹತ್ರ ಬ್ಯಾಂಕ್ ಅಡ್ವೊಕೇಟ್ ಯಾರ ಹತ್ರ ಸಿಗುತ್ತೆ ನೋಡಿ. ಬೆಳಗ್ಗೆ ಬಂದಿದ್ರು, ಮಾಡಲ್ಲ. 21 ಕೊಡ್ತೀರಾ?
ಅದು 2:30ಗೆ ಮೆನ್ಷನ್ ಮಾಡ್ಕೊಂಡು ಹೇಳ್ಬೇಕು.
ಮಾಡ್ತೀರಾ? ಫೈಲ್ ಅಂತೂ ಇಲ್ಲ. ಫೈಲ್ ಬೇಡ ಅಲ್ಲ, ಬರೀ ಬೇಕಾ? ಇದೊಂದು ಫೈಲ್ PB ಹತ್ರ ಎತ್ಕೊಂಬಪ್ಪ. ಇದೊಂದು ಫೈಲ್ ಮಾಡಿ ಮಾಡಿ. ಇಲ್ಲ ಈಗಲ್ಲ, ಸಂಜೆ. ಹ್ಮ್. ಹ. ನ ಅಲ್ಲ, ಫೈಲ್ ಇಲ್ಲ, ಸ್ಟೆನೋಗ್ರಾಫರ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಆರ್ಡರ್ ಅಲ್ಲ, ಇವಾಗ ಟೈಪ್ ಮಾಡ್ಬೇಕಲ್ಲ, ಅವ್ರ ಕಡೆ ಇದೆ ಫೈಲ್. ನೀವು ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಕೇಳ್ಬೇಕು, ಫೈಲ್ ಇಲ್ಲೇ ಇರುತ್ತೆ. ಈಗೆಲ್ಲ ತಗೊಂಡು ಹೋದ್ರು. ಫೈಲ್ ಇಲ್ಲ, ಫೈಲ್ ಇದ್ರೆ ಕೊಡ್ತೀನಿ. ಇಲ್ಲ, ಫೈಲ್ ಇಲ್ಲ. ಫಸ್ಟ್ ಕಲ್ಬುರ್ಗಿ ಅನ್ಸುತ್ತೆ, ಧಾರವಾಡ ಅಲ್ಲ ಅದು. ಹಾ, ಅಲ್ಲ, ನಾನ್ ಕನ್ಫರ್ಮ್ ಮಾಡ್ಕೊಂತೀನಿ. ಕರೆಕ್ಟ್, ಕರೆಕ್ಟ್. ಅದೇ ಇವಾಗ ಹೇಳಿದ್ರಲ್ಲ, ಸೇಮ್. ಫಸ್ಟ್ ಕಲ್ಬುರ್ಗಿ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಥರ್ಡ್ ಲಿಸ್ಟ್, ಪಾಸ್ಟ್ ಓವರ್ಸ್, ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ. ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಗೊತ್ತಿಲ್ಲ, ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಸರ್. ಬ್ರಾಂಚ್ಗೆ ಹೋಗ್ಬೇಕು ನೀವು. ಆರ್ಡರ್ ಸೈನ್ ಆದ್ಮೇಲೆ ನಮಗ್ ಫೈಲ್ ಬರುತ್ತೆ, ನಾವು ಆಮೇಲೆ ಬ್ರಾಂಚ್ಗೆ ಕಳಿಸ್ತೀವಿ. ಯಾವ ಲಿಸ್ಟ್ ಸರ್? ಲಿಸ್ಟ್ 1 ಅಲ್ಲ, ಲಿಸ್ಟ್ 1 10:30 ಇರೋದು. ಫಸ್ಟ್ ಕಲ್ಬುರ್ಗಿ ಬೆಂಚು, ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಥರ್ಡ್ ಲಿಸ್ಟ್, ಪಾಸ್ಟ್ ಓವರ್ಸ್, ಕಂಟಿನ್ಯೂ. ಗೊತ್ತಿಲ್ಲ ಸರ್. ಇಲ್ಲಿದ್ದಿದ್ ಫೈಲು ನಾನು
ಒಂದು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರೆ ಕೇಸ್ ಡಿಸ್ಪೋಸ್
ಮಾಡಲ್ಲ, ಮಾಡಕ್ ಬಿಡಲ್ಲ. ಸಬ್ಮಿಷನ್ ಮಾಡಕ್ ಬಿಡಲ್ಲ ಅಂದೆ. ಕರೆಕ್ಟ್. ಇಲ್ಲ, ಆಗಲ್ಲ. ಫಸ್ಟ್ ಕಲ್ಬುರ್ಗಿ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಥರ್ಡ್ ಲಿಸ್ಟ್, ಪಾಸ್ಟ್ ಓವರ್ಸ್, ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ. ಅವಾಗ ಅಂದ್ರೆ ವಿಡ್ರಾ ಮಾಡ್ಕೊಳ್ಳೋದಿದ್ರೆ ಮಾತ್ರ. ಅದರ್ ಸೈಡು ಇರ್ಬೇಕಲ್ವಾ? ಕೇಸ್ ಕರ್ದಾಗ ಮಾತ್ರ ಇರ್ತಾರ, ಎಲ್ಲ ಟೈಮ್ ಇರಲ್ಲ ಅವರು. ಮಾಡಿ ನೀವು ಚಾನ್ಸ್ ಅಷ್ಟೇ, ಸಬ್ಮಿಷನ್ ಮಾಡಿ. ನನಗೇನಾಗ್ಬೇಕು, ಆ ಫೈಲ್ ತೆಕ್ಕೊಡ್ಬೇಕು ಅಷ್ಟೇ. ನಾನು ಅದನ್ನ ತೆಕ್ಕೊಡ್ತೀನಿ ಅಷ್ಟೇ. ಮಾಡಿ. ಸಿಗುತ್ತೆ. ಯಾರ್ದು ಬೇಕಾದ್ರಲ್ಲಿ
ಟೆಂಡರ್
ಅವರೆಲ್ಲ ಏನು ಹಾಕದೇ ಇಲ್ಲ ಬಿಡಿ, ಸಿಗಲ್ಲ. ಅವರೆಲ್ಲ ಸೆಂಟ್ರಲ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಅಲ್ವಾ, ಸೆಂಟ್ರಲ್ ಗೌರ್ಮೆಂಟ್. ಗೊತ್ತಿಲ್ಲ, ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಕೇಳಿ ಮತ್ತೊಂದು ಇವಾಗಲೇ ಹೇಳಿದ್ರೆ. ಸಿಟ್ಟಿಂಗ್ ಮುಗಿದ್ಮೇಲೆ. ಇಲ್ಲ ಇಲ್ಲ, ನಾಳೆ ಅಲ್ಲ.
ಯಾವ ಡಿಪಾರ್ಟ್ಮೆಂಟ್?
ಇಲ್ಲ ಸರ್, ಫಸ್ಟ್ ಕಲ್ಬುರ್ಗಿ ಮ್ಯಾಚ್ ಮ್ಯಾಟ್ರು ಫಸ್ಟ್, ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಥರ್ಡ್ ಲಿಸ್ಟ್, ಪಾಸ್ಟ್ ಓವರ್ಸ್, ಕಂಟಿನ್ಯೂ. ಅದಾದ್ಮೇಲೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಸರ್. ಲಾಸ್ಟ್ ಅಲ್ಲಿ ತಗೋತಾರೆ ಸರ್, ಇವಾಗ ಹೇಳಿದ್ನಲ್ಲ ನಾನು, ಆ ಆರ್ಡರ್ ಅಲ್ಲಿ ತಗೋತಾರೆ. ಹೌದು. ಫಸ್ಟ್ ಕಲ್ಬುರ್ಗಿ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಥರ್ಡ್ ಲಿಸ್ಟ್, ಪಾಸ್ಟ್ ಓವರ್ಸ್, ಲಿಸ್ಟ್ 1 ಕಂಟಿನ್ಯೂ. Next date will be 29/8.
I'm respondent. I'm informed the petitioner must next week. to fi-
46.
Yes.
At the request of council for respond number 1 to 6, released on 3rd September, interim order earlier granted is extended till next year.
Please.
My lord, serial number 21, my lords recollect that airport authority, the CCTV camera for 17th of April. I just received instructions. I wanted to check what period. They said that they only keep for 30 days, the CCTV. There is a circular to that effect. That only,
Inform Mr. Chowta, ask him to
I had
come.
I informed my lords. They were present actually 1:30. They were present here itself.
130 there. 130 there.
2:30 also they were here.
How many people present, sir?
That's the only submission because only 30 days as per the circular they keep.
Prayer cannot also be granted.
Please, my lord.
That prayer also cannot be granted.
Third prayer cannot be granted because the period is over 17th, 18th April.
Let him come.
Please, ma'am.
4:30 also you can.
I will inform them, my lords.
My lord, list one, serial number 49.
49.
21 I'm here.
I here, my lords.
My apologies.
Believe only 30 days.
Lords, but what little we could gather, my lords, after 30 days, all the videos or the CCTV cameras footages will be saved in the drive is what we have heard.
My lords, this is the circular to that
I
effect.
ask
I'll take necessary instructions about this.
Manu Kulkarni to come.
Yes, ma'am.
He was here earlier, we could have asked.
He was, ma'am. He's in 13. I'll
Ask him to come at 4:30.
4:30. Obliged.
Inform them about this and let him
Yes,
get.
yes.
My lord, list one, serial number 49.
Yes.
I appear in 49.1. I moved it yesterday on the score that a cooperative society matters tagged with these matters, my lord.
There's one cooperative society.
Yes, I appear in that.
Huh?
My lord, until it's delinked, my lord, I cannot move it before the.
There's a general order. What is this order? We'll have to see it. Yes.
Pass over. Pass over.
My lord, serial number 54.
54.
Appearing for petitioner.
Huh?
Seeking for 2 weeks time. Objection time.
Have you informed the respondent?
Yes.
My lord, list number 3, serial number 16.
List number 3, serial number 16.
Urgency, I request your lordship to kindly take today at the end of the list.
When it reaches, yes.
Serial number 51, list number 1.
Hmm.
Last occasion, interim order was not granted to me, and the learned QCA was directed to not check on the
Bharat, you are mentioning, you're only wasting the time for what could reach.
urgency.
If it reaches, when it reaches, yes.
Serial number 52 minutes.
Similar request. Similar state.
Tomorrow, the resumption will be undertaken by KIDD. I invested.
Yes.
Serial number 41, my lord. My lord was pleased to post it, my lord. This is the 5th time the matter is coming up, my lord. Is it possible to take up today, your lordship?
If it reaches, whatever reaches will be taken up.
That's why, my lord, I am requesting my lord to
Yes,
take up
madam.
this matter, your lordship, today, your lordship.
14%. Bar Council, my lord, is not providing me the email addresses of the contestants. I filed an election petition, my lord, where 153 are the parties. my
They're
lord.
moving a petition.
End of the
RTL ಹಾಕ್ಬೇಕು ನಮ್ಮಲ್ಲ.
ಅಲ್ಲ ಇಲ್ಲಿ ಬಾರ್ ಕೌನ್ಸಿಲ್ ಅವರು ಇದ್ದಾರೆ
ಅವ್ರು ಅಲ್ಲಿದ್ರೆ
ಹಂಗೆ ಅಲ್ಲಲ್ಲ ಅಲ್ಲೇ ಹಂಗೆ ಕೊಟ್ರೆ ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಮಾಡಿದ್ರೆ
ಬಂದ್ಬಿಡಿ ಅಂತ ಹೇಳಿ ಬಾರ್ ಕೌನ್ಸಿಲ್ ಇಲ್ಲಿಂದ ನಡ್ಕೊಂಡು ಹೋಗ್ಬಿಡೋಣ.
10ನೇ ತಾರೀಕಿಗಿದೆ ಸ್ವಾಮಿ ನಂಗೆ ಅರ್ಜೆನ್ಸಿ ಇಸ್ ಮೈ ಲಾರ್ಡ್ ಐ ಹ್ಯಾವ್ ಬೀನ್ ಗಿವನ್ ವಿತ್ ಅನ್ ಆಪ್ಷನ್ ಐದರ್ ಟು ಡಿಲೀಟ್ ದ ಡಿಫೀಟೆಡ್ ಕ್ಯಾಂಡಿಡೇಟ್ಸ್ ಡಿಲೀಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ರೂಲ್ ಸೇಸ್ ಆಲ್ ದ ಕ್ಯಾಂಡಿಡೇಟ್ಸ್ ಆರ್ ಮ್ಯಾಂಡೇಟರಿ ಸೊ ಸರ್ವಿಸ್ ಅಲ್ಲೇ ಆಗೋಗುತ್ತೆ ಸ್ವಾಮಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ 6 ವಾರದಲ್ಲಿ ಡಿಸ್ಪೋಸಲ್ ಹೇಳಿದ್ದಾರೆ ಸೊ 6 ವಾರ ಡಿಸ್ಪೋಸಲ್ ಅಂದ್ರೆ 4 ವಾರ ಅಲ್ಲೇ ಆಗೋಗಿದೆ 2 ವಾರ ಇರೋದು ಸ್ವಾಮಿ ದಟ್ ಇಸ್ ದ ರೀಸನ್ ಓನ್ಲಿ ಇಮೇಲ್ ಅಡ್ರೆಸ್ ಒಂದ್ ತಿಂಗಳ
ಏನ್ ನೀವು ಮೂವಿಂಗ್ ಎ ಮೆಮೋ
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ನಾಳೆ.
ಪ್ಲೀಸ್
My lords.
Serial number 69, my lord, is a passport matter. The last
ನಿಮಗೆ
report
ಕೊಡ್ತೇನೆ,
had asked us to get the father of the petitioner, minor child, get his opinion on it. There is a development now. The father has mailed me the consent documents required to get the passport, my lord. And has also given me WhatsApp message saying that he has taken, given all the required documents necessary for the passport to be renewed.
Do it.
My lord, sir.
So what do you want us to do?
My lord, your direction may be passed to the passport authorities to renew the passport.
If they are going, if you are complying, you can't mention it like this for disposal.
My lord, serial number 44, my lords. They have taken adjournment right now. Serial number 46, my lords. First list.
Yes.
My lords, the date is given on September 3rd, my lords. Could it be on 7th or 8th of September?
You inform them 7th September,
Please, my lords.
46.
Apologies, my lords, I wouldn't insist, my lords.
And we would want to take each of your matters, but if we make one exception for one, then it will be a problem for the others. So we can't make exceptions. Yes.
Kalburgi bench matter, R.V. Nadagowda.
Kalburgi. Pass over. List number 2. List number 2 na 3 na. The pronouncement on it.
List number 3, pronouncement of order, Vandana PL.
Let's say appear for the petitions.
The writ petition is allowed in part. A writ in the nature of certiorari is issued and the impugned government notification dated 15/9/23 at Annexure A, appointing respondent number 5 as the special public prosecutor is quashed. The prayer for general direction that the accused person be notified or heard before the appointment of a special public prosecutor under subsection 8 of section 24 of the Code of Criminal Procedure is rejected. It is left to the discretion of the state whether the prosecution be continued by the regular public prosecutor or a special public prosecutor be appointed afresh by following the procedure considered by this court and laid down by the Honorable Apex Court in Mukul Dalal versus Union of India and by the coordinate bench of this court in KV Shiva Reddy versus State of Karnataka. Any such fresh appointment shall be made only for reasons to be recorded. If the remuneration is to be borne by the complainant, it shall be by way of advance deposit with the prescribed state authority from which the special public prosecutor shall be paid and not by direct payment.
Apply.
List number 2, fresh matter, serial number 1, Satish Kumar.
Petitioner's matters. The petitioner is the wife of husband matters who is on.
Have you received instructions, madam, in this fresh matters? Serial number 1.
Seeking parole for 60 days, my lords. He's been convicted under 302 minutes. He is in jail from 11.
Where is the imprisonment certificate?
But page number 9, my lords. Pardon, my lords.
Imprisonment certificate.
Imprisonment certificate. It is not submitted, my lords. The
We
rejected
need that
order
to
is
see what is being stated by them. Produce Madilva.
Pardon, my lords.
First parole application, Nanimdo.
Yes, my lords.
Get the imprisonment certificate and file it. Land AGI access notice for the respondents. Land counsel for the petitioner is granted a week's time to place the imprisonment certificate on record, relist on 12th.
Serial number 2, Girish R.
Convicted mother is suffering from.
Certificate page number.
She's suffering for a renal function and spinal cord problem, Mila. Medical document annexure C, Mila.
Page number?
Page number 24, Mila. Annexure C. Annex.
What is the reason?
Convicted mother is suffering from critical renal function and spinal cord problem with terminal illness, and she has to higher treatment, Mila.
We have told you so many times, go to a government hospital. You still get this private nursing homes.
No, Mila.
We are not going to consider any nursing home certificate.
Parties, she's taking treatment here, Mila. Agagi.
We are not going to consider a private nursing home. Right?
1 year.
1 year.
But he's total 6 years punishment. Total punishment is 6 years, Mila.
Yes.
He's served on 1 year, 3 months, Mila. Page number 24, Mila.
This certificate we can't accept. You'll produce a better certificate.
Mila.
You'll produce a better medical certificate.
Yeah, kind of short accommodation.
AGI accepts notice for respondent number 1 to 3. The medical certificate which has been produced is by a private nursing home. Counsel for the petitioner seeks for and is granted a week's time to produce a better medical certificate. Relist on 12th August.
Serial number 3, Girish
Is extension of emergency parole, my lord. He's surrendered on third, my lord.
What is the emergency?
His convicted mother is suffering from spinal disorder and medical certificate page number 29, my lord, Annex C. He served on 8 years, 5 months, my lord.
Hmm?
8 years surrendered.
Yes, surrender.
Yes, my lord.
For this reason, if you keep on extending, how long will you extend it?
Earlier,
Emergency parole.
15 days, my lord. He's 2 days later release ಆದ್ರು ಸುಮ್ಮನೆ surety problem ಆಗಿ ಹಾಗಾಗಿ ಅದು
2
ಟ್ರೀಟ್ಮೆಂಟ್
days
ಮಾಡ್ಲಿಕ್ಕೆ
extra.
ಆಗಲಿಲ್ಲ.
The medical emergency parole is only for 15 days, not more than that.
ಬಟ್ ತಾಯಿಗೆ ಟ್ರೀಟ್ಮೆಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ವ್ಯವಸ್ಥೆ ಮಾಡಬೇಕಿತ್ತು ಸುಮ್ಮನೆ ಹಾಗಾಗಿ 15 days ಆದ್ರೆ
This court, petitioner is before the petitioner, wife of, is before this court seeking so. This court had earlier, on 14th July 2026, in WP number 18662 of 26, had granted emergency parole to the petitioner for a period of 15 days. Subsequent thereto, the petitioner has surrendered on 3/8/2026. His conduct during the time of parole is stated to be proper and satisfactory, and there are no complaints against the petitioner. Considering that the emergency earlier period still continues, in as much as the mother of the detainee requires medical attention, we will grant you, this can't go, 30 days we can review. A general parole of 30 days is granted subject to so.
Serial number 4.
Yes, Vijay.
My lordship, I am for the petitioner. The custody certificate is in page number 10, my lordship.
Page?
10, my lordship, Annex A.
10.
He has served a total imprisonment of 5 years, 8 months, my lordship. And he was earlier released on parole also, my lordship. The ground is for right of progeny, my lordship, of the petitioner.
What is the reason now?
The petitioner is deprived of the right of the progeny, my lordship. Progeny, my lordship, conjugal rights.
The petition is filed by whom?
Wife of the convict, my lordship.
Petitioner, wife of CTP 1043 is before this court seeking for the following reliefs.
Not submitted application. It is not submitted application.
Is not.
My lordship, the application was given, the authorities didn't take, my lordship. Really, my lordship, that's a instruction that I've received.
They always take the application, they reject it. But so far, this is the first time that somebody is saying that.
Yeah, this even it was also shocking for me, my lordship. Even I heard for the first time, but that's what the instruction I received, my lordship.
Submit an application, we'll direct them to consider it.
This time, maybe.
The petitioner is before this court seeking for the following ways. Learned AGA submit that there was no application submitted for grant of parole. The petitioner has directly approached this court. In that view of the matter, permitting the petitioner to submit a petitioner and or the detainee to submit a parole application and directing the response to consider the same within 15 days of such submission. Petition stands disposed.
Serial number 5. Pratap versus.
My lord, this matter pertains to emergency parole, my lord. On child's birth on 2/7/2026, my lord. The custody certificate at page number 7 has been out on general parole on several occasions, my lord. And
custody certificate is page number?
Page number 7, my lord. Now the petitioner is seeking for emergency parole on child's birth. It's placed on page number 8 and.
This is filed by your wife.
Yes, filed by the wife.
Petitioner, wife of detainee so and so is before this court. A request for parole, as emergency parole has been made on the ground that the petitioner, who is wife of the detainee, has delivered a baby, and for that reason, the petitioner, the detainee wishes to sees a baby. In that view of the matter, considering that this aspect has to be dealt with humanly, and also taking into consideration that the petitioner, the detainee had earlier been granted parole for a period of 4 months, 14 days, during which time there is no complaint against the petitioner, so and so, for 60 days.
Obliged.
Commencing from the particular case, commencing from 10th.
Serial number 6, Pradeep Patil.
And for the petition, custody certificate is at page 7, my lord. It's undergone 18 years, 5 months.
What is the reason?
My lord, continue with the family. Continuity. Endorsement is at page number 9, my lord. One case is registered against him, my lord. 424 of IPC. Earlier released on parole, my lord.
9th, you have committed an offense while in the prison.
Please, 500 rupees not sick.
Who is the petitioner?
My lord, petitioner is the daughter, my lord.
Petitioner daughter of Suresha CTP 4420. So 18 years, 5 months. Had earlier been granted parole, general parole on one occasion, court parole on another occasion, for a period of 4 months, 17 days. Parole has been rejected on account of one other criminal proceedings being pending against the petitioner. Considering that the offences which have been alleged against the petitioner are not heinous in nature, neither heinous nor grave in nature. Allowed 60 days commencing from 17th August.
Obliged.
Serial number 7, KNSS.
For petitioner, my lord, this is emergency parole, my lord. On medical grounds, my lord. Custody certificate is at page number 10, my lord. Yes, already undergone 3 years, my lord. Medical certificate is at page number 11, my lord.
You have done only 3 years.
Emergency parole, my lord.
My lord.
Only for a tear of the ligament, no. That's not an
Lord, and
emergency.
there's no application also, my lord.
That's not an emergency. AGF for respond had been convicted for life imprisonment. Petitioner has served only 3 years, 7 days as on 27/7/26. The reason for parole is stated to be who is Imalata
Petitioner sister, my lord. Convict sister, my lord.
Detinue's sister has suffered a ligament tear requiring surgery. She is married.
No. Petitioner has filed by the sister.
Who is Imalata Jansirani?
She is the convict wife, my lord.
Wife of Murugan Kasi.
Convict wife.
The wife of the detenue. Yellappa, you are 32 years old. This person is 40 years old.
Imalata is the wife of the convict, my lord. The petition filed by the sir.
Look at the imprisonment certificate. You are 32 years of age.
They have wrongly mentioned in the custody certificate, my lord.
My lord, there's no application filed by him for emergency parole.
How can there be age which is mentioned wrongly in the imprisonment certificate? Submit that AGA submit that no application has been filed. Reserving liberty to the petitioner to file application for grant of parole and directing the response to consider the same within 15 days of such filing. Petition stands dismissed.
Much obliged.
Serial number 8.
Yes,
For
Vijay.
petitioner, my lordship. My lordship, this particular petition I moved yesterday, end of the list. I couldn't unmute my lordship in the virtual
You
court.
were not there.
Apologies for that, my lordship. And page number 8, the custody certificate is there, my lordship.
What is the emergency?
Mother has expired, my lordship.
Mother is-
Death certificate is Annexure B, my lordship.
Annexure? Page?
B, my lordship. Page number 9.
19/7. 19/7.
Yes, my lordship. There are some ceremonies that have to be conducted, my lordship. It is
The
scheduled.
way you mentioned it as if it was yesterday only, so. And AGF for
One day
response.
parole had been granted, my lord. One day parole had been granted for the funeral and he had surrendered on 21/7, my lord.
There'll be other.
Yes, my lord.
Formalities. So the reason for grant of parole is the expiry of the mother of the petitioner on 19/7/26. The counsel for the petitioner submits and the mother of the detainee. The counsel for the petitioner submits that there are certain ceremonies and formalities which are required to be followed. Considering that the petitioner had been granted parole on one earlier occasion when there is no complaint against the petitioner, 30 days commencing from 10th August.
Much obliged, my lordship.
Serial number 9, Naveen J.
My lord, the petitioner seeking general parole, my lord.
Hmm?
Imprisonment certificate, page number 12, my lord, annexure A, my lord. As on date 2025, 6 years, 1 month is served, my lord.
And what is the reason?
The reason is a soft tissue injury, my lord, and on head. Soft tissue injury, my lord. The petitioner is suffering from soft tissue injury on head, my lord.
Where is the medical certificate?
The medical report, page number 13, annexure B, my lord. Sorry, page number 14, my lord, annexure C. In page number 15, my lord, in law.
The
It's
fracture of the
secondary skull and soft tissue.
or orbit. So that will be the
My
eye.
lord, his application was rejected because his bail application is pending before
Only
the High
reason
Court.
bail
That was
application.
the ground, my lord.
And AGF for respondent. Who is the petitioner?
The petitioner is convicted prisoner, my lord.
So the petitioner is before this court seeking for the following reasons. The reason for grant of parole is stated to be on account of a fall suffered by the detainee. He had a headache. On a CT scan being conducted, it was found that there is a fracture of the lesser wing of the right sphenoid bone and orbit. It is submitted that the said fracture requires specialized treatment, which is not available in the hospital, in the prison hospital. Considering the medical certificate which has been issued by the Bangalore Medical College and Research Institute on an examination made of the detainee during the course of his incarceration, and taking note of the findings therein, this court is of the considered opinion that the petitioner requires specialized treatment. Hence, had not been granted parole earlier. Hence, 30 days commencing from 17th August.
Much obliged.
B group matter, serial number 10, Sirajuddin Ahmad.
Imprisonment certificate at page 18, my lords. 7 years he has undergone, my lords. For agricultural purpose, he has filed an application, and earlier also 2 times he has been granted parole.
Why was it rejected?
Lord, because there should be 6-month gap, my lord. He last surrendered on 7/11/25. After that, he sought for the extension, my lord, which was not permissible for the prison to grant it. There is no fresh application.
Now 6 months has lapsed.
Pardon, my lord?
Now 6 months has lapsed.
Yes, my lord. Let him file the application because there was no
He
application.
has already filed, my lord, because
Where
I
did
filed
he
an extension application which did not came before you.
Don't come before this court without filing an application. If it is filed and rejected, then you come here. Don't make this the jail superintendent court.
No. Lords, already 6 months has been 7, it is 7th
Have you
month,
made
my
an
lord.
application after the lapse of 6 months?
Yes, my lord, I have made application.
that application?
That I will annex you. It may be listed tomorrow, my lord.
AGA for respond. Counsel for the petitioner seeks and is granted a week's time to place on record.
Tomorrow day after.
Application filed by the petitioner for grant of parole after the lapse of 6 months from the time of expiry of the earlier parole, released on 12th.
11. Sirajuddin.
Is is for parole till the committee considers, my lords. He has already undergone 17 years, my lords. And the premature release.
Where's the certificate?
Certificate is at page 61, my lords.
Yes.
Because of the pending case, my lords, the LCRC has rejected, my lords. Now the question involved here is, my lord.
What are you are challenging the rejection by the LCR?
Yes, my lords, rejection, my lords.
And AG accepts notice for the respondent.
My instruction is for the sixth time it has been rejected on 10/4/2026.
Place all the records. Sixth one is in 2 weeks' time to file a statement of objection and place all the orders passed earlier by the LCRC. Released on 19th August.
12.
Yes.
May appear for petition in this case. Custody certificate is at page number 17, my lords.
Page number 17.
17, Annexure B, my lords. The convicted person has been undergone more than 7 years, my lords. And the sentence was for 10 years, my lords, for the punishable offense 376 of clause 2, my lords. And this is the fresh application which is filed, my lords.
Why was it rejected?
My lords, there is no criminal appeal pending also, my lords, in this case.
So why was it rejected? Where is the rejection order?
Annexure A, my lords. Page number 14.
ಇದು ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಪ್ಪ ರಿಜೆಕ್ಷನ್ ಎಲ್ಲಿ? This is the application that you filed.
Yes, my lords.
Has it been rejected? What has happened to this application?
They have not considered it. Yes, my lords, it has been rejected.
Panini, any instructions? Rejected. Reason? After 6 years.
More than 7 years, my lords.
Petitioner mother of the detainee so and so had been, but 10 years is the maximum. This is not the 20 year, 10 years. Petitioner has been incarcerated for 6 years, 3 months, 29 days as on 10/11/25. As of now, is undergone imprisonment for more than 7 years. The petitioner had submitted an application for parole on the ground of house repairs, which came to be rejected by a respondent on the ground that the petitioner may abscond. Considering that the maximum imprisonment which has been awarded is 10 years, and the petitioner has served more than 7 years, this court is unable to accept the submission that the petitioner may abscond at this point of time. Hence, allowed 60 days from 17th August.
Grateful, my lords.
13. Kiran SS.
For petitioner, my lord. This is a general parole, my lord. Custody certificate is at page number 148, my lord. Annexure C.
Imprisonment for life.
Yes, already undergone 5 years, 9 months, my lord, till now.
5 years, 1 day, 1 month, 18 days as on 29/10/25. What is the reason? House repair.
Yes, my lord.
30 days from.
My lord, one thing, he has sought for the house repair, the reason. But on the inquiry, it came to know they are staying in a rented house. There is no, and also chance of escape. That's why it's rejected.
30 days commencing from 17th August.
Much obliged.
14. Sirajuddin Ahmad.
Yes.
Yes, 9 years. 9 years he has undergone, my lords.
Lord, this is pertaining to Belgavi prison, my lord.
Page number. Page number.
Page number is imprisonment certificate, page 27, my lords.
27.
28, my lords.
28. Where is he incarcerated?
Belgavi, my lord. No
Belagavi, my
jurisdiction, my lord.
Liberty.
AGF for respond. The counsel for the petitioner seeks permission to withdraw the above petition with liberty to file a fresh petition before the appropriate bench. Reserving such liberty, petition stands dismissed.
15, Dakshita.
For a short accommodation, my lord, I have not appended the custody certificate. And they have
AGF for respond. Counsel for the petitioner seeks for and is granted a week's time.
Weeks
to produce the imprisonment certificate. Released on 12th.
Great.
16, Ishar.
Girish. Nimde. 16.
Yes, my lord.
Why was it rejected?
There is no six-month gap, my lord. Before 6 months, he has filed the parole, so it's rejected by the.
No, my lord. Earlier is an order to 17 December 25, WP number 37994/25 is an emergency parole
File the
15 days. My
application
lord.
after 6 months or no application?
It's already 6 months. Is ordered on 17 December 25, my lord.
17 December
25, my lord. WP number 37994/25.
For how many days?
15 days, my lord.
15 days.
Yes, my lord.
So
This
when did you
application-
submit your application?
Submit application on
24/1/26, it is rejected, my lord. The application is rejected on 21/4/2026.
You filed it before 6 months.
but it's an emergency parole, my lord.
In emergency. In
His sister is suffering from ischemic heart
You're
disease
mixing
and
the facts. ಬೇರೆ ಯಾವುದೋ ಕೇಸ್ ಇದರಲ್ಲಿ ಏನಿಲ್ಲ. The petitioner is before this court, permitting the petitioner to file an application, fresh application for the petitioner, fresh application for parole by the petitioner, and directing the respondent to consider the same within 15 days of the said filing of the application. Petition stands.
Can it be 30 days, my lord? Because
30
we are
days.
sent for the inquiry.
30 days. I don't know. 30 days.
17, B. Nataraja.
Parole for 30 days, my lord. Producing the custody certificate.
ನೀವು ಯಾವ್ದ್ರಲ್ಲಿ ಇದರಲ್ಲಿ ಇದ್ದೀರಾ?
230.
230. But list 2.
Extension of time.
This is not the way that you can file it. You have to file a memo.
Oh.
Second list, sir.
Where the judgment in SC 130 of 2002? What is the sentence?
Life imprisonment, my lord.
Rigorous antide. Is there a condition without parole? Judgment idea?
Judgment illa, sir.
Face the judge. Along with that, you file this also.
Obligement.
Counsel for the petitioner is directed to place on record the judgment and order of sentence in SC number so and so. Released on, when will you file it?
1 week time, 1 week, my lord.
Released on 19th.
Obligement, my lord.
Serial number 18, Naveen J.
Petitioner seeking general parole, my lord. Producing imprisonment certificate, my lord. My lord. For house construction, my lord. My representation dated 17/4/2026, my lord. The convicted.
Why was it rejected?
They not consider, my lord, my application. My application dated 17/4/2026, Annexure B, my lord.
What has happened to his application?
ಅವ್ರು ಕನ್ಸಿಡರೇ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ನಮ್ದು ಏನು.
And consider the contention is that the application for parole filed on
Annexure B, my lord.
426 has not been considered. Directing the respondent to consider the said application within a period of 30 days from the date of receipt of a copy of this order. Petition stands disposed.
Much obliged.
19. Rakshita.
The petitioner, my lord, is the wife of the detainee, my lord. My lord, the imprisonment certificate indicates that my lord is in custody for
Page?
period of 9 years, my lord. Lordship should find it at page number 11, annexure B.
There are 2 pending cases.
But there are 2 pending cases, my lord, hence the parole application came to be rejected. But the 2 cases were registered when the detainee was inside the custody of the prison authorities.
Both the offences were committed and NDPS also.
My lord, in one case, my lord, the remand application, I went to remand application, my lord, filed in CCB police station. My lord, there is nothing that would incriminate, my lord, this petitioner. My lord, this the detainee. My lord, my lord, in other NDPS cases, my lord is only roped in, only basis of, my lord, the confessional statement of the co-accused. Lordship, my lord,
Takes us notice for response.
like the notice agide.
10 days time. File your objections.
My lord, since 9, my only prayer before your lordship, my lord, and restrict my prayer for 30 days. Since 9 years, my lord is not been out of prison.
If your client commits crimes while in prison,
Lord,
they are not inclined.
I think the state of affairs, my lord, the prison is maintaining, my lord, on base.
State of affairs.
My lord,
That you have to commit.
My lord, my submission before your lordship is, I'll produce the document of, my lord, the cases that are pending.
Objections released on 19th.
My lord, 13th, my lord, I would produce that copy of, my lord, that NDPS.
Let them file their objection. They'll give you the
This
full
is almost coming for, my lord, from past 3-4 months.
Not for people who commit offences in the jail.
My lord, mere registration of an FIR, my lord, though he's in
Yes.
prison. Lordship may have done
Get it
13th.
quashed and then come.
These are people, my lord, who can't afford multiple litigation. My lord, they are languishing in custody.
Yes.
Citation sikkide, my lord. Any short date, my lord. Remainder of natural life, my lord. Page number 12.
Reminder, where is the
Pasco
judgment?
case, my lord.
Judgmental.
Sikkide, my lord. Short dates.
And AGF for the respondent. Counsel for the petitioner seeks fund is granted 2 weeks time to place on record the judgment in special C number 198 of 2014 by the additional district and session judge FTSC 2, Bengaluru Rural District, Bengaluru. Released on 19th.
21.
My lord, general peril, my lord. Custody certificate page number at 11, my lord.
Page number
11, my lord. Custody period 2 years, 5 months, 17 days, my lord. 5 years imprisonment.
Why was it rejected?
Pardon me.
ಯಾಕೆ ರಿಜೆಕ್ಟ್ ಏನಕ್ಕಾಯ್ತು?
ಇದು ಎಸ್ಕೇಪ್ ಆಗ್ತಾರೆ ಅಂತ ಹೇಳಿ ಅಷ್ಟೇ my lord. ಇಲ್ಲಿದೆ. Page number 12, my lord.
Police
time, my lord.
verification report. Why was it rejected, madam?
Stated any reason in this?
Reason correct.
Police verification report is rejected.
2 years, 7 months sentence.
5 years is the imprisonment. They done nearly half.
House repair.
Imprisonment for 5 years. As on 5/6/26, 2 years, 5 months, 17 days. House repair, 30 days commencing from 17th August.
22. Hiranajit.
22 for the petitioner.
Yes.
Kindly. Annexure.
This is Bellary jail.
Lords.
Bellary jail.
Bellary jail. Annexure F, my lords. There was a liberty given to this petitioner, my lord. He was in Shivamoga custody in 2026. At page number annexure F, my lord.
If you are in Bellary jail, you'll have to file it.
Right now he is in Bellary, my lords. But earlier I had filed a petition before this Honorable Court. There was a liberty granted.
Courts will have to come from there.
Some date may be given senior.
Seeks liberty to withdraw the above petition and file it before the appropriate bench. Reserving such liberty, petition stands disposed.
Please.
23. Naveen J.
General peril, my lord. The purpose of agricultural purpose, my lord. The
certificate illappa.
I producing some. Also, the jail superintendent issued endorsement.
Number. Imprisonment certificate illa.
ಇಲ್ಲ ಕೊಡ್ತಿದ್ದೀವಿ ಸ್ವಾಮಿ, ಈಗ ಕೊಡ್ತಾ ಇದ್ದೀವಿ.
ಈಗ ಕೊಡ್ತಾ ಇದ್ದೀರಾ? ಕೊಡಿ.
The only reason pending cases ಇದೆ ಅಂತ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ಬೇಲು ಆಗಿದೆ. ಬೇಲ್ ಆರ್ಡರ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀವಿ ಸ್ವಾಮಿ. Page number 2, my lord, bail order.
812. Crime number 88. The reason for rejection was on account of one other case in crime number 88. Crime number 78 of 2019, raised by Nelvangla Town Police, now pending as SC number 72 of 2021. Has been incarcerated for 7 years, 21 days. Is on. When was this certificate issued? The ground for rejection is that there's one other case which is pending in so and so. The counsel for the petitioner has produced the order dated 11th August 2020 in criminal misdemeanor number 812 of 2020, granting bail to the detainee in the said proceedings. In that view of the matter, when bail has been granted in the pending proceedings, application for parole could not be rejected, ought not to have been rejected on the ground that there's another pending criminal proceedings. 30 days from 17th August.
24.
My lords, imprisonment certificate at page 84, my lords.
Page 74.
84, my lords.
84.
12 years, 2 months, my lords. And for the purpose of agriculture, the reason for rejection is, my lords, there is a pending case before the Supreme Court of India, my lords.
What is pending?
Bail application of the convict.
The appeal is pending before.
Yes, my lords.
Reason for rejection being appeal being pending before the Honorable Supreme Court of India. Merely because an appeal is pending would not be a ground for rejection of a bail as held by this court in so and so. Petitioner having been incarcerated for a period of 12 years, 2 months, 13 days.
My lords, on submission.
Has not been granted parole.
It is not for, not in this case. He is eligible for premature release, my lords, but the reason for rejection is at page 89, my lords. The police
12
report.
years only.
Page 89, my lords, is the police rejection report, my lords. Sorry, my lords.
Page
89, my lords. There is an apprehension that he might commit some offences or he might abscond, my lords. That is the reason why police.
That apprehension, madam, that he'll commit. On what is this based?
I beg your pardon, sir.
The apprehension that he may commit another
Please, my
offense. And what is that apprehension based
That
on?
I'll seek instructions, my lord.
That AGF for respond,
But
realist
my lord,
on-
my instructions are that he sought for premature release.
Ah.
That, my lord, he is entitled in September, my lord, because the
Is not
committee will be
completed.
once in 3 years.
Hmm.
So it will be placed before the committee in September, my lord. As such, he's completed 12 years custody.
After completing, why do you still have the apprehension that he will commit one more
Sir,
offense?
that will be the general opinion given by the SP.
So we'll reject. Parole was rejected on the ground that the respondent apprehends that the petitioner may commit an offense. The petitioner have been incarcerated for a period of 12 years, 2 months, 13 days as on 11/5/26. The petitioner having also filed an application for premature release. This court is of the considered opinion that such an apprehension is not well founded, nor is any document placed on record to base such apprehension. In that view of the matter, 30 days.
Please, my
They have not been given parole at any
No, my
time in
lords.
12 years.
Not even once, my lord.
30 days from 17th August.
25. Aditya is
My lords, page 16 is the imprisonment certificate.
16.
1/6, my lords. 4 year, 10 months, my lords, as on June, my lords. for agriculture purpose, and the reason for rejection is
Not so soon. Petitioner have been imprisoned for life. Petitioner has on 9/6/26, detenue has on 9/6/26 has served 4 years, 10 months, 28 days.
at least 15 days may be granted. The only apprehension is, my lords, the villagers are not in a position to receive him, my lords. There is a page 65 is the rejection.
So come back after 2 years, then we'll consider.
Please.
The petitioner having served only 4 years, 10 months, 28 days. In the considered opinion of this court, it will not be a fit and proper case to release the petitioner on parole so soon, reserving liberty to the petitioner to approach this court once again after serving substantial term of the sentence. The petition stands disposed.
Please.
26, Mohammed Tahir.
Appear for petitioner, your lordship.
Yes. Yes, Tahir. Yes, please.
Respondent.
ಯಾವ್ದ್ರಲ್ಲಿ 26 ಅಲ್ಲಿ CBI. 26
I can't hear you.
Petitioner in judicial custody since 15 years, your lordship. Medieval, your lordship.
Where is the imprisonment certificate?
Page 45, your lordship. Page 45 is the imprisonment certificate, your lordship. And also produce endorsement, your lordship, page number 23, your lordship, Annex A.
You have another 3 cases for which you have been convicted.
Lordship, it was all, already have completed 15 years, your lordship. The total sentence is 15 years, your lordship.
You have completed how many years?
15 years, your lordship.
15 years, my lord.
15 custody certificate.
Near 8 cases were there, my lord.
He's in Bangalore, your lordship, now. He's in Bangalore jail. He was transferred from Gujarat. He was transferred to.
CBI is also made a party in this, my lord. Kindly see the article.
So many matters.
The lordship, can you
Respond 1 to 3. Shri Prasanna Kumar is directed to accept notice for
Notice
respondent.
was issued on the last day.
Objection has been filed.
Yes.
Lords, your lordship may kindly see, Lords, the order, Lords, at Annexure T, page 36. Lord, this was the last order passed by the coordinate bench of this honorable court, rejecting his prayer for general parole. Lords, in the present petition, Lords, the ground which is pleaded by the petitioner is that, Lords, that he has to approach the honorable apex court, therefore parole is required. That order is passed on 30th of April this year, my lords.
He was in Gujarat.
Earlier.
Earlier.
Yes, your earlier parole application has been rejected with sufficient and more reasons.
Lordship, kindly pass, your lordship. I will come physically, your lordship.
Your physically coming will not make any difference, Mr. Counsel. When there's a reasoned order passed recently, as on 30th April 26.
Lordship, kindly pass, your lordship.
For what reason?
Lordship,
30th April, it's been rejected just 3 months ago.
please, lordship.
All your grounds have been considered.
Lordship, he was.
Before this court seeking for the following. An earlier writ petition filed by the petitioner.
Your lordship has passed in the year 2020, your lordship. That has
31619 of 2025 came to be rejected by a coordinate bench of this court as recently as on 30th April 2026, considering that the petitioner did not deserve to be released on parole the petitioner's antecedents do not inspire confidence. And the offences which have been alleged against the petitioner, multiple offences being alleged against the petitioner, do not require the exercise of discretion to grant parole. There is nothing which has been placed on record to indicate any change in circumstances from 30th April 26 to today. Hence, for the very same reasons as indicated by the coordinate bench in its order dated 30th April 26 in WP number 31619 of 2025, the petition stands dismissed. We are not imposing costs.
Right.
Yes.
27, Balasubramanian.
And for the petition, my lordship. Petitioner has more than 10 years is already.
Where is certificate page number?
Page number 20, my lordship.
First are the
Page number 20. 9 years.
Not granted parole till now. Why was it rejected?
Page 13, my lord, because he has convicted for the murder of the parents, and there will be
Same reason from
chances
last
of
10 years is.
clash between the siblings, my lord.
Application having been filed by the petitioner had been rejected on the ground that the petitioner was convicted on account of the murder of his parents, and there may be a clash between the siblings of the petitioner. Petitioner having served 9 years, 10 months, 16 days as on 6/5/26. This court is of the considered opinion that the said apprehension is not founded, is ill-founded. 30 days commencing from 17th August.
28.
28, I will withdraw, my lord. I will withdraw, my lord.
Withdraw.
No jurisdiction, my lord. Vijaypura.
Seeks permission to withdraw with liberty to file before the appropriate bench.
29.
My lord, 29, last date of verification, lordship directed to produce the judgment count. Page number 44, 45 is the operative portion. Judgment. Only imprisonment for life. Custody certificate is at page number 8, man. First time he is sitting, man.
And what is the reason?
My lord, wife is suffering, my lord. Page number 9 is.
Page number?
Page number 9 is medical certificate.
My
Page
lord,
number
this
10
medical
is rejection.
certificate not provided to the authority, my lord. We'll just verify this thing, man. Medical certificate, he has not provided the medical certificate to the authority.
Page number 10 is rejected.
Next time you come up with this kind of certificates, and AGA seeks for is granted 2 weeks time. Released on 19th August.
Okay.
30. Girish.
Yes.
Paper petition in this case, my lord. Emergency parole. Page number 17, custody certificate, imprisonment certificate, my lord. As an certificate is in undergone 6 years, 2 months, 27 days, my lord.
My lord.
What is the emergency?
Petitioner's sister is suffering from ischemic heart disease and along with renal cure. Page number 18, my lord, medical certificate.
My lord,
He has been 10 years.
My lord, can I make one submission, my lord?
Yes.
The medical certificate and the surety details is not provided, my lord. They have just sent a mail. No detail.
10 years, out of which served 6 years, 2 months, 27 days on 1/12/25. 30 days. The ground on which the parole has been sought for is the ill health of the sister of the petitioner requiring surgery. 30 days commencing from 17th August.
31. Girish.
General parole, my lord. Custody certificate, page number 21, my lord. Annexure B. As on custody certificate, she is served 3 years, 8 months, my lord. But as on 21/5/25, my lord. Custody certificate. But
Had been
now you say
convicted
4 years.
for imprisonment of life. He has served
But
3
this is-
years, 8 months,
So
5 days as
submission,
on
my lord. There is a
17
two children, my lord. 2 children. They are in hostel, my lord. But they
Not
other bit to
yet.
ಬೇರೆ ಯಾರು ಇಲ್ಲ ಸ್ವಾಮಿ ಹಾಗಾಗಿ. She has to ಅವ್ರ ಫ್ರೆಂಡ್ ಬಿಟ್ರೆ ಸ್ವಂತದವರು ಅಂತ ಯಾರು ಇಲ್ಲ ಹಾಗಾಗಿ ಸ್ವಾಮಿ. ಅದನ್ನ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಕೂಡ ಹೇಳಿದ್ರು.
She has been convicted for 302 offense. She has served only 3 years or maybe 4 years.
As in 21/5/25, my lord.
ಆಯ್ತು 1 year extra ಹಾಕಿ.
ಬಟ್ ಸ್ಮಾಲ್ ಚಿಲ್ಡ್ರನ್ಸ್ ಇದ್ದಾರೆ ಸ್ವಾಮಿ, ಬೇರೆ ಯಾರು ಇಲ್ಲ ನೋಡ್ಕೊಳ್ಳಿ, ಅವ್ರ ಹಾಸ್ಟೆಲ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ.
ನಾವು ಹೇಳಿದ್ರೆ ನಿಮ್ಮಲ್ಲಿ ಮತ್ತೆ ಬೇಜಾರು ಮಾಡ್ಕೊಂಡು. These are all to be thought of before committing the offense, not after. 3 years, 8 months, 5 days, as on 17/5/25. Since the detainee having been sentenced to imprisonment for life, this court is of the considered opinion that the application for parole is premature and the petitioner has not undergone substantial, has not served substantial period of sentence, reserving liberty to the petitioner after serving substantial period of sentence. Petition stands disposed.
32.
For the petition, page number 8 is custody certificate, madam, including remission 11 year 2 months. Rejection order is at page number 10, madam.
Why was it rejected?
My lord, one submission, my lord. In this case, recently the wife of the petitioner has returned to the jail authority, my lord, telling he is harassing her. And one more thing is, it's not yet rejected. My police has rejected, but the DG prison is set to take the call on this, my lord.
My lord, last para of the legal notice, they seek only to divorce.
Because she has mentioned he is harassing her if he comes in on during the parole and all.
You filed a divorce proceeding.
No. She filed.
Place those records.
Please.
And AGA submit that the objection has been received from the wife of the detainee, contending that the detainee has been harassing her, and it is for that reason that the application is pending consideration. Counsel for the petitioner submit that the divorce proceeding has been filed by the wife. He seeks for and is granted 2 weeks time to place the said documents on record. Relist on 19th.
Obliged.
33. Kiran.
Query for petitioner, my lord. This is a general parole, my lord. Yes, already undergone 10 years 4 months, my lord. Custody certificate at page number 10, my lord. This is the second time.
Reason for rejection?
Pending case, my lord.
My lord, the pending case already has been quashed, my lord, in a criminal petition 9495/2024, my lord. What is the code?
This is crime number 66. Pending case cited is crime number 173.
Yes, my lord, 307, my lord, same case.
The
same case.
Crime number 173 then. This what has been quashed is crime number 66. There was one more case.
The trial is going on as SC 5009 of 2024 before Anekal, my lord.
Illena mistake there. This 63 became 5009. You have mentioned 5009. So and so. The reason why, Yanik, why did you ask for the
Education purpose, my lord.
for
Yes.
education purpose?
Yes, my lord. Produce the study certificate as well as master, my lord.
Petitioner having taken up his examination for 11th standard.
Yes, my lord. Just second time parole, my lord.
The reason why the application was rejected was on account of the pendency of proceeding in SC number 5009 of 2024. Then counsel for the petitioner submit that the said proceedings have been quashed insofar as the petitioner is concerned by order dated 12th March 25 in criminal petition number 9495 of 2024 by a court bench of this court. in that view of the matter, the reason for rejection does not survive. The petitioner having sought for parole to pursue his education, having been granted parole on a court parole on one earlier occasion for a period of 2 months. And the consider opinion that the petitioner would have to be encouraged in pursuing his educational ambitions. 90 days commencing from 17th August.
Much obliged.
General parole, my lords. Imprisonment certificate at page 15, my lords. 5 years, 10 months, my lords, as on.
Why was it rejected?
My lords, pending case, my lords. I am furnishing a memo along with the bail orders.
So it was rejected on account of pending case. And counsel for the petitioner submits that the petitioner has been enlarged on bail.
In both the cases has been enlarged. Page numbers.
Where is the order?
My lords, page 9 to 11 is the bail order in the first case, my lords. It is a CC case.
Where is the order?
There's no order, my
I'll
lord.
produce a certified copy. Because it
You
is.
can take a printout also. What you have produced is only the status of the matter.
No, my lords, order I have produced at page 10. 9 and page 9, my lords. Page 11, page 10 is the order.
If this is the order, then be happy. We'll also pass some same order here.
I'll produce it.
Counsel for the petitioner seeks for and is granted 2 weeks' time to place the orders enlarging the petitioner on bail in the pending criminal matters. Relist on 19th.
35.
Free for petitioner, my lord. This is a general parole, my lord. He has already undergone 4 years, 9 months, my lord.
Plus 20 years POXO. Petitioner had been 20 years. Petitioner has undergone incarceration only for a period of 4 for offences under section 6 of the POXO Act. The petitioner has undergone incarceration for a period of 4 years, 8 months, 15 days, as on 13/7/26. Considering the heinousness of the offence for which the minimum sentence of 20 years has been imposed, this court is of the consider opinion that the petitioner cannot be released on parole at this stage, reserving liberty to the petitioner to approach to the authorities for grant of parole after completing serving substantial period of sentence. The petition stands dismissed.
Much obliged.
36. Pradeep Patil.
Yes. Pradeep.
And for the petitioner, reject copy is not provided, my lord. Female convict, my lord. 8 years. Custody certificate at page number 8.
18.
8. Page number 8, my lord.
8.
Please. She's undergone 8 years, 7 months, 22 days. Under 1 year, she is eligible for premature release.
Why was it rejected?
The reject copy is not provided.
Not.
Lord, there is no clear report from SP, my lord.
Was rejected on the ground that there is no clear report from the Superintendent of Police on police verification. Petitioner detainee having undergone 8 years, 7 months, 22 days of incarceration as on 9/7/26. And petitioner detainee having been granted parole on 3 earlier occasions, during which time the conduct has been satisfactory. 90 days commencing from 17th August.
Obliged.
37.
Why is this
Matter pertains to.
cultural?
My lord, it was yesterday.
17th August. Released on 17th August.
38. Kiran SS.
Bring for petitioner, my lord. It's a general parole, my lord. The custody certificate is at page number 10, my lord. He has already undergone 12 years, my lord.
Why is it rejected?
My lord, he has applied the application, but still it is under pending, my lord.
This Panini has been rejected or pending?
Our application is pending, my lord. Pending.
ಇದು ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಅಪ್ಲಿಕೇಶನ್ ಇದು
ಸರೆಂಡರ್ ಡೇಟ್ ಸರ್ ಸರೆಂಡರ್ ಡೇಟ್
ಸರೆಂಡರ್ ಡೇಟ್ ರಿಜೆಕ್ಟ್ ಆಗಲಿಲ್ಲ ಅಲ್ಲ ಈ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಆಗಲಿಲ್ಲ ಸ್ವಾಮಿ ಇಟ್ಸ್ ಸ್ಟಿಲ್ ಪೆಂಡಿಂಗ್ I'll just seek instruction on this one.
That AGA submit that the application filed by the petitioner for parole is still pending. He
My
seeks
lord,
for
my
revision.
apologies. It's SP police SP reject, my lord.
SP reject.
Yes, my lord.
Has been rejected on account of SP. Has served 10 years, 2 months, 28 days as on 12/9/24.
Now presently 12 years.
Agoitallappa. Is eligible
12
for
years he has completed, my lord.
mature release.
Along with 2 years remission, my lord.
90 days commencing from 17th August.
Much obliged.
39.
Prefer petitioner, my lord. This is a general parole, my lord. Custody certificate at page number 12, my lord. He has already undergone 11 years, 11 months, my lord. This is a third time parole, my lord.
Rejected.
But it's a he's convicted under POSCO Act case, my lord.
Yes, but life imprisonment.
Life imprisonment.
Not 20 years minimum. 11 years, 11 months, 25 days. As on 4/7/26, he had been granted parole on court parole on 2 earlier occasions for 3 months, 29 days. There is 90 days commencing from 17th.
Much obliged.
40.
The petitioner is a mother of the convict, my lord. Seeking 90 days parole, my lordship. I have produced the custody certificate in page number 24, my lord. "75 years old mother, my lord. She is a single mother, my lord. Seeking first time parole."
Rigorous imprisonment. Do you have the judgment in SC 51?
No, my lordship.
Reject.
It's life imprisonment, my lordship. Life imprisonment, lordship.
No, it says rigorous. That is why we want to find out what it is.
Seeking first time parole, my lord.
Do you have the judgment in SC 51?
No, my lord.
Is it there in your file?
No, it's not there.
Get it.
Kindly pass over this. I'll just produce this one, my lord.
Pass over other reach agala. Counsel for the petitioner is directed to place on record the judgment and order of sentence in SC number 51 of 21, released on 12th August.
Chocolate.
One. Aditya.
Lord's imprisonment certificate at page 15, my lords. The only issue here is, my lords, the petitioners, both the sons are in the same prison, like convicted in the same offense, my lords. They're trying to build a house, my lords. I've produced the nominal role of the.
Is to build it without them.
2 years, my lord.
Convicted for imprisonment of life on 28/4/25, as on 27/6/26, served 2 years, 9 months, 3 days. There's one other case in SC number 10016 of 2020.
He has been released on bail.
Pending on the file of the 5th Additional District and Session Judge Tumkur, where the Learned Counsel for the petition submits that he has been released on bail. Be that as it may, petitioner has served only, detainee has served only 2 years, 9 months, 3 days out of the sentence of imprisonment for life, preserving liberty after substantial term.
Please.
42.
Seeking 90 days for gender parole. The petitioner is a mother of the convict, my lordship. He have served 3 years, 7 months in the judicial custody, my lordship.
Page 17. The previous surrender date is 9/3/26, my lord. So there should be a 6-month gap, my lord, for the next.
5 months already over. There is an emergency in this case, my lordship. I have produced the medical certificate as well. The mother is a single mother who is nobody is having to take care of her mother, my lord. She's taking help from the neighbors.
Thought of before
Yes, my lordship.
302, not after. Period of 6 months. When did he surrender?
9/3/26, my lord.
9/3/26.
In page 17, my lord.
And AGA submit that a parole having been granted to the petitioner on earlier occasion. He has surrendered on 9/3/26.
She's taking help of the neighbors, my lordship. Until 30 days may be given.
Until the petitioner could not file an application until the expiry of 6-month period post his earlier parole period having been completed, preserving liberty to the petitioner to file a fresh application before the authorities after completing of 6 months. Petition stands disposed.
43.
Convict of the mother of the convict, my lord, and he is in custody for 7 years 9 months, my lord. Kindly come to page number 10, my lord.
376D.
My lord, he is in custody for 7 years 9 months, my lord, and he has been already released once, my lord.
Given parole on one occasion.
One time parole.
Conduct is okay.
Bail application is pending, my lord. That is, I'll leave to the court.
Been granted parole on one earlier occasion, court parole on one earlier occasion for 3 months. Satisfactory. So 90 days from 17th August.
Much.
44, Kiran SS.
My lord, in this, there is no application for parole, my lord.
For petitioner, my lord.
Application, my lord.
They're not
Already
filed
he has selected for board has recommended his name, my lord. Board has recommended his for premature release, my lord.
Premature.
No, my lord. Already recommended, my lord. On August 4, they have given the application, my lord.
For 13 years.
Yes, my lord.
No, my lord, because he is only served 10 years, 11 months. He's not
There's remission of 3 years, 13 years.
The copy of the
Remission also you have to take into account.
yes, on August 4, they have recommended the petitioner convict name, my lord.
So you may
My
be
lord,
released
it
on
will be
August
placed
15th.
before, my lord. Placed before the board. It's not yet placed, my lord.
Recommend agide.
Recommended to place before the board.
So 10 years, 10 months, 20 days. His case has been recommended to be placed before the board for consideration of premature release. He had been granted court parole on one earlier occasion for 3 months when there is no allegation. It's found satisfactory. 90 days from 17th.
Much obliged. Applying for petitioner, my lord. Premature release, my lord.
My lord, in this the board has recommended, my lord.
Board has recommended 90 days.
Much obliged.
46, Prakash SS.
First time general parole, my lord. Imprisonment certificate at page number 8.
Page number?
It's not available single time parole, my lord. And the purpose for general parole is for house renovation construction, as it's raining in
Why
court.
was it rejected?
Rejected at page number 9 and 10.
What are the reasons?
ತನ್ನ ತಂದೆಯ ಕೊಲೆ ಮಾಡಿದ ಬಂದಿಯ ಮೇಲೆ ದ್ವೇಷವನ್ನು ಇಟ್ಟುಕೊಳ್ಳಬಹುದು.
And 5 years. The reason for rejection being that the petitioner being convicted for the murder of his father, there may be dvesha yar mele?
Between two families, ಎರಡು ಕುಟುಂಬಗಳು.
No, your father's murder. Your father has also been murdered. Petitioner, detinue's father has been murdered. ತನ್ನ ತಂದೆಯ ಕೊಲೆ ಮಾಡಿದ ಬಂದಿಯ ಮೇಲೆ.
Same.
The others may have some
vengeance
for your safety. You don't want safety.
First time I'll ensure, my lord, because I have to maintain family bonding as well.
On the ground that the family members of the person who the petitioner was convicted, family members of the person, the petitioner have been convicted for murder. The family members of the person who has been murdered would seek to avenge, would seek to take revenge on the petitioner and the detenue. The detenue having served a period of 5 years, 5 months, 27 days, at this length of time.
At page number 11, I have produced the photograph. Page number 11, I have produced the photograph of the house.
At this length of time, this court is of considered opinion that the apprehension is not well founded. Petitioner detenue having sought for parole on account of house repairs. The rule of the photograph indicates that the house requires repairs. Hence, 30 days commencing from 17th August.
This 7 is a general parole, my lord. Our petitioner is convict of the mother, my lord. And previously, 90 days of parole has been already granted, my lord. He's in custody for 6 years, 8 months, my lord. Kindly come to page number 12 of the imprisonment certificate, my lord.
6 years, 6 months, 28 days as on 18/7 have been granted general parole on one earlier occasion for 90 days. Satisfactory, 90 days commencing from 17th August.
48.
For the petitioner, page number 18 is the custody certificate, my lord. Is eligible for premature release, my lord. Kindly come to Annexure E, page number 43. The observation of the Honorable Apex Court, my lord. Relevant page, para number 10, my lord, page number 52.
52.
Please, my lord.
What is 52?
Para number 10 of the Annexure E, page number 52. The Honorable Apex Court, my lord. May I read, ma'am? We make
That's
it.
okay, that's a general direction. Why was it rejected?
No, no. I am. This is premature release writ petition, ma'am. They have to place the file before the advisory board once he completed 13 years, 6 months. As on 16/7/26, he completed 14 years.
Petitioner is before this court seeking for the following.
Next September, he is.
September. And AGA submit that the case of the petitioner would be placed before the committee in the next meeting to be held in September 2026. The said submission answers the grievance of the petitioner, directing the respondent to place the file of the petitioner before the next meeting of the advisory committee. The petition stands disposed.
Annexure F, GH, this honorable court
ಏನ್
granted,
ಮಾಡ್ಬೇಕಪ್ಪ?
granted parole.
You're not
He's completed his sentence, Mila. I'm passing.
Considering that he is 13 years old, parole of 90 days from 17th August.
49.
Applying for petitioner, my lord. This is emergency parole, my lord. He has already completed 4 years till now, my lord.
My lord.
Custody certificate is
2
page
years,
number
9 months as on
225, my lord.
My lord, but his parole, emergency parole was rejected on 6/7/2026, my lord. Recently, after that, again on 11/7, he has filed for emergency parole. Previously, on 22nd June 2026, this court had rejected his general parole.
Not for this reason. Convicted for life imprisonment, has served 2 years, 9 months, 3 days as on 23/3/26. The petitioner's application for parole was based on certain health problems of his wife, who is required to be treated by antibiotics and symptomatic case approach. Hysterectomy has been ordered.
Pardon me?
Hysterectomy. The doctor has advised hysterectomy to be conducted.
Yes, ma'am.
So that's
I'll just verify, my lord. This is not produced because
a boring hospital.
Yes,
the government hospital.
Because on 6/7, his emergency parole was rejected by this honorable court for his sister. That time they have produced the medical certificate of the sister, my lord.
Aplamma, wife of Somshekhar.
My lord,
This
I'll
is the
produce
mother. This is a wife.
Yes. Madam,
Wife of wife.
his son had filed for this thing, emergency parole, my lord. That was rejected by this honorable court on.
Son had filed, so son can take care of.
Yes, my lord. That was the ground, my lord. The son can take care because he has 2 sons, my lord. And 6/7, this was rejected again on 11/7. They have filed for emergency parole.
Counsel for record was Kiran SS.
I apologize, my lord. This is my proxy. I am proxy. I am apologize, my lord. This is one of my colleague matters I am updating.
Petitioner is before this court seeking for the following. The earlier application for parole having been filed by the son of the détenu has been rejected by this court by order date 6 July 26. For the very same reason, the present application on the very on the basis of the very same reason and seeking for the very same relief, the present petition has been filed without even disclosing the earlier petition. Hence, the petition stands dismissed.
Serial number 50, Pratap basis.
For the petition, page number 8 is custody certificate, my lord.
Page number?
8, my lord. Next year. 8 year, 10 month, 22 days, my lord.
Why was it rejected this time?
My lord, rejected because one case is pending under section 498. Annexure C, my lord, page number 10.
My lord, and 6 months that was not completed, my lord. He was released on parole. He surrendered on 15/1/2026, my lord. He was granted court parole.
7 months over. 15/1/26 is surrendered.
When did you file your application?
My lord, Annexure C, my lord, 8/7/26. They will allow the convict to file the application once he completed 5 months, 15 days.
That is not the reason why you have rejected on account of those pending proceedings.
Please, yes. Earlier also court granted, my lord.
It was rejected on the ground that there are 2 criminal proceedings which are pending against the petitioner. The petitioner had earlier been granted parole, court parole on 4 earlier occasions when there is no complaint against the petitioner. Hence 30 days commencing from 17th August.
60 days.
One,
Like,
Aditya.
Lords, imprisonment certificate at page 16, my lords, 16. Lords. 9 years, 10 months, my lords.
Why was it rejected?
Lords, page 26, annexure D, my lords. The reason for rejection is the second surety has stated that the convict has cut his neck, my lords. That is the ಸದರಿ ಶಿಕ್ಷಾ ಬಂದಿಯು ಕಾರಾಗೃಹದಲ್ಲಿ ಕತ್ತು ಕೊಯ್ದುಕೊಂಡು ಗಾಯ ಮಾಡಿಕೊಂಡಿದ್ದರಿಂದ ಎರಡನೇ ಜಾಮೀನುದಾರ ಹೇಳಿಕೆ ನೀಡಿದ್ದು ಹಾಗೂ ಬಂದಿ ತಲೆಮರೆಸಿಕೊಳ್ಳುವ ಸಾಧ್ಯತೆ ಇದೆ. From 9 years he has not been released on parole.
He has tried to commit suicide.
In the prison, I'll just verify that, my lord.
There are no records, my lords.
Asking for parole was rejected on the ground that the detainee has tried to commit suicide. Detainee having served 9 years, 10 months, 9 days as on 4/7/26. They said statement, they said reason for rejection does not seem to be well founded. It's 30 days from 17th August.
My lords, page 16 is the imprisonment certificate, my lords. 3 years, 3 months, my lords.
3 years, 3 months. Serve substantial.
Please.
53, Pratap basis.
My lords, this is for extension of parole, my lord, on education purpose. And my
Extension.
lords passed an order. It's at page number 12, my lord, operative portion. For 30 days. Now I seek for, yesterday I surrendered, my lord. Yesterday.
This court advised ordered it 22nd June 26. In WP number 15067 of 26, granted a parole for 30 days. That being the first time that parole was granted to the petitioner. His conduct being proper during the time of the parole and the detainee having surrendered on 4/8/2026. And the considered opinion that the parole granted can be extended by a period of 60 days. 60 days commencing from 17th August.
54, Pratap basis.
My lord, this matter for general parole, imprisonment certificate at page number 7, my lord. Out of 10 years, he has completed almost close to 7 years, my lord. 6 years, 10 months, to be precise, he has completed. Now, to maintain family bond, he is seeking for a
Prior to
parole.
the amendment. Why was it rejected?
Because the local informants gave that there is chances again he will be involved in the criminal cases
I think
when
he
they
is
are doing the
Rejected on
inquiry,
the
my lord.
ground that the detainee may involve himself in an offense once again. Considering that the detainee has served a period of 6 years, 9 months, 28 days out of 10-year sentence as on 12/6/26. And the considered opinion that the detinue can be granted parole for a period of 30 days, commencing from 17th August.
55, Pradeep Patil.
My lord, this matter pertains to premature release, my lord, and
It's been
and
placed
has been
on-
recommended by the board.
Board has recommended, my lord.
Board recommended 90 days commencing from 17th.
Obliged.
56, Kiran SS.
For petitioner, my lord, this is emergency parole on education purpose, my lord. He has already undergone 4 years, 2 months, my lord. Custody certificate at page number 10, my lord.
Yes. Whose education purpose?
Daughters, my lord, convict daughters. I have produced the SLC mass card at page number 11, my lord.
Petitioner is the wife.
Yes, my lord.
So why is the detinue required?
My lord,
He's done only 4 years
4 years, 2 months, my lord. Till
for 376 and 4 and 6 of POXO.
Yes, my lord. 15 days, my lord.
Because it was prior to the amendment, it's only has served only 4 years, 2 months, 14 days, considering that he has been convicted for heinous offense under section 376, read with section 4 and 6 of POXO Act in 2012. The same cannot be considered now after completing substantial.
57,
I agree for petitioner, my lord. This is a general parole. He has already undergone 5 years, 2 months, 5 years, 10 months, my lord, till now. Custody certificate at page number 12, my lord.
Why was it rejected?
Pending case.
Where is the order? For 323. Was rejected on account of a pending criminal case in crime number 385 of 2013 for offences under section 323, 354, 504, 506, read with 34 of the IPC. Considering that the petitioner had already served a period of 5 years, 2 months, during which time there's no, as on 13/11/25, during which time no complaint. 30 days commence, first time, huh?
Yes, my lord, first time.
30 days commencing from 17th August.
Much obliged.
hearing on IS, serial number 58, petition party.
My lords, petition for seeking general parole on behalf of a 25 years old guy, my lords. It has been filed on behalf of his mother, my lords. My lord, in this petition, I sought for general parole, my lord, and at page number 7 is the implant certificate, who has undergone close to 10 years, my lord, that is 9 years, 10 months.
Why was it rejected?
It was rejected that I may have enmity with the, it's at page number 10, my lords, annexure C. At fourth line, my lords, if my lords were to see. ತಂಗು ದಿನಾಂಕ 18/1/2001 ನೀಡಿರುವ ಅಭಿಪ್ರಾಯದ ವರದಿಯಲ್ಲಿ ಸದರಿ ಶಿಕ್ಷಾ ಬಂದಿಯು ತಂಗುವ ಸ್ಥಳದಲ್ಲಿಯ ಪ್ರಕರಣದಲ್ಲಿನ ಸಂತ್ರಸ್ತರು ಕುಟುಂಬ ಸದಸ್ಯರು ಕೂಡ ವಾಸ ಮಾಡಿರುವುದರಿಂದ ಸದರಿಯವರೊಳಗಿಂದ ಈತನಿಗೆ ಅಥವಾ ಈತನ ಅವರುಗಳ ಮೇಲೆ ಹಾನಿ ಉಂಟು ಮಾಡುವ ಸಾಧ್ಯತೆ ಇರುವುದರಿಂದ ಹಾಗೂ ಬಂದಿಯು ವಾಪಸ್ ಕಾರಾಗೃಹಕ್ಕೆ ತೆರಳದೆ ತಲೆಮರೆಸಿಕೊಳ್ಳುವ ಸಾಧ್ಯತೆ ಇರುವುದರಿಂದ ಶಿಕ್ಷಾ ಬಂದಿಯನ್ನು
One submission. This is pertaining to Ballari prison, my lord.
Bellary prison.
Yes, my lord. Annexure A.
Bellary prison, appa idu.
Central prison, Ballari, my lord.
You have to go there.
Yes, my lords. But my lords, his appeal and also his trial under section 302 all were been but connected in Bangalore itself, my lord. If my
But
lords
now
were to see at page number 7, my lords.
They'll have to get instructions from there. They can't get it here. Reserving liberty to source. I1 of 26 is allowed.
59, Kiran SS.
Waiting for petitioner, my lord. This filed IA for extension, parole extension, my lord. He has already surrendered on 4th yesterday, my lord, 4th August.
Same surrendered on 4th. Further period of 60 days from 17th August.
Much obliged.
Order, serial number 60.
My lords, in this petition, I have sought for seeking parole, my lords. If my lords were to see at page number 10, I had approached this honorable court only, my lords, and I had been and has already been released on parole. But my lords have had directed me to file the
But bail orders,
Yes.
But this is pertaining to Vijaypur prison, my lord.
Why do you file it here when it is a different jurisdiction?
my lords, is it serial number 60, my lord?
Reserving liberty.
61.
And for the petition, there is one office objection, my lords.
What is the office objection?
Wakalatnam of the convict, my lords. Affidavit is filed by, signed by the mother of the convict.
So the mother is signed the Wakalatnama?
No, my lords, memo of appearance.
Should get the mother to sign. You have to
was
be
overruled,
careful in
my
all
lords.
these things, Mr. Counsel.
It was overruled, but the,
He had availed general parole, my lord, on 6/7/2020.
no, my
See, he
lords.
doesn't have Wakalatnama.
Memo of appearance is filed, my lords.
Memo of appearance has been.
Page 48, my lords. Page-
Memo of appearance we allow when you file, when detenue is instructed. If the mother is instructed, mother should sign the Wakalatam because her verifying affidavit is there. Get her Wakalatam. Counsel for the petitioner seeks for is granted 2 weeks time to comply with the office objection by filing necessary Wakalatam signed by the mother of the detenue. Relist on 19th August.
List number 3, fresh matter, serial number 2, Bhargav Deepak.
Yes.
Relinquishment deed, my lords, without consideration relinquishment deed for single site approval, my lords, by the Bayappa, page number
The
16.
lordship power of that, my lord, there is a, my lord, journal regulations is there, my lord. Journal regulations also there, my lord, regarding them.
When this court has passed orders in so many matters,
Lord.
you still continue to do this.
My lord, my submission is, my lord, pertaining to that, my lord, there is a journal regulation from Bayappa, my lord. Seventeen.
Challenges.
Lords, the impugned order, my lords, does not make any reference to his own regulation, otherwise I would have, lords, interim order and I'll amend, my lords.
We'll record his submission, you challenge this, then we'll quash this particular.
For now, my lords, is urgency, my lords.
ಏನ್ urgency, plan sanction, ಏನ್ urgency?
ಅದಕ್ಕೋಸ್ಕರ. Only for that reason, my lords.
For respond number 2, submit that the demand for relinquishment has been made in terms of regulation, zonal regulation number 17 of the master plan for BIAAPA 2021. Counsel for the petitioner seeks fund is granted.
Lords, 2 days, my lords. Friday, tomorrow I'll have it filed, my lords, and
To file amendment application challenging the said regulation. Relist on 10th August.
till then I own, until
Till
then.
then, hingappa.
Serial number 3.
Tax.
My lord, we are filing memo for seeking to retire, my lord.
My lord,
Seeking to retire from the case.
Who is seeking to retire?
memo.
Petitioner.
My lords,
Yes.
appealing for the petitioner, my lords. We request your lordships to permit us to retire from the impugned writ petition, my lords.
Memo is filed.
In this matter, my lords.
Where is the notice issued to the petitioner?
My lords, we have informed the petitioner and NOC has been given, my lords.
Where is that? Your information in writing and acknowledgement. You have to file that.
I will file the NOC, my lords.
That counsel for the petitioner has filed a memo of retirement. However, perusal thereof indicates that there is no acknowledgement of any notice issued to the petitioner. Counsel for the petitioner seeks for, when will you produce it? You have got his acknowledgement you got his acknowledgement for handing over.
Of handing over the NOC, my lords.
You have the acknowledgement.
Yes, my lords.
Released on 12th August.
Okay.
MS Nagaraja.
Association is open, nobody is here. Yes.
I'm understood it's compromise, my lord. There will memo be filed. I appear for
Pass
one of the
over.
response.
Serial number 5. Suhas PL, corrected by
Last occasion, the GB had been directed to verify the records.
Madam, you are with Indus Law?
I am, my lords, but Indus Law has not filed wakalat in the matter.
Yes, but are you with Indus Law?
Please, my lords.
Then how can we take up your matter when you are appearing without wakalatnama? You should bring it to
My
our
lords, I'm
notice.
instructed by my learned friend, Mr. Suhas, who's been on record. Because the
But you are
matter is-
appearing,
Please, my lords. On instructions, my lords.
not done.
I'll then speak to the client and then recuse it. Because my lords have heard the matter for the longest time.
You
So we
heard.
don't want to come in the way, my lords. I appreciate.
Earlier, some matters when we were told you are not part of Indus Law, we had taken it up. Now you're back with Indus Law is what was told. In some matter, they said they'll serve notice on you. That is how we came to know.
Okay, my lords. No, but only reason we continued, my lords, is because Indus Law has not filed wakalat. The advocates on record are not Indus Law.
If you're part of,
They're instructing, in fact, senior counsels as well. So I'll then take instructions and I will not.
senior counsel is a different issue.
I
not-
appreciate, my lords.
not
I
you.
will not.
The request of the counsel for the petitioner released on 19th August.
Serial number 6. Abhinav.
They will have to, my lord, the meeting could not be conducted, my lord, till now. Lordship may kindly grant us
So this
for
is at
the
Lord, some,
sanction of layout plan.
Hmm.
It's because of the change of officers, my lord, the meeting could not be conducted. Lordship may grant us 4 weeks time, my lord, sir.
4 weeks.
4 weeks time.
4 weeks, Lord. ಸ್ವಲ್ಪ ಲಾರ್ಡ್ಸ್ ಬಗ್ಗೆ
ಹೊಸ ಆಫೀಸರ್ಸ್
ಹಿಂದಿ
ಅಲ್ಲ ಬಟ್ ಬೇರೆ ಡಿಸಿಷನ್ಸ್ ಆಗಿದೆ ಲಾರ್ಡ್ ಐ ಆಮ್ ನಾಟ್ ಸೇಯಿಂಗ್ ಎನಿಥಿಂಗ್
But after your lordship's order, after your lordship's order, no meeting was conducted. If there was a meeting, my lord, this would be a top priority, my lord, on top priority, it will be
It's a
considered.
very old matter.
Yes.
They have been waiting for a long time. The counsel for respond number 2 submit that there being a recent transfer of the officers. If the matter is taken up after 4 weeks, a meeting would have been conducted by then, and the resolution thereof would be placed on record. Released on 25th August.
4 weeks, my lord, sir. First week of September, my lord, sir.
September ಏನು ಅಂತ ಗೊತ್ತಿಲ್ಲ ಅದಕ್ಕೆ.
ಅಲ್ಲ ಇರ್ಲಿ 25th ಒಂದ್ ದಿನ ಇರ್ಲಿ.
Please, if there is any progress, my lord, I'll
25th.
I'll update.
The interim order may be extended.
Interim order earlier granted is extended.
Great.
Serial number 7. Sunil Kumar Patel.
Petitioners. 2013 matter. Back 2013 matter.
Submit the survey report, my lord.
Special order. Oh, this is that.
I'll file it within the course of the day, my lord. It's ready.
So it's been
It's
done.
ready. It's ready, my lord.
You're giving them copies.
No, my lord. I've just received it now. He's come now.
And AGA submit that he has just received the survey reports. You'll be furnishing copies thereof to the counsel for the petitioner as also the counsels for the respondents.
Have it on Monday.
You'll furnish it today, by the end of day today.
Any day then.
If any to the report to be filed by 14th August, released on 18th August.
By 2:30, my lords, please.
2:30, please. Special order, so.
Serial number 8.
Appear for the
Yes,
respondent.
where is Mr. Ashwathappa? Mr. Ashwathappa, it reached today.
ಗೋವಿಂದ ಗೋವಿಂದ ಅನ್ಬೇಕು ಅನ್ನೋ ಪರಿಸ್ಥಿತಿ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಯಾವಾಗ ರೀಚ್ ಆಗತ್ತೋ ಅವಾಗ ಅಷ್ಟೇ.
The government is to
Mr. Pujari, you are appearing in this.
ಇದರಲ್ಲಿ annexure R.
Who is appearing from the state?
Lord, some affidavit is supposed to be filed. My colleague is unwell. He hasn't come today. My lord. But the affidavit is, can I request for a pass over, my lord? I'll just verify.
ನೆನ್ನೆ ರೆಡಿ ಇದೆ ಅಂದ್ರು, ನಾನು ಕೇಳಿದೆ, ಅವ್ರು ಕೊಡ್ಲಿಲ್ಲ. Okay.
Can I request for a short pass over, my lord?
Pass over.
Please.
Pass over ಮಾಡಿದ್ರೆ ಅಶ್ವತ್ಥಪ್ಪ ನಮ್ಮನ್ನ ಹಿಂಗ್ ನೋಡ್ತಾರೆ.
Let's so urgency, my lord. Otherwise, I would never
My colleague is unwell, my lord. He is handling it. I'll just look at it.
Pass over.
Lord, on the last occasion, I made a mistake in making a statement that, my lord, the modified sanction plan was applied. In fact, my lord, what I had to, my lord, ಇಲ್ಲಿ ಇಬ್ರು ಬಂದ್ಬಿಟ್ಟು ನನಗೆ ಒಬ್ರು ಆ ಕಡೆಯಿಂದ ಒಬ್ರು ಈ ಕಡೆ ಅಂತ ಹೇಳಿದ್ರು. I made a mistake. We had to file, my lord, an application, my lord, for regularization under section 249 of the GBA Act, my lord, that provides for it. Can I, my lord, just pass on the GBA Act, my lord? That we have now filed.
Mr. Kambi?
Can I?
Umkas sir has some personal inconvenience, my lord. Sir has sought for adjournment, with short adjournment. May I?
There's a party in person appearing, there's a senior counsel appearing.
Some personal inconvenience.
Lord.
because our-
In the previous occasion, they were given time till 30th to file any written objection. Otherwise, it would be proceeded as per
Filed
the
a report,
documents. A report was submitted long time ago in February.
There's some personal inconvenience for a counsel.
Yes, my lord, the junior is there. It can be taken up with the documents on record.
Mr. We
to
have
request
warned
you,
you,
my lord.
we have warned you last time.
My lord, I'm talking very softly, my lord.
You are a party in
No.
person doesn't mean you can ride roughshod.
Oh, my lord, I'm talking
Counsel who is
softly.
having
I'm
a personal
requesting the bench.
inconvenience,
It's been 8 months since this petition has begun.
yes, we'll post it after 8 months.
My lord,
You should know your limits when a counsel has some personal inconvenience. If you are a lawyer, you would have known the decorum of the court and the courtesy that is to be extended to a counsel. Shri Udayadal and senior counsel submits
my lord, can I make
that
small
on
request, my lord?
21/7/26, instead of making a submission that an application for regularization had been
Has to be
made
filed. He is required to be filed, my lord.
on, has to be filed under section 249 of the GBA Act, he had made a submission that an application for modification of plan would be filed. His submission is placed on record. Now you have filed it.
My
You
lord,
submit that the said application for regularization has already been filed. Though the party in person opposes an adjournment requested for by counsel for respondent 1 to 3 on account of personal inconvenience of the said counsel, the said opposition is rejected. When? Friday?
Yes, ma'am.
Released on 7th August.
Yes.
my lord, I have submitted a memo. Is it on record, my lord, after the affidavit was filed? The section 214 is not operative, my lord.
Yes, we'll hear them once he's there.
Yes, my, yes, 7th will.
Interim order
Much
extended.
obliged.
Interim order earlier granted is extended.
Yes, great.
Why 4 matters, Keshav?
My lords,
Same
because
petitioner?
this senior roster,
No,
all the-
same. Oh, that is one.
there are 4
KLR and there are 4
KLR
petitions.
matters.
Mr. Pujari, you are appearing in this.
My lord, except in one matter, my lord, I am ready, my lord. Except in one matter. That the different regions of forest, my lord. It's not belong to the same division. So first matter 1360, my lord, I am ready. And second matter, my lord, encroachment of forest land.
Lords, there is no encroachment. I'll take my lords through the facts.
Yes.
Lords, if I
Which petition do we need to take?
my lords, if my lords can take 1360 of 26.
First one, 1360.
First one
yes.
itself, my lords.
Hmm.
The petitioner is the owner of survey number 19, measuring 80 acres, 20 guntas of land, situated in Kodgebailu village, Tirthali Taluk, Shimoga district. Now, my lords, in 1914, a K2R is issued in the name of the petitioner, and subsequently an RR6 and RR5 are also standing in the name of the petitioner. The RTC as of today is also in the name of the petitioner. If I may take my lords to the RTC, my lords, which is at page number 69 at annexure B35. Page 69, annexure B35.
69. Yes.
My lords will find that Bhimanakatte Mata as the first entry in column number 9 as measuring 80 acre 20 guntas. Subsequently is Kodgebailu village, which is 13 acres, and Lakunda Minor Forest, which is 20.
Aranya, 13 acres.
13 acres, and the other one is Lakunda Minor Forest, which is 20 acres. The entire extent of land, my lords.
No, it's wrong what you're reading. The petitioner 80 acres, 20. Lakunda Kiri Aranya is 13 acres.
Lakunda Forest is 13 acres. Kodgebailu is 20 acres.
Is the reverse.
Is the reverse. My apologies, my lord.
Yes.
The survey number, my lords, will find at column number 1. Survey number 19, totally measuring an acre of 120 acre, 5 guntas of land. At column number 3, my lords.
acres, 5 guntas, yes.
120 acres, 5 guntas.
Yes.
Now, with these facts, my lords,
So
the
80,
petitioner
100,
kindly
just a minute. 80, 100,
120 acres.
13 plus this 6 acres, 25. Yes.
Please, now, my lords, the RTC with respect to what the position was before, that is from 1969 till about 1979, was that the petitioner's survey had a different Hissa number altogether. And that is evidenced at page number 35.
35.
At column number 1, my lords will find survey number 19, bar 1.
This is 6970.
Page number 35, my lords.
Yes.
Column number 1, survey number 19, bar 1, measuring 80 acre 20 guntas in the name of the petitioner Mata. This was the position as of 6970 till 7475. At the bottom of the page on the left hand side, my lords will get there.
1969 to
7475.
To 78, 79.
Please, my lords.
Next page also.
Even subsequently.
To 78, 79. It is 80 acres, 20 guntas.
Please, my lords.
Yes.
Now what transpired is they merged all the survey, all the Hissa numbers in respect of survey number 19 into one survey number, which my lords will get at page number 38, sometime in the year 1980.
Was the notice issue? This became 19.
It became 19. No notice was issued. We in fact issued representations asking for it separate Hissa number and a different entry altogether to be continued as it was earlier.
So this is merger of all sub numbers of survey number
All
19.
sub numbers of survey number 19, which my lords will get at column number 3, if I'm not mistaken, my lords, 120 acres, the total extent.
Yes, 120. But where is the order reference? Was there any order passed for this merger?
No, my lords, we are not aware, or we don't have a copy of that.
This is 84, 85. Column 10 has a GO number reference.
My lords, we were not able to get hold of that MR number, my lords.
And MR7 of 78, 79. Yes.
My lords, subsequently, my lords, we issue representations to the respondents for the rectification of the khata and different bifurcations. Subsequently, as representations were not adhered to, we preferred.
Did you submit that?
My lords,
Immediately or much later?
my lords, immediately, but I'll just.
Yes, proceed.
We had issued, my lord, I'll take my lords to that one document. Subsequently, what transpired, my lords, is that we preferred a petition before this honorable court. My lords will get that at page number 82, my lords.
Yes.
For a different PODI and a survey to be conducted.
This was in 24. Yes.
Page number 82. Lords, the operative portion, my lords, will get at page number 89. On the basis of this, my lords, a survey was conducted. Though I had informed the respondents that my representative would come, without my presence, they conducted a survey. And they claimed to be the owners of the entire extent of land.
All interest stakeholders shall be notified, and any objections during the survey shall be, you are notified?
I was notified. I put my representative on the spot, my lords. Initially, I had also preferred a petition before this court seeking a mandamus for police protection. This court had granted police protection as well, pursuant to which the survey was conducted.
Police protection for what?
Because there were a lot of locals who were creating issues for conducting of the survey. So pursuant to which a survey was conducted, during this, pursuant to them drawing up the survey sketch, they claim that the entire extent of 80 acres is the land of the government on the basis of a notification of 1932. If I may take my lords to that notification, my lords. My lords will find the notification at page number 115.
The typed copy available? Yes.
Typed copy is there, my lords. It's at page number 117. This is for Lakunda Minor Forest. At page number 117, my lords. Survey number 19, my lords will find. It's in the middle portion. Survey number 19 is 13 acres of land.
Yes.
Subsequently, my lords, and kindly take page number 123, my lords, which is the other notification that they refer to.
123.
123. Which is for the Kolge Bailu Minor Forest. My lords will find the first column in the as survey number 19, measuring 20 acres of land.
The same survey number is in both the...
In both, my lords. 20 acres and 13 acres is what is there in terms of the notification. I am not on that line at all. Now, my lords, kindly take the survey report, the survey sketch, my lords. We'll find it at page number 139. The survey sketch says that the entire extent that I own of 80 acre 20 guntas is also a forest land.
So entire survey number 19 measuring 120 acres, 5 guntas.
Is forest land.
Forest land.
Is on the basis of this survey report is why I'm before my lords. That they are going beyond the notification and their own records to say that I am the owner of the land
Yes.
to claim ownership of the property, which is why I have sought for setting aside the survey report and consequently my fresh POD to be done and a fresh survey with respect to my extent of land.
You asked for certiorari.
To quash the survey report, my lords.
Annexure A you asked for quashing. Not annexure.
Annexure A is their notification,
Annexure A is
endorsement, my
challenge.
lord, saying that
Annexure
the entire extent of land is theirs. Annexure A is at page 26, my lord.
That's what challenge.
You're not challenging the survey report. You're challenging only this
My lords,
endorsement.
in 1360, I have challenged this. In 16125, I have challenged the survey report, my lords.
So 1360 is
The endorsement.
endorsement.
In 16215, I have challenged the survey report.
Yes. 6398.
And in
17925.
for the representation, my lords, that there is an internal communication between the forest department to say that this is a forest land,
What is the prayer in 17925?
to set aside the representation dated 9/6/2025, where they on the basis of the survey report they say kindly change the RTC to the name of forest.
And what is 162, oh, sorry, 6398?
My lord, 6398 of 24 is a different parcel of land that is concerning 1081 acres of land. Initially, there were 79 AB proceedings that were initiated against the petitioner Mutt, and on the basis of which we had preferred a petition before this court. This court, in view of the ordinance and the 79 AB being repealed, allowed our petition.
The acres is part of 107?
No, this is not part. This is a completely different extent at a different location altogether. That is a different portion of land, and that is a different extent and a different located in a different place altogether.
Why are all these matters connected to each
Which is the same, my lords, they were connected because all of them belong to the same petitioner Mutt. So there was a mistake by the.
You may own some other land in.
My lords, this is my submission on the first day when this
Delhi
matter.
or somewhere. That cannot.
I understand, but.
That is what about 600 acre in another place. 600 acre. No title at all. No,
My lords,
no height of title.
Insofar as that petition is concerned, I can argue it right now.
An order passed, yes. Yes, go ahead.
My lords, if my lords could take.
Yes.
My lords, if my lords could take the 2024 writ, my lords, that.
6398.
6398, my lords.
6398, buddy. Yes.
My lords, in 6398, my lords, it was purely filed for the purpose of a writ of prohibition because they were interfering with the possession of the Mutt over the extent of land. Now, my lords, kindly take Annexure A, which is an RFA order passed by this court, which grants title as well as possession of the entire extent of land in favor of the petitioner Mutt. And this is dated 16th April 1970, and it has not been challenged or set aside, and it is still binding on the state. My lords, the schedule also is very different. At page number 15, my lords will find the schedule.
Page number?
Page number 15, my lords will find the schedule that I have
15.
1-5
That is of the petition.
of the petition. I'll take my lords to the judgment as well. My lords will find the decree at page number 61, my lords. Relevant portion is at page number 64.
What is the decree?
586 acre, 27 guntas, situated in so-and-so village, and another extent of land which is about 494 acres, situated at a Kudge Malige village, which are two different extents.
Suit was for?
My lord, suit was for declaration injunction, which came to be dismissed, and on that basis there was
allowed.
And on that basis an RFA was preferred, which came to be allowed.
You are declared as absolute owner of land described in item 2 to 4 of plain B schedule.
B schedule land. There was no issue with respect to A schedule land.
And to cause rectification of entire in respect to schedule land except for the lands of item number 1 of schedule B. So schedule B is Kardumalige village, Tirthalli.
Kadu Malige village, which is about 494 acres of land. Total extent at page 65, my lords will get the extent.
That is the total. Kardumalige is 22 acres, Bakse, Kenchigadde.
Base Kanchigadde and Dabbana
Dabbanagudde Mattu Hobli. Yes.
Mandagadde.
So these.
So, my lords, this is a different issue altogether.
Not the same.
Not connected with the other three at all. Now, my lords, in this what had transpired was there were 79 AB proceedings pending before the Karnataka Appellate Tribunal against the petitioner. Now, my lords will get that at assailing that order, my lords will get that at page 134, annexure G. Assailing that order, my lords, we prefer a writ before this honorable court at page number 358, my lords, annexure H is the order passed by this honorable court.
Yes.
My lord, the operative portion, my lords will get at page number 364, my lords.
.364 is reasons.
Is the reasons, my lords.
Yes.
The operative portion, my lords will get at page number 369, last para, my lords. In the above circumstances, the writ petition succeeds. A writ of certiorari issued quashing the impugned orders. That is the Karnataka Appellate Tribunal's order dated 29/1/2021, entered in so and so. It is hereby declared that the appeal proceedings and all the original confiscatory orders from which the said proceedings arose have abated by operation of law, and as a consequence, petitioner's possession and title to the land in question have been rendered cloud-free. Now, pursuant to which, my lords, the state prefers an appeal before this honorable court. This honorable court dismisses the said writ petition, the writ appeal, my apologies. And against the order of the division bench, there is an appeal pending before the Supreme Court.
It's pending.
It is pending.
Hmm.
I haven't produced that in this writ because at the time of filing of this writ, those proceedings were not challenged.
But you could have filed it subsequently. The writ
I
appeal
believe
order,
I've filed a memo.
writ appeal was dismissed. Any stay by the Honorable Supreme Court?
My lords, there is an order not to alienate the property in question is concerned.
By you?
By both of us, by the respondents and the state.
Yes.
And that is all that is pending there. Now, insofar as what the survey and my extent in survey number 19 measuring 80 acres is completely different. So
You don't interfere with their position until Supreme Court decides.
My lord, that's why in the beginning only regarding that second writ, my lord, what is arguing, my lord, I said, my lord, requested my lord to defer. But I am ready in 1360, my lord, first.
This is a batch matter. You can't be saying that.
No, it is
ready in
separate.
one.
Lands are totally separate. They're not the same region also. Different things.
It
My
has
lord,
been
not that.
connected and it's come before.
Not that, not that. My lord. That one particular petition may be kept, my lord, parted. It could be parted. But other things I'm ready, my lord. First petition. That is pertaining to Tirthahalli. This one is Tirthahalli.
all of them are in
They're different.
You finished that and
1360, lord.
that is simple. That's all right.
this petition, this is all there is.
Even the others is also that.
That is all, my lords.
That's
I've
your
taken my
argument.
lords to all the documents, including the
1360,
notification.
man.
The notification is very clear that it is only 13 acres and 20 acres of land.
Yes.
My lord. Though the forest notification, my lord, produced, my lord, I filed the statement of objection.
In which matter you filed?
The 1360, my lord.
1360 you filed?
Yes.
1360 is the first one. Alidiyanama?
Adala.
6398 there's objection.
1360.
Did you file?
They've also filed
That's all.
objections in
28,
161.
28-4. My lord, 26. Madam, Idu.
We don't have it here.
You have the copy.
ಇಲ್ಲ ಇಷ್ಟೇ ಇದೆ ಅಲ್ಲಿ ಮಿಕ್ಸ್ ಆಗಿದೆಯಲ್ಲ You filed it when, Mr. Pujari?
28-4, man.
Learned counsel for additional advocate general submit that statement of objection had been filed in WP number 1360 on
28-4, man.
28-4.
For
Not have
26.
I been served the copy, man.
You've not been served.
I haven't been.
ಕೊಟ್ಟಿದೆ. Sir.
ಇಲ್ಲೂ ಇಲ್ಲ ನಮ್ಮ ಹತ್ರ ಯಾರಿಗೂ ಕೊಟ್ಟಿಲ್ಲ. But here's the seal there. So. Serve a copy on him also. When filed on 28/4/26, registry is direct put up the same. Counsel for the petition submit that he has not been served with a copy of the statement of objection. And AGA is direct to serve a copy of the statement of objection on the counsel for the petitioner. What about 10.1 then?
My lord, 10.1 is
Objections have been
insofar
filed.
as the survey report is concerned.
That is here.
My lord, in that petition, my lord, second petition.
You wanted time now. You're getting time
Addition.
for other reason also.
Additional.
Taken as
Actually,
part
additional
of-
statement.
You want to file additional statement?
Yes, ma'am. Very soon I will file.
10.1.
Can it be taken as part heard, Manoj? Because I've addressed.
It could be, my lord. But in fact, it's covered by,
Parted matters.
it's covered by lordship judgment regarding boundaries.
What parted? No. You argue.
Please, grateful.
That AGA seeks for and is granted.
My lord,
How much time?
week time.
A week's time to file his additional statement of objection. 10.1. 10.2.
10.2 is, my lord, it's incidental things, my lord, no problem.
You want to file separate?
No.
They have already filed statement of objections
Yes,
in
it's filed,
10.2.
ma'am. It's already filed.
10 point. You want to file any rejoinder?
I'll seek instructions. Manoj.
10.3.
Same
My
thing,
lord,
no problem. We have
10.3
filed.
is the, 10
Rejoinder, if any, to the statement of objection
Please,
filed in
I'll seek
10.2
instruction.
and 10.3 within 1 week's time from today. Relist on 18th August.
Manoj, can it be had on 17th, 18th, some
18th, 19th.
17th.
18th and 19th, some inconvenience.
17th.
Grateful.
17th, Mr. Pujari.
May I request? 20th minute.
20th.
Yes.
Grateful. Manoj.
20th.
Serial number 11,
ಈ ಫೈಲ್ ಮಾಡಿಲ್ಲ.
connected matters.
If the petition
ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
this is also a challenge to the constitutional validity of 41, my lord, of the Consumer Protection
My lord,
Act. We
In
permitted
earlier petitions, my lord, it is stated, so I am not sure whether the office has filed it or not, my lord. Statement of objection. If it's not filed, I will file it, my lord. Because
ಯಾವ್ದ್ರಲ್ಲಿ?
at the earlier petition ಅಲ್ಲಿ.
Then file it. If
Please.
not filed, file it.
Please.
Yes, 11. You challenge the constitutionality of what?
to be permitted to impede the union.
The Consumer Protection Act.
Please. The other matters
Challenge the constitutionality in all of them.
in 11, my lord,
Only 11.
please.
The constitutionality of section 41 of the, not been decided in any matter? 41?
Lord, there is one matter, my lord, but that pertains to section 67, my lord, where
41 has been considered, any challenge has been made to 41 earlier?
not by this honorable court, my lord.
Any
67,
court is fine, it's central enactment.
I'll look into it. My lord. 67, my lord, the
Command
Supreme Court has,
says final order will be binding everywhere.
the appeal to the Supreme Court, my lord, in section 67, my lord, and the mandatory statutory deposit was considered over there.
Has 41 been challenged,
No.
Gaurav? Not been challenged. The constitutional validity of section 41 of the Consumer Protection Act 2019 has been challenged. Counsel for the petitioner has filed an application to implead the Union of India represented by the Ministry of Department of Food, Civil Supplies and Consumer Affairs. Learned issue notice. Since the constitutionality has been challenged, issue notice to learned Attorney General. Learned ASGI accepts notice on his behalf. Who is there from the Senate?
I am appearing for R3.
R3. Central Government Council, yaar idhar. Any Central Government Council?
Aditya Singh. Aditya will take
The ASGI will have to take it. So
He'll inform
the
him.
Aditya Singh accepts notice for the proposed respond number 5. The others have been served, yes. R3, AGA for R1. Yes.
Your Lordship.
Counsel for the
The
petitioner
others
to
are
serve
served.
One
two sets of the
submission.
petition along with annexures on the said councils. Objections, if any, to be filed on or before 25th August, released on 2nd September.
One submission, my lord. This constitutional validity of this section 41 of the consumer this act was challenged without arraying the Union of India as a respondent in this case. This is a central act.
Correct. That's why now he has filed an application.
Yeah.
He's filed an application. Released on 3rd September, interim order earlier granted is extended.
Your
Just may be
Lordships.
tagged along.
Connect with so and so.
Your Lordships, and the counsel for the petitioner in 11.1, Your Lordships.
Yes.
I have recently filed my wakalatnama. Please kindly grant me 2 weeks to comply with the objections.
All of them will be on the same day.
Interim orders may be extended.
Extended, madam. You're not listening.
Obliged.
What about 11.2? You have to make payment of process fee.
11.
In both of them, you have not made payment of process fee.
Mine is 11.1, Your Lordships.
Both in 11.1 and 11.1, you have not made payment of process fee.
Yes, Your Lordships, I'll do it.
Counsel for the petitioner is granted 2 days time to make payment of the process fee. If process fee is not paid by 7th August 2026, the petition would stand dismissed for non-prosecution. If process fee is paid by 7th August, issue notice to respondent. You will appear for respondent?
Yes, sir. Respondent number 3.
You will appear.
Respondent number 3, I am appearing. Filed wakalat.
Allapa 11.1,
Alla, other
31041 al appear ಆಗ್ತೀರಾ?
10335.
Issue notice to respond number 3, returnable by 3rd September. 11.2 also process fee has not been paid, Gaurav.
Respond number 2.
Hmm.
I'll do the next.
Counsel for the petitioner seeks one is granted 2 days time final to make payment of process fee. Same order. If 7 not paid, if paid, returnable by 3rd September.
Obliged.
Connected matters.
Vinay Venugopal. Vinay Venugopal.
The interim orders may kindly be explained.
Serial number 12.
My lords, I am for respondent 1 and 2 in this matter, 1 to 3 in this matter, my lord.
My lords, this is the matter
I have
pertaining
been
to.
served to IAS, my lord. I am not getting which is IA 1 and 2. I need to file objection. I am,
My lords, 1 month's time was matter.
both the IAs are same dated, my lord. I am little bit confused.
If I may give some context, my lords, this was a matter
You
where.
give the IA number for him to
Please, my
file
lords.
objections, that's all. So that I'll file objections in 1 week's of time. Write it properly and give it.
Please, my
Counsel for respondent 1, 2, 3 seeks for and is granted 2 weeks time to file a statement of objection. Released on 25th August. Obliged.
March 13.
I appear for the petitioner in the case, my lords. My lords,
Party in person.
yes, my lords, a party in person has filed an pleading application along with certain documents, my lords. Having gone through the said documents, my lords, lords, I request for 2 weeks time, lords. I have to place certain documents on record. I have to procure certified copies of it.
You are the impleading applicant.
Yes.
Have you got Form C?
Yes.
You had gone before the party in person committee?
Yes, sir.
Bandidya, Form C.
I also allowed, sir. I have filed an account of 2 copies. Sir, can I proceed?
Form C Bandidya, ma?
Yes, sir.
Bandidya certificate. ಯಾವತ್ತು issue ಮಾಡಿದ್ರು? Any idea?
No idea, sir, but there was a little objection was there in the file. I separated, no objection.
But you are sure it has been
Yes,
issued?
sir, yes, sir.
Uma
Yes,
C,
sir. Yes, yes.
party in person
I know,
submit that
ಮಾಡಿದ್ದೀನಿ, sir.
Form C has been issued by the party in person committee. The same is not found in the file. Registry is direct, put up the same. You want to file objection to the impleading application?
My lord, I have to file my objection to the implementing application.
Is a disposed matter.
Your lordship.
Madam, this is a disposed matter. We had only listed for compliance by them.
Lords, if I may submit, my lords. My lords, the matter was disposed of. The file was kept for compliance. My lords, the kata
Yes.
was issued in my favor. Well, my lords, after
Hmm.
issuing the issuance of such a kata, the impleading applicant, my lords, before this court filed objections for the above said kata. My lords,
Hmm.
later on, the Greater Bengaluru, my lords, has passed an order on basis of the objections, my lords, wherein kata has been kept in abeyance for time being. My lords, there are certain things that I have to bring on record because, my lords, the documents produced by the impleading applicant before the court are cherry-picked documents. Plus, there were 2 execution petitions. The entire order sheet is not come on record. So kindly, my lords, have it
I
sometime
already filed, sir.
sometime later in second week, after 2 weeks, my lords, so that I'll be able to file my objections along with certain documents, my lords.
Excuse.
Madam, this is a disposed matter where we have issued a mandamus directing them to consider the representation. That representation has been considered and some orders have been passed. You can't now come on record as a impleading applicant in a disposed matter.
Yes, sir.
If you are agreed by it, you'll have to challenge it.
Yes, sir. I'm ready to do this.
Challenge
I
ma'am.
have all the documents with me, sir.
Then we'll dispose of your application, giving you liberty to challenge the order.
No, sir. Can I continue in this court hall, sir?
Dispose ಆಗಿದೆ ನಾವು ಹೆಂಗ್ ತಗೊಳಕ್ಕೆ?
ಸರ್ ಯಾಕೆಂದ್ರೆ ಅವರು ನನ್ನ ಸಪ್ರೆಸ್ ಮಾಡಿದ್ದಾರೆ ಸರ್, ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ. ಆಕ್ಚುಲಿ ಅವ್ರು ತಗೊಂಡಿರೋ ಕಂಟೆನ್ಷನ್ ಏನಿದೆ, ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಪಿಟಿಷನರು, ಐ ಹ್ಯಾವ್ ಪರ್ಚೇಸ್ಡ್ ದ ಲ್ಯಾಂಡ್ ಫ್ರಮ್ ಚೌಡಮ್ಮ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಒಂದ್ಸತಿ ಡಿಸ್ಪೋಸ್ ಆದ್ಮೇಲೆ we can't allow you to implead and again take it up. You can challenge this order or you can file a review. You can't file.
ಬಟ್ ಏನಾಗ್ತಿದೆ ಗೊತ್ತಾ,
You are a lawyer by profession?
ಎಸ್ ಸರ್.
ಮತ್ತೆ
ಆಕ್ಚುಲಿ ನಾನು ಏನ್ ಹೇಳ್ತಿದ್ದೀನಿ ಅಂದ್ರೆ, ಬಿಕಾಸ್ ಆಫ್ ದಿಸ್ ಆರ್ಡರ್ ರೈಟ್ ನೌ ದಟ್ ಖಾತಾ EPID number but stood in my name without my knowledge.
Madam, you are on the facts, we are on the law.
Yes,
If
your
you are,
honor. But
you
ಏನಂತ
should know the difference between the fact and the law.
yes sir,
Alva?
but without notifying me, they have taken my name
and they have
We are not in the advisory jurisdiction. We can't advise you what to do, but what you have done is wrong ಅಂತ ಹೇಳ್ಬೋದು. ಅಷ್ಟೇ ಹೇಳ್ಬೋದು.
but last time
This
you
impleading application is a disposed matter. We are not aware of it being disposed. We'll dismiss this
filed the
impleading
review.
application. You will reserve your liberty to avail any remedy that you choose.
yes
IA 1/26 has been filed by the party in person to implead in the present proceeding, which had already been disposed by order dated 20th January 26. That being so, liberty is reserved to the petitioner, to the impleading applicant to avail such remedies as are permissible under law. IA 1/26 stands accordingly disposed.
Serial number 14. Narendra Babu.
IA 1/26 is allowed.
Request, my lords, to take it up 14.1, my lord.
Non-amendment and non-filing of amended cost title. Mr. Narendra
That is
Babu.
in another writ petition. As far as in 14.1, my lord, I had filed.
Let's do 14 first. The non-amend, Mr. Narendra Babu Eli. You appear for Mr. Narendra Babu.
Yes, my lord. There is a small
Have you
clarification.
carried out the amendment?
What happened in the Lord? My lord. In earlier writ petition filed by the Lord, the petitioner really. Lord, the impleading proposed respondent was Shivaji. Petition number, my lord, 6613 of 2025.
28/7 order coding.
My lord, there are two pleading applications are there, my lord, in that.
No, this is 14.1. One by one Mr. K.V. Shivareddy and another is my lord
Anantakirti.
Anantakirti. That's where, my lord, the confusion was caused last date of hearing also. 14.1, they are speaking of impleading of.
I will make my submission, then you ask me. What happened, my lord? In earlier petition, Shivareddy's impleading application has been rejected. Again, he has come before this court, therefore my learned friend has submitted a submission that has to be rejected. Whereas my application.
Mr. Jagdish, IA 2/26, which came to be allowed on 28/7/26, in 34112 was filed to implead the deputy commissioner.
Yes.
That application has been allowed.
That in another petition.
Not in another petition. You filed it in 34112.
Please, my lord, in that petition.
Yes. 34112, it has been allowed. Deputy commissioner has been brought on record. So you have to carry out the amendment and file amended cost title. Now 14.1.
Number
in this
1192.
In this, my lord, I have filed objections to
Two
the.
IAs were there.
There is an impleading application filed by one Lokesh Kumar.
Yes,
For that I have to
Lokesh
file
Kumar.
objections, my lord, because there was no copy served on me.
One is by Anand.
Lokesh Kumar.
I appear. Yes,
Good morning.
For that I will, I may be permitted to file objections, my lord, because two applications
Anand
were there.
Kirti also I have filed. What happened, my lord? In Anand Kirti, my IA has been filed.
Shetty ಅಂತೆಲ್ಲ ಹೇಳಿದ್ರೆ ನಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ. ನೀವು IA number ಹೇಳಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ.
IA number 1.
IA number 1.
Yes.
What has happened to IA number 1? In
IA number 1 for impleading.
That copy, my lord, I got just now. I may have to.
What Mr. Jagdish is saying is there are two applications, IA 1 and IA 2. IA 2 is filed by Mr. Lokesh. IA 1, what happened?
IA 1 is pending consideration before my lord. What happened? In earlier writ petition number.
11992 ಕೊಡಿ.
Lord, in Annex A, L may be kindly be taken, my lord. My IA has been rejected. On the ground that earlier round, my lord, my IA was rejected.
There is no order
Not
of
that IA.
rejection. There is no order of allowing. There neither is an order of rejection.
That's
IA
where, my
1
lord.
ಮೇಲೂ order ಇಲ್ಲ, IA 2 ಮೇಲೂ order ಇಲ್ಲ.
That's where, my lord, I have
For
filed
order sheet.
objections to one IA.
ಆರ್ಡರ್ ಇಲ್ಲ ಅಂದ್ರೆ ಪರವಾಗಿಲ್ಲ
ಏನೂ ಇಲ್ಲ
ರಿಜೆಕ್ಟ್
ಇಲ್ಲ.
ಆಗ್ಬಿಟ್ಟಿದೆ.
IA 1 ಮೇಲೂ ಆರ್ಡರ್ ಇಲ್ಲ, IA 2 ಮೇಲೂ ಇಲ್ಲ.
That's where, my lord, for one IA I have filed objections. Another IA will have to file objections.
Madam, either you argue or let your senior argue. You don't need to raise your voice when your senior is there. IA 1 ಏನ್ IA 1 ಇದೆಯಾ ಅಲ್ಲಿ?
ಪೆಂಡಿಂಗ್.
ಇಲ್ಲಿ ಪುಟ್ಟಪ್ ಆಗಿಲ್ವಲ್ಲ?
On 28/7 there was an order, my lord, passed by your lordship.
28/7 was passed in 34112 allowing the deputy commissioner.
No, my lord, it was, they were permitted to assist the court. Application was disposed of accordingly. That is IA number 1 of 2026, my lord. IA 1 of 2000 has been filed by proposed respondent claiming that he is the resident of
So IA 1 has been allowed. Not allowed, but he's been allowed to come on. Where is his name shown?
Another IA have filed objections, my lord.
IA 1 has been filed by Kavyashri.
Yes, my lord.
As intervener. Yes, she is there. Kavyashri.
She is my colleague.
Good. Lokesh Kumar, you want to file your objections?
Yes.
On merits, I have one submission. After my lords
Let
consider
us
the IA.
sort out this.
Yes.
14, IA 1 of 26 is allowed. Counsel for the petitioner seeks fund is granted a week's time to carry out the amendment and file amended cost title in WP 34112 of 2025. 14.1, learned counsel for the petitioner seeks fund is granted a week's time to file a statement of objects. Yes, Mr. Roll.
Our IA, my lord, which has been filed, we are my lord, requesting the court to implead Ananta Kirti.
No, you are.
IA number 1.
Ananta Kirti came.
Yeah.
You want to come on record to protect?
Please, my lord. They have not filed objection for this.
We have passed orders on IA number 1.
They were
IA
permitted
number
to
1
assist the court.
On 28/7, we have passed the
Yes, my
orders.
lord. On the
We have
submission-
permitted you to come on record as an intervener to assist this court.
Please, my lord.
So it is
Because
disposed.
what happened, Lord, my learned friend has made a submission on the earlier round in writ petition number 66613. Another IA has been also filed by one Shiva Reddy. There, my lord, the IA was rejected.
We have not rejected your IA. We have allowed you to come on record as
Yes,
an
I fully agree,
intervener
my
to
lord. I
assist.
fully agree. My lords have given a liberty to assist us.
Ashte.
But what happened was, based on the submission on the earlier occasion made that my IA was rejected. Therefore, this court has held. It was not so. It is one Subba Reddy IA was rejected.
We cannot permit anybody and everybody to come on record as,
Yes, my lord.
otherwise
That
the
what
whole
we-
of
so
your
we will
district
assist.
will be
We will
here.
assist, my lord.
You
As
want
an
the entire
intervener, my
district to
lord.
come?
Please,
You want to file a public interest
No,
litigation,
no,
you
no,
are free
no.
to do.
As an intervener, my lord,
Ashte.
we will assist.
And you will be assisting Mr. Ron.
Please, 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 I agree.
We don't need to certify, but he is perfectly competent to take care of.
Same order could be passed against Mr. Vishwanath.
As
Agrees
far as
because we stand
my
on the
writ
same
petition
footing.
is concerned, my lord, I have preliminary submissions to make, my lord. In
On your writ
pers-
petition or on the IA?
IA I'll file objections, my lord. As far as one IA, it has been disposed of. Another IA, your lordship
But
has,
Mr. Reddy is saying the same thing would apply to him.
Assist the
He
court.
can also assist the court.
that I leave it to your lordship.
Let him assist. Instead of these formalities, we can get to the merits of the matter.
Yes.
But because the IA was specifically, the impleading application was rejected on an earlier proceedings, in pursuance of which final order has come
You
to be
can
passed.
argue all those things. We
Yes, ma'am.
consider
We'll assist.
him
Yes,
to
let-
assist.
let them.
Yes.
And this we are only allowing because it's forest land. Otherwise, you
Yes.
would not have
We
allowed.
would not have had it.
IA 2 of 26 has been filed by one other person wanting to come on record to protect the forest land. For the very same reasons as that passed in respect of IA number 1 of 26, the impleading applicant is permitted to assist this court as an intervener. It's made clear that he is not brought on record as a party to the proceedings. Yes, Mr. Ron.
But, Lord's 10th or this one, because there are two survey numbers which are involved. Survey number 1 and 2.
Housekeeping early, not.
Nothing, my lord. My date can be fixed at the earliest.
When will you file
My only
your
request.
synopsis of dates
Next
and
week.
get ready?
Mine is ready, my lord. I'll also serve a copy.
All the respective councils are directed to file their respective synopsis of dates and events, list of authorities along with authorities, copies of the authorities after serving a copy thereof on each other.
Next week.
By 14th August, released on 19th August.
Lord, that Nagmangla association matter, we are filing a joint memo.
ಇದನ್ನ ಅಲ್ಲಿ ಫೈಲ್ ಇಟ್ಟಿಲ್ಲ.
ರೈಸ್ ಆಗ್ಬಿಟ್ರೆ ಮತ್ತೆ ಅವ್ರು ಮತ್ತೆ ಕರ್ಸ್ಬೇಕಲ್ಲ ನಾವು, ಎಲ್ಲಾರು ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಎಲ್ಲರಿಗೂ ಕೇಳಿಸ್ತಾ ಇತ್ತು ಅವ್ರು ಬಂದಿದ್ದಾರೆ ಅಂತ.
Not joint memo in Nagmangla case. They have intervened and.
Serial number 15, your lordship suggested mediation.
Just a moment, let us, once this is done, half the court will get empty.
Madam. Lord, we have fixed the committee also, which will oversee the elections.
Copy. Hear the voice and then see the person.
ಕಾಲು ಉಳುಕ್ಬಿಡ್ತು, ಕಾಲು ಇಷ್ಟ ಆಗುತ್ತೆ, ಕಾಲು ನೋವು ಆಗುತ್ತೆ
ಎಲ್ಲ ಆಯ್ತು.
ಟೋಟಲ್ 4 ಬರಬೇಕಾದ್ರೆ
Same committee is returning officer and IPOD committee.
Yes.
This is not clear as regards the
Supreme Court judgment, no?
Supreme Court judgment. It's not clear as regards the updated list of members.
Lords, that we have stated, my lords, by 27th it is to be published.
15/7/24 up to the last election, 15/7/24 you have said.
My lords, 15/7 shall be provided to the High Power Committee on or before 10th August. My lords, clause 4. My lords, then para 5, my lords, last date for updating the earlier list of members and newly enrolled members shall be 15th of August 2026. And from there on, 10 days time shall be provided to pay the arrears on or before 27.
Yes.
High Power Committee shall notify the calendar of events.
Sitting on the fence. You should say there clearly that eligible members can apply for membership. Whose membership will
Lords,
also
fresh
be.
membership, what happens under the Act also, if the members are enrolled less than 1 year from the date on which the scheduled elections are there, they will not be eligible to vote. They should not be in arrears of subscription for 1 year. That is what it essentially says.
You are allowing everybody to pay the subscription now.
Lords, all of them are members. Lords, all the advocates practicing 87 are members.
But it so happens.
There's going to be a dispute which will come up again on this.
Allah, it so happens that new members are already enrolled. Enrollment.
All of them till the cutoff date.
ಯಾರು ಇಲ್ಲ enrollment ಯಾರು ಇಲ್ಲ ಇನ್ನ.
ಇದ್ರೆ
ಆಯ್ತು, ಒಂದು
apply
ಸೆಂಟೆನ್ಸ್
ಮಾಡಿದ್ರೆ-
ಸೇರಿಸ್ಬಿಡ್ತೀನಿ ಅಲ್ಲೇ.
ಇದ್ರೆ ಅಪ್ಲೈ
ಅಲ್ಲ ಸೇರಿಸ್ಬಿಡ್ತೀನಿ ಒಂದು ಸೆಂಟೆನ್ಸ್.
ಆಮೇಲೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ಸ್.
ಅದನ್ನ ನೀವೇ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಬಿಡಿ, ದಟ್ ವಿಲ್ ಎನ್ಫೋರ್ಸ್ ದ ಸುಪ್ರೀಂ. ಯಾವ ಫಾರ್ಮುಲಾ ನೀವೇ ಹೇಳ್ಬಿಡಿ.
No, my lords.
ಮಾಡ್ಬಿಡ್ತೀವಿ.
ನೀವು ಯಾರಿಗೆ settlement
ಅಲ್ಲ, ಅವರು
District elder ಅವರು, district elder.
we have to say this, because of intervention of senior counsel R.S. Ravi, we were in a position to bring about some truths, though the group was not very happy in the initial stages, but we should also place on record, I think President will not dispute, the members of the bar members of Nagmangla were very, very cooperative in whatever suggestions fell from the senior councils, and they agreed for it.
Now there is no faction. It is one.
No factions now.
We took
Only
a joint
elections.
photograph. We took a joint photograph of both
They
the
didn't
factions.
invite me, my lords.
Then I said, Lord, I said, by the time next election takes place, factions will change.
Already there was one submission made which we pointed out. You know that.
Yes.
Petitioner is before this court seeking for the following reliefs. ಯಾವ ಸೇಲ್ ನಂಬರ್ ಯಾವ್ದಿದು?
4, list 3, serial number 4.
List 2, 3, 4.
List 3, serial number 4.
ಓ, ಇದು ನಿನ್ನೆ ರೆಕಾರ್ಡ್ ಆಗಿಲ್ವಾ? Learned AG accepts notice for respondent number 1, 2 and 3. Shri G. Nataraj is directed to accept notice for respondent number 4. You will appear for 5 and 6, Mr. Reddy?
Right.
Shri Murli M, who has filed caveat for respondent number 6, accepts notice for respondent number 6 as also for respondent number 5. When the matter was taken up for arguments on 4th August 2026, considering that the matter related to an advocate association and all the advocates being officers of the court, it would not be proper for there being any conflict between the members. This court had suggested that the parties could try and amicably resolve the disputes. In pursuance thereof, both Shri D.R. Ravishankar, learned senior counsel appearing for the petitioner, and Shri Vivek Subbareddy, learned senior counsel appearing for respondent number 5 and 6, had submitted that they would endeavor to try and resolve the issues. Today, a joint memo reporting settlement has been filed, signed by the president of the petitioner, respondent number 5 and respondent number 6. 5 also is there.
Yes. 6 ಮಾಡಿದಾರಾ?
ಮಾಡಿದ್ದಾರೆ. 5 the signature match. Respondent number 5 and 6 and their respective counsels. The same reads as under.
But 5 is a politician, so on dispense ಮಾಡ್ಬಿಡ್ಲಿ.
ಅವ್ರದ್ದು ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡ್ಬಿಟ್ರೆ ಅವರು ಅದೇ ಹೇಳದ್ನಲ್ಲ, ಕಾಂಗ್ರೆಸ್ ಬ್ಲಾಕ್ ಕಮಿಟಿ ಪ್ರೆಸಿಡೆಂಟ್ ಅಂತ, ಅವ್ರು ಬೇಡ. ಡಿಸ್ಪೆನ್ಸೇಷನ್ ನಾನೇ ಮೆಮೋ ಹಾಕ್ಸ್ಬಿಡ್ತೀನಿ.
Counsel for dispensation deletion.
ಆಯ್ತು.
Counsel for the petitioner has filed a memo for deletion of respondent number 5. Hence, respondent number 5 is deleted from the array of parties. Memo reporting settlement has been filed, which reads as under. The submission of Shri D.R. Ravishankar, learned senior counsel, and Shri Vivek Subbareddy, learned senior counsel appearing for the respondent, is that they will adhere to the terms as recorded therein.
Yes.
Additionally, they submit that any member eligible to be registered as a member of the petitioner association would be so permitted to file necessary application for enrollment, for membership of the first respondent
before
the first petitioner. Any such application filed before 25th August 2026 would be considered, so long as all the requirements are fulfilled.
Yes. That he must locally practice in Nagmangla. That he must practice in Nagmangla.
ಏನಿದೆಯೋ ಅದು, that we are leaving it to the returning officer. The decision of the returning officers, as mentioned in the memorandum of settlement, memo reporting settlement, would be final in that regard.
Yes.
You have taken their consent.
Yes. We have taken the consent.
Secondly, a submission is made that insofar as the reservation of seats for women candidates are concerned, the directions issued by the Honorable Supreme Court would be
Adhered to by
followed-
the High Power Committee.
would be adhered to in both letter and spirit.
Yes.
Their submission are placed on record. In that view of the matter, the appointment of an administrator having necessitated on account of the conflict between the two earlier factions.
Yes.
Between the members. We are also not very, between the members. This court is of the considered opinion that the order for order appointing the administrator would be required to be set aside, since as per the memo of reporting settlement, there is no conflict in existence as on today. In that view of the matter, this court passes the following order. Writ petition allowed, a certiorari is issued. The order passed by the first respondent, while order number so and so dated 24/7/26 at Annex Z is set aside. On conclusion of the elections, the High Power Committee is directed to file a report.
Yes, please.
Within 15 days of the conclusion of the said elections. In the event of the returning officer or the returning officer committee.
Yes.
Committee of returning officers or the High Power Committee facing any issue.
Yes.
They would be free to approach this.
Move this honorable. Please.
For seeking for
please.
any
That is good.
directions that may be necessary in that regard.
Please.
Lords,
anything else?
That's it.
One
That's it.
sentence, my lords,
You are
what
at
is
the
my
last-
place on record.
Are
that-
they last?
The members of the,
this court places.
Ravishankar ಮೇಲೆ record.
ಅಲ್ಲ ಅವರು
Recommendation.
ಅವ್ರ ಮೆಂಬರ್ಸ್ ಎಲ್ಲ ಪಾಪ ಬಹಳ ಕೋಆಪರೇಟ್ ಮಾಡಿದ್ರು.
Proactive stand taken by Shri D.R. Ravishankar Learned Senior Counsel, Shri Vivek Subbareddy Learned Senior Counsel, Shri R. The members of the Advocate Association Nagamangla. ಇನ್ಯಾರು ಬಿಟ್ಟಿದೀವ?
ಅಲ್ಲ ಅಷ್ಟೇ ಅವ್ರು ಸೇರ್ಸಿದ್ ಸಾಕಾಗೈತೆ, ನಮ್ದೇನೇನ್ ಪರವಾಗಿಲ್ಲ.
And also places its recommendations for the members for Shri Vikram Wilgur, Learned Senior Counsel, Shri Anil Kumar and Srimati Shweta Krishnappa, Learned Counsels who have agreed to take up the task of being nominated as returning officers and High Power Committee.
Yes.
So great.
Please. Oblige.
Just a moment, please. Yes.
Serial number 15 in third list. That's that the lordship had suggested if mediation can be, Justice Ravindran has kindly consented.
Yes, my lord.
Parties will, my lord, councils will interact the modalities. Only Mr. Rajesh's client and petitioners want to be.
For the order sheet.
Last time your lordship said passed. I have it here, but it's chicory there. Order dated 29/7/26.
In furtherance of the order dated 29/7/26, Shri K.N. Panindra, Learned Senior Counsel appearing for the petitioner in WP number 15824 of 26, and Shri Ajesh Kumar, Learned Counsel appearing for the impleading applicants in IA 3 and 4 of 26, submit that they have agreed upon Shri R.V. Ravindran, Shri Justice R.V. Ravindran, former Judge, Supreme Court of India, to be the sole mediator to mediate the dispute between the petitioners
1 to 3
and the impleading applicants in IA number 3 and 4, if necessary, by also including petition number 3. Petition number 3 is family member, if necessary.
Petition number 4 is family.
It's not. No.
If necessary.
What will happen is, I would request, my lord, petitioner 1, 2, 3 and the intervener.
Petition number 1, 2, 3 and impleading applicant so and so. Who will coordinate with the mediator?
Well, I'll coordinate.
Both councils.
Both of us will coordinate.
With
One of the clients have already come in
modalities.
from.
The respective councils to coordinate with the learned mediator.
Yes.
As regards the modalities.
Yes.
And the logistics.
Yes.
The learned mediator would be free to fix his fees in the matter.
Yeah.
We have told him all about this 10 days business, everything that you are there.
Lords, Mr. Kusmohan Raj has spoken to him, explained. Lords,
my clients have, one has already come, my lord. The other one is coming tomorrow.
So when will you?
They are available.
You work out the logistics.
Yes,
so when do we post this?
Lords, after 2 weeks.
2 weeks.
After 2 weeks, because
Just
last week ಅದು ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲನೆ ಹೊಟ್ಟೋಯ್ತು, ಇಲ್ಲ ಅಂದ್ರೆ ಅವತ್ತಿಗೆ ಆಗೋಗಿರೋದು. ಅಲ್ಲ ನಿಮ್ ತಪ್ಪಲ್ಲ, ನಾವೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಹುಷಾರಿಲ್ಲ ಅಂದ್ರೆ ಯಾರೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಮತ್ತೆ ಯಾಕೆ ಹೇಳ್ತೀರಾ?
ಇಲ್ಲ ಅಂದ್ರೆ ಅವತ್ತಿಗೆ ಆಗೋಗ್ಬಿಟ್ಟು
this
client had come, we wanted to finish off anyway.
List on 25th August.
Great.
Please.
If I may mention one matter.
Yes.
Serial number 52, my lord. It was set down today to file an
Resume.
My lords,
You want us to direct him to resume?
No, my lord.
it's already resumed, my lords.
No, it is not, my lord. It is not.
The order is issued, possession is not taken.
Senior counsel is also.
Don't resume it.
No, my lords, my lords. He's now filed a document showing a tent. There is nothing there, my lords.
Reaching, that is the problem. Until then, don't take advantage of that situation.
And in fact, would be staying. My lords may have it tomorrow. We'll argue because he has given now document to show it there. We can see it from the photograph.
Mr. Patil, we can't consider it at 519.
Lords, there may not be an interim order. My lords may have it tomorrow. That's it will have an
ಏನಪ್ಪ ನೀವು ನಿಮ್ಮ ಅಂಡರ್ಟೇಕಿಂಗ್ ನಮ್ಮ ಆರ್ಡರ್ ಎರಡರಲ್ಲಿ ಒಂದು ಆಪ್ಷನ್.
My lords, in the next set of hearing again it will.
The matter has been listed for last several occasions, however could not reach due to the pressure of other due to numerous other matters being listed. In that view of the matter, considering that if the land of the petitioner were to be resumed, the interest of the
possession
petitioner
were
would
to be
be
taken. Resumption agogide. Possession were to be taken.
adversely affected. Hence, respondent number 2 is directed not to take possession, to restrain itself from taking possession of the property subject matter of the petition till the next date of hearing. Relist on 17th August.
My lords, liberty may be reserved to file vacating stay
We have also filed. one
My lords, it will
It
go
is
into B
reserved
group. It
for
won't be
filing
heard
vacating
again.
stay application.
But
Then
we
we will
have
say vacating stay along with the main. So
Yeah,
get ready for
we
the
have
main.
also filed one additional affidavit in that matter. That may be.
My lords,
You have filed, it's been filed, that's all.
my lords, date may be fixed, my lords.
17th.
ನೀವು ಕೇಳಿಸ್ಕೊಳಲ್ಲ ನಾವೇನ್ ಮಾಡೋದು. ಎಸ್ ಮಿಸ್ಟರ್
My lord, kind
ನೋಡಿ
request
ಅವ್ರು
tomorrow,
ಭಯ ಪಡಿಸ್ತಾ ಇದ್ದಾರೆ.
tomorrow at least, my lord.
ಯಾವ್ದಪ್ಪ serial number ಅದು?
Serial number 8 in
8
list 3.
230 tomorrow.
My lord, serial numbers.
Taken up next week, I mean, first Monday.
ಎಲ್ಲ ಡೇಟ್ಸ್ ಕೊಡ್ತಾರೆ.
Serial number 55.
We are coming in sequence, please.
21 on CCTV matter.
Yes.
My lords,
Mr.
21.
Kulkarni, ಏನಪ್ಪ, for how long do you retain your CCTV?
30 days, my lords, because the custody is with the owners. I maintain it under directions of Bureau of Civil Aviation Security. Therefore, my lords, I follow their orders.
So you are deleted or it's overridden?
Automatically gets overwritten, my lords.
Gets automatically erased.
Gets overwritten. 1 or 2 days here and there, it may be, my lords, but this is of April, we are already in July.
Insofar dictate ಮಾಡಿದೀವಿ. Insofar as prayer number 3 is concerned, Shri Manu Kulkarni, learned counsel, appearing for respond number?
Respondent number 6.
Months.
They have not updated your name. They don't know your name. They're still in Bangalore International Airport.
Yeah, 6 months.
6, respond number 6. Submit that in terms of the directions issued by respond number 5, the CCTV footage is maintained only for a period of 30 days. Thereafter, the earlier CCTV footage gets overwritten by the subsequent CCTV footage. And on that basis, we submit that the CCTV footage of April, 17th April, 17th and 18th April 2026 is no longer available for it to be furnished to either the petitioner or to the investigating agency. His submission is placed on record. In view of petition stands disposed. Cost will stay.
Serial number 61, my lord.
Huh.
Kindly list the matter tomorrow, my lordship. There is a urgency. The petitioner got, my lord, the petitioner got a custody and visitation rights of his 6 years old daughter, my lord.
Tomorrow.
Seeking police assistance, my lordship.
My lord. Huh. A certificate circular. ನಾಳೆ ಲಿಸ್ಟ್ ಮಾಡಿ.
My lord.
Pass over ella will be listed tomorrow.
My lord, one submission.
As we have to see the papers and
Serial number one,
why it is got
list
done.
number 1, your lordship, serial number 41. I am sorry, my lord.
Serial number 48, my lord.
Serial number 8, list 3, interim order extent.
Serial number 41, your lordship. Serial number 41 in the first list, your lordship. I filed application vacating stay, my lord. This matter is coming up. My lord, let it be in second list, your lordship, tomorrow. Second list, your lordship. Madam, serial number 41.
ಒಂದ್ ನಿಮಿಷ. ಲಿಸ್ಟ್ 1 29/8 ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್
Madam.
ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
ನೀವು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ, ಸಾಹೇಬ್ ಬಂದು ಚೇಂಜ್ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತೀರಾ. 29 ಫಿಕ್ಸ್.
29 ಬೇಡಿ ಮೇಡಮ್, ಬೇರೆ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್.
29 ಸಾಕು ಸರ್.
ಇಬ್ರು ಇದೀವಿ.
ಸರ್
ಬೇಡಿ. ಇಲ್ಲ ಇದೀವಿ ಏನೂ ಇಲ್ಲ, ಯಾವಾಗಲಾರು ಕೊಡಿ ಮೇಡಮ್. 43
ಏನ್ ಬಲಿ ಸರ್, ಕಾಯ್ಕೊಂಡು ಏನು
ಲಿಸ್ಟ್ 1 ನಲ್ಲಿ ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ 29/8
ಮೇಡಮ್. 43 ಸ್ವಲ್ಪ ಬೇಗ ಬೇಕು.
ಲಿಸ್ಟ್ 3 38
ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಪಾಸ್ ಓವರ್ಸ್ ನಾಳೆ.
ಮೇಡಮ್ 43 ಲಿಸ್ಟ್ 1 ನಲ್ಲಿ ಟೆಂಡರ್ ಮ್ಯಾಟರ್ 29 ತುಂಬಾ ಲೇಟ್ ಆಗೋದು.
ಈಗ ಪೇಜ್ ವೈಸ್ ಬರ್ತೀನಿ, ಹೇಳಿ ಯಾರಿಗೆ ಅಂತ. ಪೇಜ್ 9 ಸೀರಿಯಲ್ ನಂಬರ್ 41.
ಮೇಡಮ್ ನಮ್ದೇನೆ ಒಂದು
ನೆಕ್ಸ್ಟ್ ಮಂತ್
ಒಂದೇ ಒಂದು ಡೇಟ್ ಬರಿಬೇಕು ಸರ್ ಫೈಲ್ ಮೇಲೆ. ಯಾವ ಡೇಟ್
ಹಾಕಿ ಮೇಡಮ್.
ಒಂದು ದಿನ ಬರುತ್ತೆ, ಯಾವತ್ತು ಅಂತ ಹೇಳ್ಬೇಕು.
ಇಲ್ಲ 11 ಅವತ್ತು ಆಗದೆ ಹೋದ್ರೆ ನಾವು ಅವರು
ಸರಿ ಒಂದೇ ಡೇಟ್ ಹೇಳಿ.
11-12 ಮೇಡಮ್ ನಮಗೆ
ಸರ್ ಎಲ್ಲಾ ಸತಿ ಹಿಂಗೆ ಆಗ್ತಾ ಇದೆ, ಒಂದ್ ಡೇಟ್ ಹೇಳಿ ಸರ್ ಅಷ್ಟೇ. ಸರ್ ಮುಂದಕ್ಕೆ ಹೋಗ್ತೀನಿ, ಇವ್ರನ್ನೆಲ್ಲ ಕಳಿಸ್ತೀನಿ, ಆಮೇಲೆ ಡಿಸೈಡ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಪೇಜ್ 10 ಸೀರಿಯಲ್ ನಂಬರ್ 42 to 45. ರೀಚ್ ಆಗಲ್ಲ, ನೀವೇ ಹೇಳಿ. ಕಾಯೋದು ಯಾವತ್ತು ಅವತ್ತು ತಗೊಳ್ಳಿ. ಯಾವತ್ ಕಾಯ್ತೀರಾ ಹೇಳಿ. ಅಲ್ಲ ನೀವ್ ಹೇಳ್ಬೇಕು, ನಾವ್ ಆ ಡೇಟೇ ಬರೆಯೋದು.